welcome everyone to this Monday, May 3rd, 2010 edition of Money, Banking, and Trust by Moving Titles and Commerce. Welcome to NTT as New Trust Technology. I'm your host, Christian Walters, and this is the Monday Trust Ambassador meeting. So we'll get right into the call here. I was doing some Black's Law research again, and we ran across some. I was also going through the corpus juris secundum, and it really reinforced the fact that, just like I read on a Saturday show, that basically stated in corpus juris secundum that if you're expressing a trust or making any reference to a trust or making a claim for a trust, then you're the one that's going to have to bring the proof that it is. You're going to have to treat it as a trust. And something I discovered out of Black's from the definitions, which even leads more into the courts, what's happening there, and indictments and charges and things, that even those are trusts, and here's a confirmation. The definition of bail in Black's Law 8, we were looking through those, and it said bail says to place in someone else's charge or trust. Okay, if it's to place in someone else's charge or trust, charge is a trust. Now the definition of charge, Black's Law 8, a person or thing entrusted to another's care. Entrusted. There's definition of charge. You have a trust term in there. You're entrusted to another's care. So the charges that are coming with you for the indictments or the bills are nothing more than trust, getting you to be placed into another's care. More confirmation that everything is really, really a trust. So, Chris, you had some interesting things to say there earlier, but why don't you come on back on? You were at the Tim Turner seminar this last weekend?
Yeah, and it's the first Tim Turner event that I've been at, and I saw that what he was presenting in his material with the administrative process of negative avertment, he had expounded into several different areas, traffic tickets through mortgages, credit cards, property tax, and on and on. They really have done a really great job with their paperwork. But I had mentioned very gently, and not going into, overtaking his, his presentation of material. And I could actually see that while he was standing up there and I was telling him about the grantor and the settlor, that he started putting some pieces together that he hadn't had before just by me mentioning what it was and what we were doing over here at this camp. And I could actually see him respond like, aha. And so what I was looking at is,
Can you give an example of what he was talking about that kind of got enlightened on?
Well, he would be talking about a court case dealing with a negative avertment and about taking it in the chambers, and I would be telling him like an example of where if you were as the grantor and the settlor that you were there to settle the matter, that it was like a no-brainer that the judge had to act out the trustee based off the Bankruptcy Act. And, of course, I was only sliding this stuff in just gently because there was like 60 people there, and I didn't want to overtake but I could see in his eyes he was just like this, he was like a mathematician taking what I said, and you could see his eyes brighten up. And the best that I could possibly say is that he started realizing that trust has a play in this whole scheme. Yeah, a lot of the people in the group responded equally because I was flooded with people. Oh, we got an echo back.
Yeah, let me mute some out. Back in again.
Muted.
All right, press star 6 to come back in.
Yeah, I'm here. But there was a flood of people that recognized, with using the language that we've been speaking and training ourselves with about the grantor and settlor, and just walking people that if you were the grantor to any kind of a situation in contractual law, that once you name yourself as a settlor in any event, that your intent was to execute a certain set of commands upon any person that touched that particular contractual agreement, ended up becoming the trustee, and it was their responsibility and their obligation to settle those things, and that if they fail to do so, they can be charged with breach of trust or breach of public trust. People are just like responding just like piranhas. I just couldn't believe how people were just like picking up on this. And I really didn't know how much I grew and understood in the last 3 months. I've been really, staying with this stuff with you on the trust stuff, how much I really learned until I just was there in an environment of where it was just all administrative and it was all contractual law and it was all around the negative avertment and maritime liens and whatnot. It's not to say that I didn't learn a lot with what they were doing over there, but it struck me that there was this one thread of truth that ran through the whole thing, that once you put everything in order with the trust information, everything fell right into place. It was just amazing. So I just wanted to get back to you and let you know how proud and how effective what it is that we're learning here really is in comparison to what is the next second best thing that there is on the market, which is the negative avertment in admiralty law.
Yeah, corpus juris secundum, it says on Section 90 under Book 90, Corpus Juris, under Section 161, Rules of Consideration. It says, in general, it is a rule of equity that once a trust is created, it is thereafter to be treated as a trust. And that's what I was trying to kind of connotate just before the show there, that, once you express a trust or any kind of thing, like if you're making a claim that there's a trustee or there's a trust or there's a beneficiary, if you're mentioning these terms, what you're doing is you're claiming that there's a trust. But anybody who claims that there is a trust, once there is a trust that is created, it is therefore to be treated as a trust. So if we don't treat it as a trust, if we treat it as debtor-creditor, then it isn't going to work. We're not treating it as a trust.
And we have paper securities under Black's Law definition. Is a term applicable to any business paper or term paper in school, really. That is, paper that is or may be the basis of credit. The basis of credit is paper securities. You sign your name, you endorse it. That's one of the first things you learn to do in school. Put your name on it. Official. Official is defined as the meaning of or pertaining to an office, position, or trust. So is an official a trust? Connected with the holding of office, quantitative, authorized, and on. But anyway, position or trust, that's an official? And we think that these people are officials, but it says they're really trusts. So if we make a claim, are you trustee, or I'm the beneficiary, or I have a Sesticate trust. Any of these claims, you're claiming a trust, and you got to prove the trust, and then you have to treat it as a trust. If you don't treat it as a trust, and you go back in the debtor-creditor realm, then it's not making a connection. So, Chris, this was a 3-day seminar?
Yeah, it was.
What do you think it might be the best way maybe to make people realize what we really have here?
I stood up and I said maybe 20 different things in the 3 days, and I had a flood of people. Every person in that room asked me questions about what it was that I had said, and it was all related to the trust superseding everything that was said. It was said in a manner that it was a compliment to Tim Turner that allowed him to realize, it actually gave him direction of his next step in understanding about trust, that I did it to where it was not a conflict with his information. I was not there to be in conflict with the negative avertment or the maritime lien information, but just gently laid this stuff out each time that I gave a comment, and everybody just flooded me to want to find out the rest of this. I said, go to Christian Walter's call. I wouldn't be a bit surprised if we don't have a couple of the people from that event this weekend here right now.
Was there like one particular question that they keep on coming back to that kind of popped up?
Mostly it was the relationships that was being missed between what the plaintiff would be in lieu of what the grantor and the ability of the settlor to over and supersede what the trustee, if the trustee is not doing the rightful thing for that particular trust. I kept trying to point out to everybody that you have every right to stand as a plaintiff, grantor, settlor in each of these situations that you're involved with, is to command, instruct to any administrative officer and or judge to set things right, and if they fail to do so, it would be a breach of trust in that trust, and it would also be a breach of public trust, of which a judge would never, ever cross that, so he would execute your instructions right away to keep himself out of hot water.
So do you think it was the possibility of the remedy? That was the main issue, the main thing?
Yes, is the closure of those cases and whatnot, and whatever I had said, it was just common in our groups to talk about this language, but people picked up on it like it was a homing beacon because I passed out probably 100 cards, business cards this weekend. People wanted to follow up this information. I said, well, you contact me. What I'll do is I'll give you the schedule for Christian Walters because this is where, this is what I've been studying, and this is where I put most of my attention nowadays. So I gently just went in there and not tried to take over a Tim Turner's event, but tried to be a complement to give people direction of what it is when you walk into a court and you can actually maintain being a plaintiff, grantor, or a settlor and take command of any situation in a courtroom.
Do you think there was one particular area that might be helping him out, which would be maybe the weakest point that could be strengthened with the trust?
Mostly that he was functioning and naming this stuff off as a debtor-creditor relations, and I wanted everybody to understand that they could actually take command as being the true creditor. And a couple of the people in private conversations were asking me, well, if you were to practice and study this stuff and become the pure creditor, do you see that the secured party papers are necessary? And I said, from what I understand from what Christian has explained, is that when you become a true creditor, those things just pass under the byway. They're no longer useful, and you can actually take them off the public record that you had these things filed. And people were just intrigued. They were just like looking at me. It's like, say what? I says, yes, there's a point of where you can actually own and command every event in your life, being a true creditor under trust, that everything you say goes, and anybody that crosses you is in breach of trust. And people were just like, they were right there, hungry is the word I could say, because they were very inquisitive. And, of course, there's so many distractions at those things. I was unable to really take it any further than that. But I really felt that Tim actually heard some of the stuff that I was saying, because he would keep calling upon me to give an example or to give a cross-reference. And every time I did, gently as I possibly could, is I would deliver some of the trust understanding that you've been teaching. And it fit in so well. And it actually took precedence. It actually superseded but complemented everything that he was doing over there and presenting. So I was really proud and very excited to share that with you.
Here is a corpus juris secundum, also section Book 9, section 213, which is special or trust deposits. It says a special or trust deposit of public funds may be entitled to priority without regard to whether there is a prerogative or statutory right or priority in favor of public deposits. So it says a deposit of public funds may be entitled to priority without regard to whether there is a prerogative or statutory right of preference in its favor, where the circumstances are such as to render it a special or trust deposit. Next paragraph. In the absence of sufficient special circumstances, however, a deposit of public funds, like a deposit of other money, creates merely a general deposit, giving rise to the relation of debtor and creditor. Let me read it again.
However, a deposit of public funds, now this is in the absence of special circumstances, however, a deposit of public funds, like a deposit of other monies, creates merely a general deposit giving rise to the relation of debtor and creditor, and the mere fact that all public monies are, broadly speaking, trust funds or held in trust by the officer depositing them, does not of itself render a deposit of such funds a special or trust deposit so as to entitle it to priority. But remember, that's in the absence of sufficient special circumstances. If you have those special circumstances, then it's not merely a general deposit giving rise to the relation of debtor-creditor relationship. It is then a trust fund, and it must be treated as a trust, and the person who deposited into the trust is the trustee because he's the officer depositing, and it's to be held in trust by the officer depositing them. This is how we're getting into the debtor-creditor relationship. We're not claiming these special circumstances, which are your special deposits. We're not claiming trust. And everything, it says, was public funds. So we're being tricked into giving a general deposit, which gives rise to the debtor-creditor relationship. And bingo, they got you. More information that trust is controlling, but only if you express it to be a trust. That was under Corpus Juris Secundum, Section 9, which is banks and banking. And the copyright on that is 1996. So anything else to add, Chris? Maybe of that?
Well, outside of the confirmation that Tim Turner had offered about the Supreme Court decision within the 30 days that they were challenged to get the Restore America back in order, he says how, he thought that was quite a coincidence that they had done it on the 30th day, that the 31st day would have been a default, but the decision came forth that all judiciaries throughout the 50 states were to revert back to Article III courts. And my question to him in the class was that, does that mean that exempts people from statutory codifications and regulatory laws? And he says that would be the impression. And I thought that was pretty striking. That means that traffic tickets are out, any kind of banking contractual agreement under deed of trust are out. He did say that the military has special interest on the outcome of restoring America with republic form of government, and he named out those things.
Interest?
Say it again?
Special interest?
You were kind of blocked there. I didn't quite catch it.
Special interest? Is that what he said?
Yes. In other words, there was special interest. And, that was the other thing I noticed about his new documents on the negative avertments. He's including special negative avertments just to he caught on with.
Meaning private.
Mm-hmm, exactly. But I thought.
I'm glad to see that some of this stuff is filtering out, and some of the so-called, everybody that's up the top, the gurus, they're picking this up and they're starting to incorporate it in there. I've even seen Winston Shroud come out with a new document, new DVDs and stuff. He's coming out with trusts. So, the information's out there, and I'd like to see us all get on the same page, because I think we can take this bear down and wrestle it to the ground with no problem under trust.
One of the things that was brought up when I got home this morning, somebody had called me and says, "Have you heard the news?" Well, what news is that? They said that there's a group based off of Christian Walter's process that has taken down 28 states with some kind of a provision around the Sesticate Trust. And I says, well, I couldn't even imagine who that could have been except for the Michigan group. You remember the folks that came on about 3 weeks ago?
Right.
Those folks had something up their sleeve, and this morning, I have no confirmation of what that was, but somebody had called me up and said that 28 states had agreed to come into that fold, and so there's a lot of things going on right now.
Yep. I'm glad to see it. We started something, really.
Yeah, and you know what? God bless you, man. I'm telling you. It's like flipping the beast over and cutting his belly open, because for some reason we're actually part of getting this country out of the hands of these mafia organized crime groups and getting it back into the hands of the people. And I'm so proud to be part of this whole thing. I really am.
Well, I just wonder if there's anything else we could be doing that might be, ramp it up a bit.
Well, we do, but I can't talk about it on the call. Off the call, I have an opportunity to talk to you about it. I was told to keep my mouth shut about some things, but on a private call with you, I can explain some of that. And you should be aware of this stuff too, because in your own Florida state, you can definitely rock with some of the stuff that's going on in the background. Or you can contact your the coordinator for the state with the grand jury. Restore America stuff, because they went into phase 2. That means that anybody that wants to be a backup grand jury has the ability to sign up and get sworn in right now. And what they're hoping to do is have, here in the state of California, like 2 or 3 sets of grand juries to start processing. And we're in the beginning stages of getting the training, and everybody that's signed up are capable of getting in and getting the training now in the beginning stages. So every one of the states that are out there, and anybody that wants to qualify, get a hold of your Restore America coordinator for your state and get yourself signed up as soon as you can, because we're just now starting the grand jury manuals and the training.
How do you do that, Chris? Because I've asked 2 people now about getting together with my state coordinator, and nobody's contacted me.
Yeah, they've been a little busy, and I guess they must have had a plunger happen last night, but we had a conversation about that today. And we, the people, and the Restore America, we're moving forward. We're not going to let anybody stand in our way to get this country back in the hands of the people. And I swear to you, I'll do everything I can to make that happen that way.
Well,
if you want to get a hold of me directly, I will make sure that your coordinators get in touch with you.
Well, I asked Sam Davis to get me in touch with him, and he was going to do that, and he hasn't done it yet.
Yeah. Well, like I said, offline, get a hold of me, and we'll make it happen. Because for some reason, they took a liking to me like I never thought that they would. But for some reason, Tim Turner called me at the first part of this week, and he said, "Can I ask you a favor?" I said, "Sure." And it's like, wow, okay. I never expected that either. So, if you want me to give you a helping hand to get in touch with the coordinator, I'll be more than happy to do that. And for you too, Christian, because I think that this is we've got quite a support by the military to have this happen. And from what they were saying over the weekend is that they're actually surprised of how much interest the inner structure of some of the parts and agencies of the government wants to have this happen. So I was impressed. I mean, there for a while I wasn't getting the juice, and now I've got the juice, and it makes a difference in my whole being, what it is that I'm participating with.
I guess there's factions in the Rothschild family that want this to happen.
I wouldn't doubt it. I asked Tim, I says, "Well, Tim, what's the story with this foreclosure that's happening from the British Crown?" I says, "Can you confirm that?" And he says, he waited and paused for a minute in front of the group, and he says, "Yes, I can confirm that. There's a foreclosure process from the British Crown that is happening as we speak on Washington, D.C., and at the end of that, there's going to be an unlawful detainer served upon all these government officials."
Right. The Queen told the Congress to get off her property.
Yeah, it's something that, it was just conversation that had happened, sporadically as there was intermedians in his teaching that these conversations came up, and I popped that out because I heard about it from one of our private investigators out here. He says, yeah, there's a foreclosure process going on. So I asked him, and he says that's confirmed.
So do we give her the 10 square miles in Washington, D.C. back? Yes. Well, as a matter of fact, she found, she has a copy of the deed that they thought was, that all of that was destroyed in 1812.
And
well, maybe we should claim trust first and then turn it into a special deposit and get her for breach of trust.
you know, I was talking with some other people about what we're doing, working together. And well, as a matter of fact, one of my friends who is in constitutional government and other things, when I mentioned to him, I said, and I told him what we were doing as far as studying trust. He said he'd be interested in some more information, and I told him, you know, that to get in touch with you and listen to your radio programs. He wants me to send a bunch of the archives to him, so I'm going to do that. But
why don't we extinguish the debt by taking the simple contract debt, the debtor-creditor relationship that she says she has? Why don't we merge the title with the asset, with the higher security, the trust, and that would extinguish the lower simple contract?
Mm-hmm.
Yeah,
I think you're on the. I'm sorry.
Okay,
go ahead.
So Christian, that's a good idea. What do you propose? How do you propose we do that?
Just the same mechanisms that we've been using. We've been talking about the merging of titles, and because that's just the definition of merger anyway.
Right, but I meant as far
a contract, and that would be the debtor-creditor relationship for any purpose, and afterwards have entered into an identical engagement by deed. The simple contract is merged in the deed and becomes extinct. And this extinction of the lesser in the higher security, like the extinction of the lesser in the greater interest, is called merger.
Mm-hmm. So, right, okay, but I meant in terms of organizing it, would it be a project that we engage in or on these calls? We have side groups. How do you propose? What's your thought on that?
Well, apparently she's talking about what? The past war debt, right?
Well, she's talking about having the deed that they had confiscated or something in the War of 1812. And she has the 1876 contract that was that everyone thought was eliminated, and she came up with one of the originals.
Okay, so according to law, you would not only have to be holding, but you would have to prove ownership. Where did she get right to it? Where is her chain of titles?
Mm-hmm.
Where does she
well, actually, the Treaty of 1812 actually does have a foot through the door clause. That's how they got into our country, and part of the history of Lincoln proves that his worry and concern was the foreign banking powers that infiltrated into the United States from the 1812 war. So that treaty has some clause in it that allows them to put a lien against the United States.
Well, the lien was put against was put against the United States Corporation when they loaned money to them in 1876. When Benjamin Franklin, I believe it was, went over there to get money for the colonies.
Are you saying 1776? Because Ben Franklin was dead in 1876.
Oh, well, it might have been. Well, excuse me, 1781 and 1785, in that area. I'm sorry.
All right. Yeah, because I'm sitting there saying, well, that doesn't jive.
Yeah, right. Okay. You're right.
Yeah. But once again, I'm asking the question that you said we, Christian. Like, well, what do you mean that we form groups? Do you have any idea, or you were just using that proverbial we?
Yes, I was just using a proverbial we. Yeah.
Okay, so then, Chris, I mean, is that something that? How do you feel about that? Do we, as a proverbial group, can we work together to accomplish something like that?
Yes. The fact is that on the inside circle, there's some stuff happening at Tim Turner's camp that is not public, that we would have to talk about this stuff off the call, but I think we've got a winner here. We've got a perfect match with what you're doing, Christian. I swear to you, we've got a perfect match. If you take a vested interest, I will see what I can do about hooking up the information, and we just might have ourselves as a winner with what I have inadvertently heard is going on over there on trust. in on these phenomenal amounts of money that have been circulating the planet, and it has to be delicately dealt with. I think that your plan of merging titles would be the most smoothest, most positive, most constructive.
And I'm on a conference call, and with a guy who knows about trust and stuff. It's very good.
Yeah, so with the lady speaking, figured out.
Yeah, so what I think might happen is I can make a couple calls and see if I can't get a powwow together, and I can either contact JC and or Eric so they can contact you and see if we can't just get you guys together with some of the people over there at Tim Turner's camp, because they're talking our language. They're talking international. They're talking about this great big trust, and they're talking about what angle to work with it at. And I just see that this is probably it. This is probably the matchup that you're looking for. You've got the people, you've got the research, you've got a whole group of people that are moving this direction, and the Restore America plan. And if we come in on the backside and you got the formula, this could be it that you're looking for.
So, like Chris, when I was leading up to is that I'm offering my services to help. I mean, just if it's part of what we, if I can help, I'd be happy to do that.
Sure.
I was speaking to Chris in California.
Who is it again?
I was speaking to Chris in California, not you, Christian. Chris in California.
Well, no, we're all a team. Anything that just your participation and your wholeheartedness is more than enough. And if you're called upon, absolutely, you're more than welcome to participate. This is above me, but I did understand what's going on behind the scenes. I can pick up stuff like most people can. And I'm telling you, Christian, we might have something here that you might want to address on the private side. And I don't want to talk about this particular thing anymore on the public.
Okay, maybe we can talk about it tomorrow.
Yeah, absolutely, because I think that this is imperative that at least you guys have an opportunity to talk about it in the private. And if it's a good strike, and I do believe it is, I can see the matchup. And boy, if this is true, woohoo!
Okay. Anybody else have something to say? Anything? Something about that? Go ahead.
I was just going to say that before we got into this, I had in the back of my mind that there was something that we could do, perhaps along the lines of marrying some of the ideas that people like Patrick has with trust and getting the Syndicate trust settled with our trust with our NTT.
I'm reviewing Patrick's forms.
Pardon?
I'm reviewing Patrick's forms.
Oh, okay.
3520, 20A, all those other ones.
Just for your information, Christian, if you go back to Dr. Phil's calls and listen to the last 3 weeks, I had a chance to briefly talk to Patrick. He says that pretty much all the information and the breakdown of understanding of those forms were spoken about on the last 3 calls over at Dr. Phil's.
Is that that's on TalkShoe, right? That's on a...
Yeah, I think that was 35531 or something like that. I can't quite remember what Dr. Phil's number is right offhand, but it should be. Oh, here it is. 24681. I think is what it says here. 24681 is his TalkShoe number. But Patrick says that that's the easiest, quickest, fastest way to get educated because he broke it down really well from what he was saying with those forms that he just recently came up with.
Yeah, because there's a lot there, yeah. It really takes some people that have some research ability and can dig into this stuff and make heads or tails out and find out whether or not it's going the right direction. And it takes more than just one person to do it.
Yeah, and it would be a dream come true to have a team like that. You know, that Michigan team, since they've got such a strong core of people that are so committed and dedicated, maybe we can entertain some type of like inner research core with them to do something like this. To take material like that and digest it, mull it around, and confirm whether or not it's effective, or if it's part of a formula that we can use.
Well, that's basically why I've been kind of dragging my feet on the workshop and other things moving forward, because you really got to have at least some kind of a team or a few people together that understand this stuff with enough sufficient depth to be able to see past the debtor-creditor wall.
Mm-hmm.
And that just doesn't happen overnight.
No. But I was impressed with talking to Victor, and I think the other gentleman's name was Mark. Both of them were very inspired. They seem to have a core heat among their group that they got the combination or the elements right to where all of them were very, very intrigued, and they were just kind of like working together in a manner that they actually got some stuff done and were moving forward. And when I was told this morning about the 28 states falling under Cesta K Trust, I thought to myself, okay, well, I didn't hear too much more than just that, so I couldn't confirm anything, but by tomorrow I'll find out for sure. But I thought it was interesting, and the first thing that came in my mind was that group, was they finally went ahead and initiated it. But I don't know, the last time you went on to the web and looked under Christian Walters, do you know there's probably about 50 groups out there that are doing their own study groups that are on the web with their own material?
Yeah, I know it's really mushroomed, yeah.
Yeah, I was impressed. I went to go look under Christian Walters, and we've got groups from Canada all the way from Florida to California, and I think there was like 3 pages or 4 pages of just different groups that are doing your material.
Yeah, we had, when the website was up, we had 152,000 downloads in a month.
That's great. When I had Bill Thornton on the calls, the talk show calls, I said, well, Bill, you might want to prepare yourself. I says, you're going to get a lot of hits. And he says, well, I'm going to call the webmaster. So he had prepared himself, and he said between the time he had a talk show, within 1 week he had over 80,000 hits because he came on talk show. That was when I was helping Rod with the AIB radio. He says, Chris, he says the webmaster was floored. He couldn't believe that he had that many hits on the site.
Yeah. And he was talking about what?
Well, Bill Thornton is common law, and he wins almost unanimously working under common law. And so all of his paperwork and everything that he's promoted comes from the angle of you being the plaintiff and setting the court under court of records. And this guy's thorough. I don't know if you know who he is, but man, when he talks, he knows how to talk and walk at the same time. And everything that he has over his site is just spectacular. He posts all his wins and everything else over there. That's what is it? If I can remember, it's 1816.org or something like that. Anyway, if you go to lawlearners.net, his site is posted over there, and in one weekend, yeah, there it is. In one weekend, he had 80,000 hits.
Well, anybody else have something? Question?
Hey, I got a question for you, Christian, real quick.
Sure, go ahead.
This is L, man, from Nashville, and well, I've expressed to you before that I really enjoy and appreciate your calls, and I tend to learn a whole lot. I think probably more from listening to you and studying your previous material than maybe any of the other guys that I've been studying under here since I started studying these alternative ways of looking at the law and commerce and trust and so forth. But at any rate, I am really, enthused about, maybe at some point calling myself a trust ambassador, but it's just difficult because I can't get the back audios anymore. I downloaded a bunch of them, and I was going through all of them and listening, and I was, working with a group here in Nashville. But any idea when the site's going to be back up?
Yeah, I'd like to know. I just got so much to do. That's the problem. That's the thing. I'm like swamped for time.
Okay. All right. Well, we're patient. Patience is a virtue, and once again, thanks, man, and we're just patiently waiting.
I appreciate that. Anybody else? Question? Press *6 to unmute. State your name, where you're from. Is Mike from Chattanooga on? Mike, you out there?
Yeah. But this is Eric. This is Eric. Hey, Christian.
Hey, Eric. Go ahead.
Hey, I just want to say to L, if you'll contact me, I have a lot of recordings that you probably don't have. If you want to contact me, I'll share them with you. Please find me on Skype at Imagine the One, and that's the numerical number 1.
Imagine the One, okay.
All right. Please just let me know the last date you got a recording, and we'll figure something out to get you some more to get you up to speed and progress you along.
Cool.
And if anybody else needs that out there, don't be shy. Contact me. I might not be able to get to you right away, but I will get to you over the course of time.
Eric, what you been up to?
A little house remodeling and listening to you while I'm working around the house. Just getting more and more programmed into it, thinking about I looked at the definition to the word infraction today.
Infraction, okay.
Yeah, do you know what those, the first 2 words of the definition of the word is a breach. And I'm going to it in Black's Fourth right now. And because I guess it's not an issue in criminal or civil, even though we know it's all debtor creditor, so it really boils down to civil. But it says a breach, a violation, or an infringement as of a law, a contract, a right, or a duty. So when I was looking at this, I was looking at this in terms of a traffic infraction and thinking, so if we commit an infraction, what do we breach? Do we violate or infringe on a law, a contract, a right, or a duty? Which one do we actually infringe upon or breach?
What'd you find out?
Well, I'm bringing it up for discussion among everybody, just to bounce it around, so we can all have a little conversation about it. Because if it starts with a breach, obviously we're looking at, that's obviously, I guess, a portal term, and maybe we can look at it through equity and through debtor creditor, through both ways, and source out what it means on the debtor creditor side and what it means on the trust side.
Well, did you look at the definition of breach?
I think somebody spoke at the time you did as well, Christian.
Did you look up the definition of breach also?
No. Well, let's go right to it then. No, I didn't, to answer your question to begin with, but I'm going there now.
Hey, Eric.
Is that Chris?
Yeah, one of my comrades out here, one of my researchers, him and his brother are one of the most outstanding set of people that does research on traffic. He broke down the infraction right down to the core and did a document that he submitted to the state of California, the Superior Court, that infractions were a gray set of rules and are not laws. They have construed this as being somewhere between civil and criminal, and so therefore he nailed them on the fact that they had created this out of imagination, and that there is no law that supports infractions. And I can send you that document if you want it.
Yeah, sure, absolutely. And going back to what Christian said a moment ago, what's the definition of breach? It says the breaking or violation of a law, right, or duty, either by commission or omission.
So then, if that's the case,
reduce all the statutes and codes down to the public trust. So really, it's a breach of the public trust.
And that's what I was thinking about when I saw breach. And I thought, if it's a breach, then it's a breach of a trust. And what trust is it? Naturally, the public. So all we got to do is claim it, then we can go ahead and set the law of the case.
Right, like that little statement I was given on the other night.
So when we go back to infraction, we read a breach, violation, or infringement as of a law. That's an interesting statement, as of. Instead, it doesn't say of a law, it says as of a law. So there's some gray area there, it sounds like.
Yeah, it's all these others, the definitions that they have, unless otherwise by agreement or otherwise, or that other thing that they put at the end, you know.
Okay. Because, I mean, it's kind of like either left or right here, because it says as of a law, a contract, a right or duty. So I really look at duty in this in terms of trust.
Yeah.
Okay, because that's really where it all starts, and then it gets construed anyways. So if we're going to look at duty, and we're going to look at where did we breach, or did we commit a breach, and then they're making a prima facie case, as we've talked about so many times in the past.
Yeah, because the definition of charge was a person or thing entrusted to another's care.
A personal thing entrusted to another's care. And what was that personal thing?
A person or thing.
Or thing. Oh, okay.
Entrusted to another's care.
Which is the same definition of res, basically, right?
Yeah. Yep.
Okay.
So if we can put in trust.
Right, and then when we say entrusted to another's care, what we're talking about is the judge being the trustee looking out for the public. We're entrusting the judge to look out for us.
Yeah, but it's never been expressed that way. They're working on that misconstruement because of the IMF record.
Right.
And the definition of bail to place in someone else's charge or trust.
The definition of the word bail is to place in another's charge or trust. That's the definition of the word bail?
Yes. Uh-huh.
Okay, and you were saying?
It's, all these definitions we were reading before, but we were reading with debtor-creditor eyes, and we ignored the words that linked it to trust, but they were there in the definitions all along. And it's like when you go back and read them all again, now the trust stuff starts jumping out at you. And here, either or, whichever way they're going to misconstrue it, or whichever way you're going to be tricked into doing it.
Or allow them to misconstrue it because of your lack of knowledge and understanding.
Yeah, you're not centered, right, and you're acting like a fiction.
Okay, and then, when you said jumped out, I was watching TV in the last 7 days, and they were on, I don't know if you've been watching TV at all, but that Casey Anthony case, she got a new judge assigned. Have you seen that on TV at all?
No.
Well, one of the things they had that judge up on TV talking about was he was going to grant, and he was making orders. So, of course, it's jumping out at me at trust.
Yes.
Right on national TV, they're throwing it in our face, and they're just going, please, just recognize the fact that there's trust here. And the other day I was walking to the courthouse, there was an attorney standing up front. I said, hey, you an attorney? And I said, hey, do you do anything with trust law? And he said, no, nothing. So it just goes to show that all these guys walking around that courthouse probably don't know anything about it, really.
Yeah, that brings up that little scenario about the judge and you at a claim and counterclaim battle, where you're going to come back and state that I claim that I am the beneficiary, and who are you, and what right do you have to take my name? Because you could come back with another thing. You could say, well, I have not granted you the beneficial right as beneficiary, so how could you take my name? I have never granted you the permission to take it. That's a good one right there. Yeah, I don't grant you the right to take my name. I have not granted you the beneficial interest as beneficiary. How could you take anything from me?
Who just jumped in and spoke about that? Because there was quite a bit on that last Monday and Tuesday, if you don't have that.
Say again, if I don't have what?
No, whoever just jumped in and said that's a good one. That's a good one. Whoever said that, I have some recordings from last Monday and Tuesday I can share with you if you don't have that, because Christian spoke on that quite a bit last week. Okay. I guess they're being shy.
I didn't hear them.
Could I get a copy?
Please just find me on Skype.
What's the name?
Imagine the One.
Imagine the One.
And and that for me, when he spoke on that, you guys, was really another step forward in the progress of this as to what we're dealing with when we on the public side. And for a while, I was wondering, is there going to be another step that gets taken forward? But Christian keeps on coming out with more and more stuff that helps us get better understanding.
Yeah, because the judge is really just making a claim when he says, who are you? What's your name? He's taking jurisdiction, and the key word is taking. And through the research under trust, the only one who has the right to take is the beneficiary. But how did you get that beneficiary status? It had to be granted by the grantor. And who's the grantor on the case? You are. So they're taking jurisdiction because you're giving it to them. And give, by definition, was to voluntarily transfer a property to another without compensation. So that's what you're doing when you're giving. And that's the same meaning also to the word gift. Gift and give are the same definition. To voluntarily transfer a property, that's what you're doing, to another, the judge, without compensation. And under gift, the second definition was a thing, which would be the res, so transferred. So a little court scenario there, who are you or what's your name, you're being tricked And to them taking jurisdiction, you're being tricked to you give the transfer of your name without compensation. And only the beneficiary has the right to take from the trustee, say, or otherwise. But you could come back with your counterclaim and say, are you taking my name? And the judge's probably going to say yes. And then you come back, well, what right do you have to take my name? Or what type of relation do we have here? And are you the beneficiary? Are you claiming a trust? Probably the judge is going to say no. No, I'm not claiming a trust. I don't see a trust. But that is the garage door opening that you need to drive the trust truck through. Well, I'll come back and say, well, I claim I am the beneficiary, and who are you, and what right do you have to take my name? I have not granted you that beneficial right as beneficiary.
And all that in the first minute, right?
Yeah. Then you could play the second scenario. I could give the judge my name, but then under the restrictions, I'll give you my name in confidence to be returned in the future, along with the proceeds therefrom with my interest. Now, that scenario probably puts him on a rock, between a rock and a hard place, worse than he was before. And if you would try to challenge jurisdiction and walk off without any jurisdiction, I would rather take this scenario myself. I would give them my name in confidence and with reliance to be returned in the future, along with the proceeds therefrom with my interest, because I'm just making a trust, and I'm doing a special deposit, and I'm going to demand the surrender of the special deposit back, along with all the proceeds, all the bonds and the things that they've stuck in the background. They're all mine because they're all generated from my signature off the grant. And if they don't, they would be in breach of trust. So I think we went over more on Monday and Tuesday last week?
That's what it was, yeah, extensively.
Then I took it another step forward. I don't grant you the right to take my name. I've not granted you the beneficial interest as beneficiary, so how could you take my name?
That would certainly imply that they were doing ID theft.
Yeah, look up the word identity. Look up the words parties, the definition of parties.
Which one do you want first, identity or parties?
Go to parties first, because that one's going to take you back to what comes down to identity and how you identify someone. Because the name is just one way of identifying a person. There are other ways of identifying a person other than the name. And if you look in corpus juris secundum under parties, that's where you're going to find that.
I got Black's Law. I was going to say I got Black's Law fourth on parties.
Say again, Shane?
I just was going to say I got Black's Law fourth on parties. It's a good half page, but there's a couple paragraphs at the beginning. The persons who take part in the performance of any act or who are directly interested in any affair, contract, or conveyance, or who are actively concerned in the prosecution and defense of any legal proceeding. And then in Roman civil law, the parties were designated as actor and rus. In common law, they are called plaintiff and defendant. In real actions, demandant and tenant. In equity, complainant or plaintiff and defendant. In Scotch law, pursuer and defender. And so on. So, interesting. And it goes on and on, actually. Livelant, respondent, we use that, respondent. In appeals, appellant and respondent. Plaintiff and error, defendant and error. It just goes on and on in criminal. So there's always two parties, though, isn't it?
Could you grant somebody your qualified name? I grant to you my qualified name. Could you say that in your little indenture?
Well, didn't Christian say you got to ask for the to hold it in confidence and ask for the return as well?
Yeah, the in confidence is really a substitution for the word to be held in trust.
So that's a key word then.
So, Christian, what were you trying to glean out of parties that you wanted us to recognize there?
Well, I think it was really we were looking through corpus juris secundum again. It might have been under the navigable waters, and they were talking about parties. And it talked about under that section, I believe, that that the name identifies a person or a party to an action, say, but the name was only one way of identifying. But the thing was that just jumped out was identity.
Christian, in Black's Ninth on the party, note that an indenture is made between two as parties thereto in the beginning, and in the deed one of them grants or lets a thing to another who is not named in the beginning. He is not party to the deed. I'm not sure if that's what we want, but before that it seemed to indicate that we could be forming a trust.
Yeah, anytime you're talking about a deed, you're talking about a trust. It's a deed of trust.
But he says that he who is not named in the beginning is not party to the deed. So that wouldn't apply. That wouldn't be working for us, though.
Yeah, that may be it.
It says if the indenture is made between two as parties thereto in the beginning, and in the deed one of them grants or lets a thing with a capital T to another who is not named in the beginning. And it says, comma, he is not party to the deed.
Is that Bill speaking?
Yes, it is. Was this JC?
No, Eric.
Hi, Eric. How you doing?
Good to hear your voice, my friend.
Likewise.
Yes, under Corpus Juris Secundum under Volume 65, and that was change of name. That's what it was. In number 1, general, the scope of the title, and under number 2, the definition. It says names are used merely as one method of indicating the identity of persons. Identity of persons. That's under the name. Names are used merely as one method. So there's other methods. Names are used merely as one method of indicating the identity of persons. And it makes reference to Corpus Juris Secundum. Also says the right of privacy and publicity under Section 14. Now, I wonder why. We haven't checked this out yet, but why are they talking about privacy? Right of privacy and publicity.
Well,
and how does that with the identity of the persons?
That gets back. Does that get to
that there are descriptive of persons for identification, since the identity is the essential thing. So the key is to persons, or the name, is identity. Since the identity is the essential thing, and that's making reference to number 6, and number 6 is boundaries. Boundaries, Section 19. So since the identity is the essential thing, that's making reference to boundaries, and when identity is certain, a variance in or misspelling of the name is immaterial. Description, however, is not the equivalent of a name. So the name doesn't mean, it means it really is talking about it's the identity of the person, and the name is only one method of indicating the identity of the person. So the identity of the person is probably set by the boundaries.
That's true. Yep. Christian, real quick, Keith Livingway has been trying to get us to understand that the way the UPU is set up, and if you're a postal zone, you have boundaries of where otherwise you're subject to a postal zone of value, of which what I told to Swift Arrow with the United Nations of Turtle Island last week is that because you are subject to the United States of America and their postal zone, you have no boundaries. You're subject to anything they dictate, and you're not sovereign to them. But what Keith Livingway has been...
You're not private. You're not private until then.
That's
and
right.
If you're private, now you've kept your property and yourself segregated, and now you're talking about a trust. So I think all this stuff is relating back to trust.
Mm-hmm.
Private trust, because that identity of persons, they're making reference to the privacy and publicity. So it's the right of privacy, but then by boundaries. Now, I haven't checked those two out yet. I'm probably going to, but from what I can glean out of this so far and tie that in with what you just said, with what Livingway's doing, the boundaries is leading to keeping it private. And when you keep it private, you're really doing a trust because you're segregating it. You're doing a special deposit.
Well, what he does in order to have boundaries is you've got you can do a declaration of easement of where you set up your boundaries That could actually be part of our indenture of where you can write in your easement of where there's boundaries, where anybody that comes to that boundary, they have to have an easement. In other words, they have to get your permission to cross over and conduct any kind of commercial business with you.
Well, you remember declaration is one method of formation of a trust.
Yeah, correct.
Okay, now we're jumping to boundaries under Section 19 of Book 11.
Before you go forward,
and
Christian, before you go forward,
yes,
one of the key words that I keyed in on earlier that seems to just be resonating through everything you guys are saying is the word private. And when you were reading something earlier, just 3 or 4 minutes ago.
Uh-huh.
So if we establish boundaries, are we no longer in their public realm because we establish our private boundaries? Is that what they're really getting at in what you read?
Yes, it's in trust.
If you have no boundaries, you're public.
You're making a special deposit and keeping yourself private. You're manifesting your intent to keep yourself private by putting yourself in trust, by specifying boundaries and making yourself private.
That's right.
Is it kind of like saying that public is kind of like a presumption until you rebut it by giving some specific way of saying that you're not in the public?
Yes, rebutting it.
Well, Shane, that's what they default to every time anyway.
Yeah. It's just, but the idea is, I like it because it makes sense, right? It follows that principle. They got the hidden presumption, and if you don't see it, you don't know how to rebut it.
Right. But going back to what you said, do you think that that's what they were trying to communicate to us in what you read, Christian?
Without going into it further, which was going to jump into book section 19 on boundaries here.
I mean, but what you read already.
Yes, right.
Okay, because that's exactly what I was thinking about. If we fail to make the claim, then they're going to go ahead and construe it just as they always have.
Correct, right.
All right, I'm with you.
So section 19 under boundaries, it's talking about by name. So where a reference to land as owned or occupied by a named person conflicts with a more particular description, the question of what land is intended to be conveyed is one of construction of the whole instrument. Reference to a tract by name or by a lot number on a map or a plat may sufficiently define boundaries. Now, where land is described by metes and bounds or by courses and distance, and also as being or having been in the possession or occupation of a named person, the two descriptions conflict. The determination of what land is intended to be conveyed as a question of construction of the whole instrument. If it is clearly the grantor's intention to convey the land as so described by ownership or occupancy, that description will prevail. But where such reference is merely descriptive, it will yield to a more certain and definite locative cause.
So in other words, what they're saying is that if you do a private express trust and it's fully expressed, they can't breach that on that. But if it is left undescribed, then it's under the presumption under public of which you're subject to a statutory law.
Well, yes, in a way, but it's the grantor's intention and comes back down to that. What did the grantor intend?
Mm-hmm.
Always comes back down to intention of the grantor. He's controlling the whole thing. And even if he doesn't spell out exactly in an indenture, he can always come back if he's still alive and correct it by parole evidence that was not his intent. That's a mistake. You guys are construing it wrong.
Did you say parole evidence?
Yes, parole evidence. That's oral. Oral testimony, parole.
Also in Corpus Juris Secundum 11, under boundaries, section 3, 1995 in black, it says, the object of the rules for the establishment of boundaries is to ascertain the actual location of the property as made at the time. The important and compelling consideration where there is a conflict as to the boundary is the party's intention, whether expressed or shown by surrounding circumstances.
What section was that?
11. J. 11? CSJ, boundaries. Number 3, 1995.
Okay, that might be a different one. The section 11 that I have is government corners.
And section, no.
Again, it's corners and their location. But I just wonder, does corners mean the corner? The undertaker, the state coroner? Or does it mean the boundary locator? I don't know.
Well, here's a question. What about the language we use? Can we put that in the trust as well?
Yeah, you can. You can make an indenture as complex and narrow it down to exactly what you want and spell it all out. Or you could make it as simple as, I just deposit in trust to be.
Well, what I'm asking is, if rather than, we're claiming the language as a res. It's our problem.
Claiming the language as a res?
Yes.
No, I don't think not on an indenture. You wouldn't want to claim the language as the res. You mean like the charging instrument? Claim that?
Well, what I mean is, like, if I say to you, 2 plus 2 equals 4, what do I really mean? You could have TWO plus sign, TWO equals FOUR, or you could have a multiple combinations of TOO, plus TO plus FOR.
Yeah, you have to clarify that, yeah.
Right, but I'm just asking.
If you're still alive, you could do that. You could correct the misconstruement.
Yeah, so we could make the language a specific language trust res.
Yes, I like to keep it simple principle. As long as I can shoot from the hip, I got no problems. They can misconstrue it all they want, but as long as I'm still alive, I can come back in and correct the intent.
Right, okay. It says here we have private boundaries and public boundaries. A private boundary is an artificial boundary maker. Public boundary, a natural formation that marks the beginning of a boundary line.
Okay, this is under the same section, continuing on under tracks, it says. And I'm going to skip the paragraph that talks about reference to the tracks by name, although it might be better explained in the next paragraph. Ordinarily, a designation by name for the track or by reference to a lot or lot number will yield a more particular description by metes and bounds. The particular description, which is erroneous, will be rejected. In a state in which the United States government system of describing land is in accordance with the federal statute directing the subdivision of public lands into quartered sections is used, a description of land as the northeast half of the section is unintelligible. But ordinarily a designation by name or by reference to a lot or a number will yield a more particular description by metes and bounds. Doesn't that sound like what they're identifying you as? Just by a name and by reference for a lot number? So is like your Social Security number just a lot number?
Yeah.
And a name and a lot number?
If you go back to what...
and your boundaries?
Christian?
Yeah.
If you go back to what Keith Livingway has been talking about on the calls, is that the proper way of conducting yourself is like an ambassador or a diplomat under postal zones. What you're doing is you're gaining easement by surveying the other person to have proper easement to conduct correspondence with that other postal zone. The same is true with going to a courtroom. You need to survey the courtroom and describe it in order to have easement to properly go into a courtroom. He says that most people are engaging court in a trespass of which they are doing a criminal trespass against the court, surveying it and setting up an easement to conduct business with the court. I thought the language and the way that he was describing that was quite interesting because it's related to our topic tonight, and it's to be taken with a grain of salt. It is, some of the stuff that Keith Livingway is bringing forward, but it's related to exactly what we're talking about here. Gaining easement means that you survey the postal zone that you're looking to interface with in order to have a diplomatic relations with that other postal zone.
Oh, that's probably why they have the high watermark stake out by the federal buildings.
That's right. And one of the things that he emphasizes on doing land patents is you go back and set the sea and land boundaries as they were prior to the commercial realm that they are implying now, and reestablishing that as part of your land patent. That is part of the description of a proper land patent on any part of land, is having boundaries by sea and land. And so therefore if you go over to his site, he has actually set up all those sea and land boundaries for people to utilize that in their land patents.
Mm-hmm. But backing up to that first paragraph I read under boundaries, it said in the middle there, if it is clearly the grantor's intention to convey the land as so described by ownership or occupancy, that description will prevail. Yep. So if it would make it clearly the grantor's intention, or make it clearly corrected as the grantor's intention because of mistake.
Are you reading that out of Black's law?
No, I've gotten my full set of corpus juris secundans back, which I'm very well happy about.
Where do you get that?
You have to be fortunate enough to run across it. I bought a set used at the library for $250, 167 volumes, and they range from 1955 to 1989, something like that, copyright dates. A full set, 167 volumes.
You got the whole set, Christian?
Yes, I have the full set, yes.
Nice.
Back in my possession, like the Ark returning.
Hey, Christian, why don't you tell them what the volume is about? It's a little bit like the Valentine's Dictionary of Words. This is the approved definition of words.
I'm not following you, Chris. Tell them about what now?
Well, the corpus juris secundum is the proper lawful enactment by Congress of the definition of these particular words.
Oh yes, okay, right. Yeah. And now if we had a set of am juris, that would complete it.
Hey, Christian.
So what value do we give to Congress?
What did it say again? What value? What?
Well, if Congress is a de facto organization, what value do we give to a body that's de facto with respect to names?
Yeah, I think when you realize that you're the grantor and you've got all the power, I think you just strip them and defang the snakes. Really means nothing, because those definitions are setting it in their realm.
Right. So that's what I'm asking. Like,
yeah.
I mean, it's a good reference, but I'm just saying we'll be playing by their rules.
Yeah, but the public is the liability side of the ledger, and the private is the asset side of the ledger. To make a closure and settlement, I must be in control of both sides. So once I know the definition, what controls the public side, and once I know the definitions that controls the private side, then I can do a closure and settlement. I can merge the titles and extinguish the debt, because I know it's not all about GAAP. It's about merging titles.
Right.
And that's what they don't want you to know. Deposit in Black's law. The act of giving, and remember what we said giving was? The transfer without compensation. Deposit, again, the act of giving money or other property to another who promises to preserve it or use it and return it in kind. Well, if that's not trust, that's a special deposit. If they're returning in kind, that's a special deposit. And use, to use it, that's trust term also. But the only way anybody who gets to use it is the trustee. The beneficiary gets to take to the use. Giving of money or other property, that takes in just about everything. And you can make a deposit of other property. Especially the act of placing money in a bank for safety and convenience. And then on down to general deposit. A bank deposit of money that is commingled with other depositors' money. In other words, they didn't keep it separate. It wasn't private. And 2, a bank deposit that is to the depositor's credit, thus giving the depositor a right to the money and creating a debtor-creditor relationship. Creating a debtor-creditor relationship. Just like we said in Corpus Juris Secundum. Now, this is out of Black's. So a general deposit creates a debtor-creditor relationship between the bank and the depositor. The bank is not required to return the actual money deposited as a general deposit, as it must with a special deposit. The bank need return only an equivalent sum. So special deposit now, a bank deposit that is made for a specific purpose that is kept separately and that is to be returned to the depositor. The bank serves as bailee or trustee for a special deposit. And remember we said bail was to place in someone else's charge or trust, then a charge is a trust. And they said a bailee or a trustee for the special deposit. And then remember, charge was a person or thing entrusted to another's care. So when you go to court, they're offering the charge to you, which is they're offering a trust to you. And they're trying to take your special deposit, your name, to trick you to give or make a deposit. But you're not expressing it to be a special deposit unless you put some kind of qualifiers with it. And if it is a general deposit, then the relationship that is created is the debtor-creditor relationship. And you just got sucked into the public realm.
Can I get clarification? You said personal thing entrusted. What was the word that you were using in reference to that?
Okay, that's the definition of Black's Law for charge. A person or thing entrusted to another's care. So that charge that they try to stick on you in court, you got to make a special deposit instead of a general deposit. If you make a general deposit, it's going to be debtor-creditor relationship. And they're going to take your name, and you're not going to have any comebacks on them.
That's part of Eric's answer for his situation that he was describing.
Yeah, yep.
So, Chris, you're saying when you give your name to the judge becomes a trustee?
No, he's the beneficiary because he's taking your name.
Or becomes a beneficiary, okay.
Yeah.
And you, by giving your name?
Confirm that he's the beneficiary because he's the only one who can take. But you haven't corrected the misconstruement. And the assumption stands that you're a trustee. Because the trustee is the holder of possession of the property, and he's supposed to give to the beneficiary.
So,
and the only one who can take from the trustee is the beneficiary.
So in principle, we don't want to give because we lose control, which makes sense. We want to give with special conditions to show that we maintain control, but we want to cooperate because we want to give him the name so that he can do what he has to do. That might be one of the conditions, but that's the idea?
Yes,
okay.
Because I would rather see that I would give you my name in confidence with the reliance on to return in the future along with the proceeds therefrom with my interest. And then once the trust would be formed, I would then instruct them to do the conversion of the principal and merge the two titles and extinguish the debt, the lower title, with a higher security in the trust. And then I would proceed to call back the proceeds therefrom because I was entitled to it because that's my interest.
Could you say all that publicly in the court?
You might be able to because I could probably say that this was a public trust we're forming right now.
Okay.
Because that was my intent.
Okay.
And we could operate under statutory trust. We could just pick out Gilbert's and operate by statutory trust.
They would certainly have to recognize that.
Yeah, as long as I could prove that there was a public trust after I made the claim.
Oh, yeah, and you'd still, of course, getting back to proving it, of course, yeah.
Well, wouldn't a public trust be the HCR 192?
Yes, along with all the other statutes and codes.
Yeah, but I'm saying that that's a primary example.
Now, I wonder if that's establishing boundaries.
Just an inquiry. When you were saying that the judge remains as a beneficiary, but you're working the capacity of a grantor / settler, you're giving instructions and orders to the judge. Wouldn't he become the trustee at that point?
If you were forming a trust, yeah, you could make him the trustee, yeah.
Because he would be mandated to close and settle the matter if he's trustee.
Is there such thing as a limited trustee?
Yeah, sure. But I don't know if you have control to close the matter though that way.
Yep. Because if he was limited, that means there is a co-partner in trusteeship of where he would have to be not in conflict with that other decider to the trusteeship.
Like there has to be a total transfer of interest from the grantor to the trustee. If he had any kind of limitations on it, then it wouldn't be a true trust.
Yeah, I was thinking more just in the sense like if you were the trustee and you're essentially just making him like the quote-unquote secretary trustee, the one who has to get the work done, so to speak, more along that lines.
Yeah, now I was reading in Lewin where a trust can form along with powers associated with it, but yet the powers are not part of the trust. And I don't know if that would apply to that situation or not, but...
Well, in general, just to go back, I forgot how we're trying to do it then. When we are in court, for example, and let's say the name came up and they asked them, so are you asking me to give you the name, and trying to focus a little bit on that? And who knows what kind of interesting conversations could come there, but basically something I'd try and say trust along the lines of trust. I'll give you this name, but on condition that settlement, whatever. Where was I going with that? So what position, by definition, would I be in? Am I just acting as a grantor there, or am I being more than the grantor?
One of the trust, your grantor or settler.
Okay. So you're creating a little trust right then and there, essentially.
Yes, right. Mm-hmm.
Okay.
If I'm giving my name, he's taking my name. There was a transfer of my name right then and there. There was a trust formed verbally.
Got it. Okay. Thank you.
There was an actual transfer of trust property, the name.
But in that particular situation, is that trust res in order to close and settle?
That's an option.
Yes, because, yeah.
So you would have to mandate the order or instructions to execute that to the judge.
Sure.
Right.
That's why they are limited to. That's why they can't force you to give them the name. They try to dance it out of you, right?
We've always asked for settlement and closure on a debtor creditor, and then we made a payment out of the trust. So, but we never signed by trustee, but we claimed that there was a trust, but we never proved the trust. So we never had the office of trustee hat wearing ability to make a signature as trustee to authorize a payment out of the trust. Therefore, they never had to honor a trust payment under debtor creditor because we never expressed it as a trust. Which is the same thing I was trying to bring out under corpus juris secundum, which says that a trust has to be treated as a trust.
Hey, Christian, would you say that again? I'll give you my name, and then go on.
I'll give you my name in confidence, and in confidence is synonymous with trust, in trust. So I give you my name in confidence with reliance. So I'm relying on this now. Give you my name in confidence with reliance to be returned in the future, along with the proceeds therefrom, with my interest.
Aren't you going to leave them anything?
No, why should I? It says in there the trustee does not have to be compensated.
They don't. I thought they got a right
they
to.
Take your name. Do they take your name with any consideration?
Well, besides that, but I mean, but isn't there a little bit of goodwill and cooperation that makes it even harder for them to come against you?
No, I think I've contributed enough to their retirement policy. I don't think I need to contribute any more.
I hear you.
They'll be the duty.
I can't argue that.
I think many people before have paid the debt well over by their incarcerations, and they allowed it to happen.
Okay, so this is like tough love. Just letting them know straight up what the deal is.
So, in other words, if the judge fails to execute the trust, then you can hold him in contempt and or breach of public trust by failure to execute the closure of the case by the grantor or the settler.
Yes, he's in breach of the statutes and codes by letting the trust fail because he's committing bad faith, and he's in breach of the public trust now as well.
Yeah. And how would you execute a document like that? Would it be under contempt? Would it be a notice of felony? How would you execute a document to
Probably
give
a writ of execution on the private side.
A writ of execution, okay. Excellent. Private. What happened to Eric? Because this is the juice that he's needing for his traffic ticket. Eric, did you get off the phone? Okay. Guess he did.
Oh, he just stepped away.
I'll have to make sure that he gets this part of the call.
Christian, when we do this, I give you my name, give you my name. That's a form of trust. But do we have is there any orders for the court to perform?
Yeah, I would probably have to send him a letter of rogatory in private to take and give him instructions what to do.
Okay, so now we're in the so-called court right now, and the guy says, "Give me your name," and we say what we say. Then how do we put that in? Do we say we need time to make an amendment, or what do we do?
Do we need time to make an amendment? Well, I think you're going to know that before you're going to be going in there, so you better have all your ducks in a row before you get in there.
Mm-hmm.
Oh, I see. Right. Okay. Right. Okay.
So in other words, would you give notice to the court prior to the date of the arraignment, or just showing up in court, naming your name as trust res, and that you're granting them that through the instructions to execute trust res by using the name itself for settlement and closure of the case? Is that how you would do that?
Yeah, but it wouldn't be settlement and closure. It would really be the extinguishment of the debt.
The extinguishment. Okay, the extinguishment. Yeah, that makes better sense.
So then when we come to court, it would be sort of like a moot issue at that point.
Yeah, because otherwise, if he didn't dismiss the case and close it out or extinguish it, then he would know right away that would be a breach of trust and also a breach of public trust, and he would be liable for damages.
That makes sense.
Yeah, and you could come at him on the at-law side and hit him with tort charges, and you could come at on the equitable side and hit him with equity performance of the duty.
Yeah, or lack thereof.
Come back over onto the private side and hit him for damages and both compensatory and punitive.
So just for a trial case, if we had a traffic ticket, for example, if someone has a traffic ticket, in advance you have to go, in advance you're going to have to put your name, we will put the paperwork in advance, indicating that we're forming a trust.
Mm-hmm.
I would like to point out, though, this is all everything notwithstanding that you know how to go into the court and avoid all the jurisdiction stuff, all the other stuff that they're going to try and do to get jurisdiction over you. Any one thing that you might overlook. And if you find that they're ignoring you, then, you might have done something.
Yeah, well, I could come in and say, I do not grant you any other right that I have given you.
That'd be the quick and easy way to handle that, huh?
Yeah, but they can keep coming back at you, though.
Well, they can't because they need our energy to continue.
And I would go to the three-strike rule, and after that I would say that this court's in dishonor. It all ends now.
Yeah, I need some kind of strategy.
Hey, Christian?
Yeah.
Hey, do you suggest, walking, when you walk in the court, you're standing at the bar, here in Tennessee, of course, Davidson County, where I am, they have a big sign on the court that says attorneys only. And I've heard some other mentors say, well, you want to ask for permission to walk in, or there's a certain... Do you suggest asking permission to walk in, or do you just kind of walk in
I'm not going to ask for permission. That's precatory.
Yeah.
I'm going to grant, declare, and decree and order.
That's what I thought. Okay. Another question for Chris. You mentioned about corpus juris secundum. I think you said it was official language, or more official maybe than...
Way back in the 1800s, the only one that was endorsed as a definition was Valentine's. It was the only dictionary that was ever endorsed as the definitions of words. What replaced that was the corpus juris secundum. This, from A to Z, is your definitions of all the law terms and definitions of names in its details. That's what the corpus juris secundum is. And it gives you all of the endorsements and the enactments of law as part of the definitions.
Yeah,
and it also has all the key sites, too.
Right,
Yeah.
and I read a lot out of American jurisprudence, but what I wanted to really point to is here in Nashville, the only public law library is the one at Vanderbilt's Law Library. And I noticed, I was literally just talking to the law librarian in the special research desk about this less than 2 weeks ago. They have removed Corpus Juris Secundum from circulation at the law library. They don't carry it anymore. So the only way that you can get it is if you have I think it's on Westlaw or digital. So if you have a subscription to Westlaw, and they only have a public subscription to Lexis. So, it's not there. I went in, I talked to the law librarian about it, and I actually overheard some other people asking where it was. They were like, oh, they canceled it for some reason. So
we've gone total lawlessness.
Pardon me?
I say we must have gone total lawlessness.
Well, and they used to have, 3 computers. Well, first of all, in Davidson County, there used to be a law library that was maintained by the Supreme Court of the state of Tennessee, or the Supreme Court of Tennessee, whatever it was called. And then it closed in 2008 for budgetary reasons. And then that left.
Are they getting budget cuts?
Yeah, well, exactly. And then so that left Vanderbilt's Law Library as the only one. And they used to have 3 public computers when I first started going there. Now they've only got 2. And they're gradually, just kind of getting rid of, I guess, public access to the law. So anyway, that was.
Well, what they're doing is inadvertently they're making up an excuse, the reasons why you can't have access to what the definitions are that were the intent of legislation of when they described and defined each of these words and how they can be used. So therefore you have to haphazardly guess of how to conduct your cases without it.
Problem, reaction, solution.
Yeah.
Information is power.
You have to go through them. That's ultimately what they want. They don't want you to be able to walk into court and stand on your own, stand on your claim.
Control of distribution of information.
Yeah.
Well, as the trust, you are the law of the trust. You are the law of the case through the trust.
And that's what I was saying about the language. He who controls the language controls the law.
That's right.
So that's what I was asking. Yes, we want to keep language flexible. At the same time, if these books or these sources are being eliminated, then we may find it necessary to create a language that gives us protection, and if you put that in trust, it's our language, because the language we use, like UCC, that's their property. We don't own that. That's a copyrighted material.
Mm-hmm. Well, it might be good for us as a group is to pool together enough money to be able to have these sites available for us on NTT, just as for our study material. It's just go ahead and pay the money outright to have the links posted. Of course, it'd be just for the inner core people. You wouldn't public that. Well, I don't know. It's up to you, Christian. But maybe what we can do is pool the money together to pay for the site link to where we have access to both of those, the MJUR and the CJS.
Yeah, do they have a digital version of those? I don't know.
Yeah, they do, but you have to pay for it.
Right.
Also, too, the law bookstore out here by Richard Finley is closing in June, and there's a strong chance that he's going to liquidate all the books that he has there, and he probably has a substantial amount of both of these sets of books that he will be wanting to clear out, and they're not as easy as you think to clear out because not everybody wants these volumes, because it's like 20 cases or more.
Well, here's that's what everybody does, that they go to their local library, their main library, and they go back and ask the head librarian, who's in charge of what they do with all the old books. Because they got a special room back in there that you can go in and you can probably buy these volumes that cost $400 or $500 each volume. You can buy them for $5 a piece.
That's right. In fact, Tim Turner said
most small books.
Tim Turner says that in his hometown, he went down there, and whoever is the shipping and handling person says that when we get these brand new books in, we don't know what to do with them. We just end up discarding them. He ended up getting a whole volume of one of these sets, either the CJS or the MJURs. He got a full set for like $240. Right. Really ridiculous. And he says that he felt like he was like a kid in a candy shop, dude. I feel like I hit a gold mine when I got that volume.
Yeah, go to some of the law firms, the large law firms, and say, hey, what do you do with your old books? You know, would you donate them to our church effort? We're putting up a law library for the young ones.
Yep.
Hey, Christian, here's a question.
You're the youngest one yet, right, Christian?
Say again?
I said you're the youngest of the young ones, right?
Oh, yes, yeah. Young at heart, yeah.
Young and wild, right?
No, not wild anymore. That's over with. Young at heart.
That went with the oats, right?
I got smarter.
Hey, Christian, I got something that I'm trying to figure out if I've the process of deducement has brought me here. I'm speeding ticket. I did a refusal for cause, and the judge wrote me back and said that the UCC doesn't apply to the Uniform Florida Traffic Code. So I thought to myself, well, if the UCC doesn't apply, then there's only one other place to go with this, and that seems to me like that would be trust, because it's either the UCC or trust. Is that right?
Yeah, trust would be a way to go, but I'm thinking, he says that the UCC does not apply?
Yeah.
That's not the first time I've
heard
heard
that
that
either.
either.
If I him a check to pay the bill, then he can't apply UCC to cash it? I think you got smoked.
I'm thinking I did too, but I just wanted to bring it up, and because they wrote me back and said, no, you got to come to court because, I requested a hearing after they said that the UCC don't apply when I refuse for cause. I said, okay, well, I'll go in there and get them to tell me how.
Ask them, how am I going to pay you then?
Okay. What's going to govern the payment of this?
Obviously negotiable instruments are out then.
Okay. Tell me how I can make payment.
You got to establish you have no money too.
Or use the clause stating a claim of where no remedy can be used.
Okay, maybe he's making reference to that he can't apply UCC because you didn't bring UCC in. Did you refuse? Did you come in like under 3-104 and bring 1-104? Excuse me.
I did it under Florida statutes, and she told me the UCC didn't apply under Florida when I used Florida statutes when I did the refusal for cause.
Well, where's the conclusions and facts and law?
Okay. So when I go to court, get it's a woman, but get her to state that.
Why not?
Yeah. Let's get this on the record.
But wouldn't
you obviously if UCC doesn't apply, there's no way possible I can make you a payment.
Yeah. Why don't you go ahead and make a judicial? Why don't you put it on the record how I'm supposed to make payment if the UCC doesn't apply? Because negotiable instruments are out, obviously. Okay.
Did you reference the UCC from your state title or from the national UCC?
It's I referenced the Florida statute that the UCC was comported to.
Oh, okay. Wow.
So she would be able to see it.
Could refusal be construed as a form of controversy or contempt, as opposed to, say, like waiving the offer?
We could probably make a case out.
You mean her refusing my refusal, Shane, you mean? Is that what you mean?
No. I'm looking at your refusal as contemptible, as opposed to, because I forget, there's a big reason why we always use waive, because you're using language that they can't construe as being, you avoid contempt, right? And I'm curious, too, did you also get a chance to respond back to them in 3 days? Yeah.
I did it by registered mail. It was certainly within the 72 hours.
So I would have suggested maybe just saying I waived this offer and put a date and signature on it.
What did you do under trust, though?
I didn't do anything under trust.
Shame on you.
Huh?
Shame on you.
hey, that doesn't mean I'm not gonna.
But what you need to ask them is if you're not in commerce and you're not using UCCs as part of your guideposts, why are you listed on Dun & Bradstreet?
Have you signed any kind of notice of appearance or anything? Are they trying to are they asking you to set a court date? Is that what they're trying to say to you?
There's already hearing, and it's Wednesday.
Did they give you the date, or did you sign anything to go for that date?
I called up and requested the court date, and they sent it out and said, here's your date.
I guess in a sense, is that the same as signing a notice of appearance then? Because you accepted?
I didn't reject it, so I guess that's acceptance, right?
Oh.
Did you do a validation on it yet? Did you do any discovery on anything?
The first question was, did I do what? What kind of validation?
Debt validation.
No, I didn't.
And I just want to run this by you.
That would be the first thing I would do to anything. I would run a debt validation on the thing, and when they didn't, then I could generate that certificate from the notary. And that certificate from the notary, that's a colorable side thing, and I could run with 100 different ways with.
It's a colorable side thing. Okay, so then in order to have time to perfect the administrative remedy, which you're talking about, what I was really trying to do is figure out how I can avoid going on Wednesday. And I was going to send a letter with my...
haven't done discovery. Put some discovery in there, some kind of request for something. Try to discover some information. That'll jam it up for about 3 months.
Well, but I got to send a document to the judge's assistant tomorrow, and I need good grounds for getting another date.
Just adjourn it for another date.
Grounds for another date for a continuance.
Do you have an example?
Hey, Shane, one at a time, you guys, please.
Grounds for a continuance.
I'm sorry, please say it again.
Discovery is grounds for a continuance.
Okay, so, but they're going to say, well, you had time to perform discovery already. What if they do
Well, put some kind of discovery in through the court and put something through to, say, the arresting officer. Put some admissions in. Ask the court to produce. You don't want to see the original. You want to see the, whether they're holding, who's got the ownership.
Christian, I just dropped out for about 30 seconds because the call dropped. I'm sorry. Last thing I heard was do some kind of discovery.
Yeah, admissions into the guy that did the arrest. Put in admissions into the court, for put some production into the court for make them produce the original. You want to see the original.
Or better yet, Christian, because I've had a chance to talk to him, because it was a radar gun that was used under the best evidence rules, he can ask for discoveries of whether or not that instrument had been secured for evidence on the case and been put into the evidentiary room. And when they fail, that would be your discovery right there, Eric.
Mm-hmm.
Okay, but at this point, what I need is good grounds to get a continuance or a rescheduled hearing, however you want to say it.
Some kind of discovery in. Now that you've got through the court some kind of discovery going on, they must grant you continuance because you have discovery going on.
Eric.
They can't default you or give you summary judgment while discovery is going on. And you have a right to discover the facts in a case before you go to a hearing.
So what, just write the letter and the grounds are still conducting the discovery?
No. Actually put some discovery in. Put it in by motions. Run it through the court.
So what I need to do is go ahead and get that over to the case file tomorrow because the hearing's the following day, so I have it registered in?
Yeah. So you got some actual discovery in the case running, and then you can ask for a continuance.
Can't you just say you haven't exhausted all your remedies and you need more time, you request an adjournment?
Yeah, but usually I don't know, they don't kind of accept that one so much.
And I was going to say that I can't find competent legal counsel.
No, they'll appoint you, say,
a
public
defender for a traffic case?
Yeah, right.
Are they really that pushy on your rights, like with stuff like that? Because I've always seen them give me adjournments for anything.
He can also file a counterclaim against the officer for trespass and for false arrest, which they would have to address that because he becomes the plaintiff, and they would have to address that before they got to the issue of the traffic citation.
Yeah, well, I'm just thinking he needs to buy some time so he could do a debt validation and then come in with the debt validation, the certificate from the notary, and have a colorable side build up.
I thought if you say you have not exhausted all your remedies by definition, you're not supposed to be in the court, and they got to get you out of there.
Yeah, well, I've tried that one before. If we have not exhausted our administrative remedy, we haven't started discovery, and we want 120 days, and that didn't work.
Okay, good to know.
But when you put actual discovery in the case, now you have a motion in there doing discovery, and then you could come up and say, well, I've got discovery running. You can't default me while it's running, period.
One of the challenges that I have is here in Florida, because it's very hard to figure out who I'm going after for discovery because there's no prosecutor on a traffic case. Who do you send your discovery request to?
Well, run the discovery on the officer.
Okay.
No prosecutor, it's got to be the state then. Send it to the, I don't know. We ask the clerk where it goes from there.
Well, he has no case. I mean, if you just use the best evidentiary rule and ask under discoveries whether or not the radar had been secured at the date in order to be secured as evidence for the case, if they failed to have that secured and put into the evidentiary room, they have absolutely no case because they were basing the whole case based off of the radar.
Actually, Eric, I got a PDF on that whole thing that he's talking about.
On what Chris is talking about, Shane?
Yeah.
Okay. Yeah, because I'm not sure when you say best evidentiary rule, what how do I figure out what rule in Florida that is?
Well, you'll know when you read this thing.
Okay.
Yeah, it's pretty common, actually, but why don't you pass it to him because he'll open his eyes real quick and realize that that's his whole case right there.
Yeah, speeding in the radar gun, if that's your issue, I'll pop it up here. Hold on.
And also, there's still the option of going ahead and doing the 1 and the 3 and claiming, and then the protective order and taking it in and ordering payment and disbursement.
I'm pretty sure that either way would work. Hey, Shane, can you send that to me too? I could keep that in my archives.
Sure.
Yeah, I think it works better when you give them something on the colorable side that they can save face and bow out gracefully. If you don't have anything over there, they're going to say, we can't do this, We might not. If you give them a way out, they could do that.
Christian, just on this kind of the same topic, if you had signed, got the around to signing a notice of appearance, and you signed it without prejudice, and they set a court date on it, could that go against them? That they set a court date on a contract where you didn't give up your rights to agree to that?
Yeah, but should I express it to be a trust and come in and claim it as a trust then?
Oh, yeah, I don't know what the outcome. Yeah, well, no, it's a different track. But I was just because I'm trying to figure out. I have done it many times, and other people have, and they don't set the court dates. And of course, I'm just begging the question, sort of. They're obviously avoiding something because obviously they would still try and sneak and do it. But obviously, it's enough that they never set the dates on any of these tickets. So they're afraid of something. I was wondering how powerful. Because that's, like, for example, if you say, by what right did you set this court date? They'll say, well, you signed a notice of appearance and say, well, can you show me that document? Uh-oh, right? Is that, what I'm getting at?
Yeah, they don't have the document. What'd you do with it?
Well, if they did, then you'd say without prejudice on it, which they couldn't present in court to begin with, right?
So they may have attached it to a bond and used it, or they're trying to get rid of it because it says without prejudice?
Yeah, exactly. And then, yeah, at the same time, that's the whole, and you'd probably have your own copy of it. I guess you'd have to show that in private or something.
Yeah.
You like that?
Yeah, either that or you have to claim it was lost or stolen or destroyed and then come back in and reform it.
Well, you want to throw it in their face because, that's going to totally, I don't even think they'll want to see it in the court because it's like that you can't, well, technically, I don't know, would you be violating a trust if you brought a copy of it in? Because you're signing without prejudice, meaning that this can't be used in a court of law, right? Yet you need it to prove that they had no right to set a court date based on that in the first place. So just trying to see get around the logistics of that.
Well, make that part of your trust res and then put in a CCC.
I'm just figuring that it's got to kill their whole justification for setting the court date by definition. I just want to basically establish that, and I think that would be the end of it.
I'm having a mental block on that one.
Okay. Well, just let it, if it comes, think about it for a bit. And
now, do the complaints, the police do not sign those complaints under the penalties of perjury, do they? So if you sign questionnaire that you're going to send them a questionnaire and give them all the answers. If you sign it under penalties of perjury in front of a notary and never mail it, that's not equal. And they don't respond. Your claim is under the penalty of perjury, and theirs isn't. Wouldn't that make a difference?
I don't know about that.
Litigate the case, yeah. It might.
I mean, you're saying giving them something in a colorable side, and your statement is under notary presentment under the penalty of perjury, and they didn't respond. You asked them so many questions, they didn't respond, or you gave them the answers, that means they're in agreement. Wouldn't that just about put the mix on them, the colorable side?
It might.
Part of the remedy is explained on the back of the ticket. In California, it's Penal Code 853.7, of where it allows you to respond either in written and or oral by convening a hearing on the issue of whether or not they had jurisdiction at all, of which is kind of like a probable cause hearing, of where once you explained that you were traveling separate and independent from commercial considerations, you have a right to travel with a commercial license and registration. And if you're conducting just personal business without commercial value, that ticket does not issue them jurisdiction to continue. On your ticket, look on the back. It will actually allow you to respond separate from going to a judiciary, to be able to show up at an administrative hearing to hash this out of whether or not they have jurisdiction to move forward to a judicial court.
That's all a trap, though. I mean, in a way, he's got himself in jurisdiction by accepting their court date right off the bat. And I don't know if you can just create any kind of statement, or even making a statement. You're actually drawing your jurisdiction there. So I mean, people totally underestimate this, really. And I guess you got to experience it, though. That's best. But I think part of it is the attitude that I think he's got the right idea for discovery, because your attitude is you're going there under duress to clarify any misunderstandings, and you're only there on discovery and to hopefully settle and close any accounts, that kind of thing. And you're not there for any other reason. And you got to be very clear about stating that so that it rebuts any other presumptions otherwise. So, like, do you understand that I'm here only under duress, and I understand that, or I'm aware of, that if I didn't come here, there'd be lots of misunderstandings and warrants and whatnot, but I'm here to assist the court, and if there's any actual claims, to hopefully help you, assist you in settling them.
Well, couldn't you say special appearance, Shane?
Yeah, maybe, yeah. I hear a lot of people say that.
Well,
I've never tried it.
Would you send that over to me, too?
What, the speeding ticket, then?
Yeah.
It's not going to talk about the jurisdiction. It's just going to talk about arguing. You know what? I haven't read through the whole thing because it's not my style. I like the simple, stupid, preemptive, cut it off before it even gets started kind of stuff. You know what I'm saying? I'd rather make my argument there, right? They're trying to, if they can't get you established, then there's just nothing to go on. And that's the end. It's a lot easier to argue just one simple thing over and over, because actually you might think, oh, that's easy. Just make sure you got no jurisdiction. Yay. But I mean, that's so many stupid little things that they got going. But that's a whole game in itself, right? But at least it's the same game every time. And I think after you've done it 2 or 3 or 4 times, it starts to make a lot more sense. I mean, you don't have to go a lot of times to increase your understanding very quickly. I think after 2 or 3 times, you'll have it.
Well, here's the other alternative, is to take an indenture, describe yourself under decree or declaration, put it on a UCC-1. Anytime you're pulled over by an officer, you serve that in your preemptive consideration within the 72 hours that they have just created a trust with you, of where you have a fee schedule in there of $500,000 for each act for each person, and that it increases if it's continued to the courtroom of $1 million per act per event, and that is enacted and brought forward, or it's self-executing. You give them notification prior to once you get that stuff filed on a UCC, you give them a copy of it or notification that this is the terms and conditions that you're setting that you are to be left alone, and or they would be voluntarily self-executing upon them approaching your vehicle.
I think if you do that, I like the idea. I don't know if the sorry.
Yeah, you give them a copy of the indenture, Chris?
Well, what I did for the state of California is I terminated agency, and I gave them. I did it under cause. You don't have to give them any reasons why you're terminating them as an agency, but I went into the rights to travel issue, and then I sent them a fee schedule that went with that. That if it was self-executing, that any time that they wanted to approach me, I was more than happy to cooperate. That I was a non-combatant civilian, and that I would not put up a fuss. I would, extend myself to sign and do all that crap that I don't believe in. But the thing is that sealed the deal of the contract, of where that's a $500,000 infraction on their behalf, of which it's, because it's self-executing, and they've had over a year now to respond or rebut it, and they failed to do so. So the stand is as fact. So therefore, if I am pulled over, by being pulled over is $500,000. If he wants to engage with asking me for my ID, that would be a trespass for ID. That's another $500,000. That's $1 million right there. By him writing me a citation or towing my vehicle, that's another $500,000 each. And
well, that's a good idea. I like that one. That's one of the one place where we're having a lot of problem is even though they still beat them in court and stuff, they're getting that vehicle towed. That's the only. And they're lying and they're doing all kinds of bad stuff, but it's still hard getting after them because the clock's ticking and the money's going up as it's being stuck in there, and we shouldn't be paying for that. But
the problem with that is that we have fought tooth and nail out here in California, and we've proved it in the courtroom that a contract between the tow company and the city is between those two parties. That does not give consent for the private party that the vehicle is being towed by. There is no contractual agreement between that and the tow company, so it's Grand Theft Auto.
That's a good argument. I like that.
Oh, you betcha it is. We won in court over that one.
How are you set up with the license and the registration of the vehicle?
Well, I went through Swift Arrow at the United Nations of Turtle Island, and I have an international driver's license. After terminating the agency, I gave them notification of my new driver's license under international law, and that I no longer considered myself a resident. I am a domiciled here in California, but I do not conduct any kind of commercial considerations for them to have any jurisdiction. And because we got this new postal zone set up for United Nations of Turtle Island, we are completely exempt and not having to go through the postal zone of the United States of America at all. So therefore, we're completely sovereign, separate from the United States, conducting our own commercial value. And then on top of that, Executive Order 13175 was an expression by the President that says that the United Nations of Turtle Island and all other Indian tribal nations has the power and are acknowledged as being able to self-govern themselves in any capacity at any level, of which gave us carte blanche to go ahead and issue out passports on top of the driver's licenses and registrations.
Wow. So that's Turtle Island covers the whole North America, doesn't it?
No, it's all the way down to the tip of South America. We got a postal zone from the very tip of Canada all the way down to the southern part of South America. We have one postal zone for all the Indian tribal nations.
Okay, and so that was your license. And as far as did you deregister the vehicle? Or
it's registered on the United Nations of Turtle Island.
So
and we gave notice.
We gave notice. You just did a notice to the driver's license office about the removal of the registration, or got them to sign something, or?
No, what we did is we gave them official notification that this vehicle is exempt from their jurisdiction, and it's been placed under the United Nations of Turtle Island. Thereafter, they are not to interface with that. It would be a trespass on another postal zone.
Oh, okay, that's cool. Say, could I get that documentation off of you? I'm looking at some guys over here that have a Indian Nation thing going, and I was thinking of joining it. And they have been making reference to Turtle Island too.
Yeah,
so
go to United Nations of Turtle Island. All that information's over there.
So you got all this in Word doc format, I imagine?
A lot of it's just in my head. I know that all these applications and documents and the executive orders. We won one case where a guy had his vehicle towed up in Canada. We won the case. It was $1.6 billion lawsuit, and we won the whole $1.6 billion for unlawful tow.
All right.
So
you must have some kind of documentation to show when they pull you over.
Well, Swift Arrow is right there by Washington, D.C. He has been working with them to give them official notification, and the fact is they even had a lawsuit against United Nations of Turtle Island using the Department of Motor Vehicle. That is not a copyright under the United Nations of Turtle Island, and he won his suit on that one too. So he can actually name it the DMV of the United Nations of Turtle Island. So no, we're winning hands down on these filthy people running the United States of America, and they can't do anything about it because the United Nations of Turtle Island under the treaties can self-govern themselves.
Was that 1.6 million or 1.6 billion?
Billion. B. 1.6 billion. Now, Swift Arrow didn't get all that money, but the United Nations of Turtle Island got 10%. But that he said that he was going to post that over there on the site for everybody to view, and that was just last week that I talked to him. So he's probably posted that over on the site right now. You can actually view the case. But he said he was going to post all the cases that we've won. He says it's hands down, every one of the cases that we have a problem with is setting precedents that once you take these cases, you print them out and put in your car, and you give notification to the police officer, you'd be left alone. And if he fails to do so, then he can be prosecuted for trespass on another postal zone. So postal zone actually supersedes all other law as far as it goes for encroachments, trespass, without using easements like what Keith Levingway was talking about.
And I think it really applies or connects. It is a trust, really.
Yeah, and you know that whole boundary thing you were talking about tonight, and right. Easement, that's the ticket right there. If you don't get permission for a person to use your name, it's a trespass. And you can use it as a trust res. Say, I'm going to grant you limited usury as trust res, execute using my name to what do you call it, extinguish, merge the titles and extinguish this trust. So, I'm catching on really well, and I'm integrating all these other groups and what they're doing. I'm integrating everything together in my head along with what you're doing, and it's fitting perfectly. I see how trust works. It's perfect. I mean, for what we have to deal with, it's perfect. You can manage this. You can win.
Christian, what Chris just described with about not giving or giving limited use, could you just go ahead and make the claim on the record in court and not even need to do a 1 and a 3? Because that's my intent.
Yeah, if you had a court of record, that you could get a record.
Okay, if you had a court
I would
record.
walk in there with it already being transferred and
or the record thereof.
Yeah.
Yeah, I agree with Christian on that, because if you have the Secretary of State doing a UCC 1 and a 3, you can actually give notice to the county, of which there's nothing they can do about it. You actually merge the titles, and the judge has no discretionary measures to deny it.
Well, yeah, because you got the records.
Yeah, it's on public record.
Well, then the simple solution here is just to go ahead and create the records and then go into court with and then go to the clerks or the records keeper beforehand and go ahead and get a certified copy back out. There's my 2 public witnesses right there and bring a protective order.
You betcha. And anytime you put it in the Postal Service, that's another public public witness. So you have the notary, the post office, and the Secretary of State. Then you give notice to the county. You give notice to the judge. That's 5 different public witnesses that have the same trust res and the merger of the title.
No, that sounds like a good experiment.
I'll be putting it to work on Wednesday. If anybody wants to get together with me and help me write my protective order tomorrow, I'd love to have the help.
How would you do that right now, in a nutshell? Write a protective order. What would you say on it? Something like...
Well, I have lots of... I've compiled quite a file of stuff that we would need to go through. Are you free tomorrow? Do you want to do it with me, Shane?
Sure, if you want. I could try something like that. I don't know what to begin with, though, because...
I'll send you a bunch of stuff tonight to get you started.
Okay.
I got some great examples.
Want to keep it real simple, right?
Yep. Yeah, but there's certain elements we have to have in there.
Oh, yeah? Okay.
I'll help you out with that if you want to take me on.
Who's speaking?
Paul Roll.
Paul, please, are you one of my contacts on Skype? What's your Skype name, Paul?
I have a Skype account, and I haven't used it for a long time. I can get that rocking and rolling again.
Yeah, please, because I don't want you to give your phone number out on the call, because a lot of people will hear it. If you'll just go ahead and find me on Skype at Imagine the One, the numerical number 1, then I'd love to have your help. We can have a conference on this tomorrow.
Imagine the One?
Yeah.
3 words?
It's one word. All one word. Yeah, you just look. You can find if you just research on Skype, you'll find it.
Yep, I will.
When do you have to have this done, Bill?
This is Eric, and I got to go to court on Wednesday.
Oh, this is Eric. Oh, okay.
So I'm going to go ahead and do my UCC1 in Washington. By everybody, we want to do that in the state of Washington because it's the international filing destination. And then I guess I got to get them to email it to me because that's considered a certified copy because there's a time and date stamp on there. And then I'll go ahead and file that into the case the morning of the hearing, and then I'll get the copy of that back out, and then I'll have 2 witnesses, and I'll bring that into court.
You said the state of Washington, not Washington, D.C., right?
Yeah, the state of.
Yeah, is it expensive as Kentucky?
It's about, I think it's either it's $5, $10, or $11, one or the other. It's not terribly expensive, but I'm specifically doing it there because that's the international destination.
Hey, Christian.
Yeah.
Guess who we're having coming to our special group tomorrow, our regular group?
Dorothy.
No, we have a CEO of a national bank that's going to do a full disclosure of the mortgage industry and how it works.
Didn't you have a meeting with one before? Same fellow?
He had a conflict with his schedules, and so he had to cancel. But I got a conference this afternoon that he scheduled, and he will be there tomorrow. And then I met a gal over there at the Tim Turner event, which is the perfect fit for the rest of it. She has worked the last 20-some-odd years at a title company, and she says that she's more than happy to come and give a disclosure of how the title companies works with escrow companies and how that whole process works. So we're quite blessed with particular individuals that are willing to come forward to get us educated and maybe even give us a helping hand with some of our reconveyances and assignment papers that we've been creating recently.
Yeah, get some names and numbers there. Yeah.
You betcha. Well, the gal that was at the Tim Turner event, she said, "Oh, Chris, anything you want. You want me to help you with closing some of these conveyances and assignments?" Says, "I know the connections that we can have an easy breeze for this stuff to happen." I says, "Wow." So we're very lucky that we're finally having people show up like this, good quality people that know what they're, that's their professional field.
Is that going to be in the talk show, Chris?
No, that's just our local regular group. We usually have about 10, 15 people that show up. And we are very, very close to having a perfected, guaranteed way of saving people's homes every time. There's no wishy-washy. The documents are so cutting edge that there's nothing like them on the open market. And I'm very, very proud that I was invited into the inner group of this activity, because these are some of the people that are behind the scenes that nobody knows, that are putting the documents together, and very impressive. I'm very, very proud with where I'm moving. But I still believe that, Christian, this I'm teaching them the trust stuff, Christian. That's why it's important. That's why they brought me in, is to teach them the trust stuff that I'm learning here.
Right.
You betcha. I told you that, that I would become a teacher for California. I meant it. It's kind of caught me by surprise. I haven't had any of the through courses yet, but I pick up things. You know how I am. I pick up things very quick. So I'm ready and rocking and rolling. Tomorrow I've got to do my own presentation with the trust stuff.
Have you seen that new case?
How do you tell those brains in your head?
Sorry?
What? Just kidding.
What did you say, Christian?
Have you seen that new case out from Mears in Tennessee?
Yes. Yes, I have.
What's the background on the case?
Mears was sued by all the counties of Tennessee through a relator in I guess it was a qui tam action against a group of mortgages. Mears was the main one, and they were hit with all the legal filings that they have been doing, that they were doing it intentionally and willfully against for bypassing the filing fees.
Yeah, see, that happened on
the $2.5 billion savings.
Mm-hmm. Well, not only that, but the state and the counties didn't have any idea who were the holders of the note.
Much worse than that.
Hey, there's Jacob. Hey, what's going on, brother?
Well, quite a bit. They not only did all the things you guys are talking about, but the worst thing that they did was that the pooling agreements that call for cutoff dates, they missed them because the loans that they were pulling from companies that were going out of business weren't there to finish off their commitments. So there's about 6 or 7 attorneys firms that they shuffled everything to in the United States, and they made up all false chain of assignments. That's what's going on. So I happen to get a copy of all signatures myself. So you can compare.
Business practice. They call a Mears scheme. The Mears scheme.
Yeah, Mears scheme. That's right.
Smells like a butt roast.
Christian?
Yeah, Jacob, go ahead.
I haven't been on the call. I've had to do some other things, and I don't know where you guys are at, but I was on a little bit earlier, and everyone was talking about, who they are in relationship to a trust and how, you're supposed to navigate in public in relationship to a trust so that we have some sort of protection, and everybody thinks that they got to go do a bunch of paperwork and this and that. And I was just wondering if you guys might want to hear somebody that knows how to do it without paperwork.
Sure,
well,
absolutely.
I've been kind of toying with that idea in the past, and, really, I don't think you need all this paperwork.
You want to hear somebody going into court and doing it without paperwork?
Yeah, go ahead.
He and I, we've recorded something for you guys to listen to. Okay?
Go ahead.
Okay, so the trust, right? So would it be very wise?
Can you hear?
Kind of muffled.
Hold on. Let me put the microphone next to the speaker. Hold on. See if this is better.
You to go in and walk into the insurance company to effect some insurance on a trust, and they say, oh, that's all great, no problem. And what we're going to need from you, sir, is driver's license. We're going to need to know who the beneficiaries are going to be driving this vehicle, and we're going to need their driver's license number. Now, that doesn't seem very wise to me. I don't have a driver's license. So wouldn't it be easier to go affect an agent on behalf of the trust, and the agent who does have driver's license goes in and inspects the trust, the insurance policy in his name, so in that specific trust name, using the driver's license, and in the name of the private trust, in both names, and then private document, the man then assigns beneficial interest over to the trust total. He's out of the picture. It's just in name only, holding insurance on behalf of the trust, but all the beneficial interest is assigned out behind the scenes. That's an excellent point. Thank you very much.
Can you hear it all?
No, not too well, no. Can't make heads or tails out of my end.
That's the recording with Michael Joseph and Gary. Right. It's on the ForShare website. It's about 5 hours long. Excellent information.
Christian, did you hear what he was doing with the driver's license?
No, I couldn't make out what he was saying. No.
Okay, I'll tell you what. I'll transcript it for the next call and be able to speak it.
Sorry, did somebody say where you could get that on ForShare?
It's not there.
Yeah, dig it in ForShare,
is under the title of Michael Joseph.
Where at? Have you seen it?
In ForShare, I think Christian, remember, I Googled Christian Walters' name, and it came out there with ForShare. And there's a list of posts there that where I access the information. I have it taped in my my little iPod.
Michael, what's your last name?
Michael Joseph is the young fellow. It's a fellow that's about 40 years old, a very, very sharp guy. And the other gentleman is Gary, and Gary is an elderly man that was ex-military, retired. That's very, very heavy into this for like many, many years. A ton of research and so many different things. But they had a very, very good conversation. It was about 5 hours long. I've listened to it about 2 or 3 times. Very good information. And it talks about the certificate trust. It talks about the driving privileges. It talks about trust. Talks about biblical research. A lot of stuff. But it's very good information. But I don't know. I think it's
without paperwork.
I'm sorry.
I think Jacob was saying that they were doing it without paperwork.
Right.
I don't know if it was done without paperwork, but I know that this gentleman, Gary, they were to go in the court and talk to the judge in a way that they really admire, respect him, his wisdom and knowledge. They leave him alone. They don't even mess with him. Same thing with Michael Joseph.
That's because they're sent here. But, Jacob, if you could come and just give us a brief synopsis about how they're doing this without paperwork, that would be great for all of us, I think.
Yeah, I'll prepare that. I'd rather not do it off the cuff. I'd rather be accurate, you know.
Okay. Well, they're expressing the trust orally or in court then?
Yeah, not just in court. I mean, even at the DMV. With the story of the DMV is phenomenal. He actually brings the Attorney General in, and they actually approve an agent trustee signing his driver's license.
Jacob, who is that actually speaking on that recording there?
You just said
Michael Joseph and Gary. I don't know his last name. Gary.
Guys, if you could let Jacob answer, you might have a reference, but it might be somebody else if Jacob has an idea.
Yeah, you know, to tell you the truth, you know, that gentleman, I mean, he has a name for this person. He doesn't really know who he's what's your name that was talking about the whatever you said?
This is Al in Miami.
Oh, okay. Do you have verification that that's the person's name that you're talking about?
Yeah, I have a recorder. I've listened to it 2 or 3 times. I mean, it's about 4 or 5 hours long, the thing.
Yeah, do you have verification
for my name, and you pop up my ForShare site that all of my audios are up on? It's on that site.
You see, it says Michael Joseph. That's the title of the recording. It'll be about 4 or 5 hours. 5 hours and 40 minutes, I think.
Okay.
Michael Joseph. Jacob,
well,
did you say?
You know, the thing is that I think that this particular entity, this guy. There's actually another guy that I'm starting to work with that's actually the mentor of that guy, okay? And so I'm just going to try to work up something that those guys are using that this gentleman, Alan, actually heard as well, and I'll try to transcribe it for us so that we get an idea. We could at least get the driver's license and the insurance and the court case for a traffic ticket, and we can get all that down. All the language.
So, Jacob, you said you signed it as the trustee, the driver's license?
No. He actually he doesn't sign nothing.
You said that somebody came in and approved of it?
Huh?
You said somebody came in and approved of how he signed or something?
Well, no, he has a trustee's agent. I was trying to tell you guys that the other day. I thought about that, how to do that myself. I could never figure it out, and then finally I got with these guys, and they showed me how they were doing it.
A contract as trustee, say, with another agent, and then he has the power to sign for you.
Well,
and that's a Form 56. You could do a Form 50.
Anyways, let me transcribe it so we have a more clear picture, and we can discuss it intelligently.
Thank you, Jacob.
Yeah.
Sounds good. If you can get access to those guys' mentors, you're hitting in the right location, because those two guys are very sharp. They're very high level in this knowledge that we're seeking.
Yeah.
I listened to it 3 times, and I couldn't get. It was very, very exciting stuff.
Are they specifically?
It's hard to understand it. These guys are using Hebrew law.
Yes. Yes.
So it's going to be very hard for you.
Based on the Old Testament, right? Based on the Old Testament, because the New Testament's been
altered. At the back of your hand, it's going to be really hard for you to decipher what they're talking about, because they go through all the trusts in Old Hebrew ancient law, and they apply every trust secret in ancient Hebrew law to what they're doing. It's amazing.
So wait a minute. Are they specifically saying that they're coming from trust, or are they just specifically saying they're coming from the first 5 books of the Bible there?
No, they're coming from way beyond the Bible, Shane. They're coming from knowledge from above.
Right.
That's where we want to go. I'll transcribe it, and you guys will be able to hear clearly. I know that Christian's got a good background in the Word, so he should understand where they're coming from, and I think it will be very beneficial for us all to see, how they don't comport to the United States. They comport to the law from above, and they have it down to a science. It's amazing.
Yeah, that's where we make our mistakes. We don't come in and express a trust and get them to argue our trust. We fall in and we do the debtor-creditor thing and get to argue their debtor-creditor thing.
Yeah, or a combination or whatever. Anyways, Christian, I will transcribe it for us, those 3 areas that I promised, and I'll get that ready, and then we'll be able to really get it out on the table so we can get your incredible viewpoint of, the Hebraic side of applying, using that as a possibility for, to take a stance from the Word of Yahweh, as opposed to
Unmuted.
United States documents, because these guys go way back. They go to the very beginning of the trust, and then they start expressing it, and they use, they really did a lot of study, decades of study on the trusts that are in the Word. And so what they did is they took those trusts in the Word and they kind of, picked them apart, and then they started applying them to daily application.
Right.
Chris, this is Terry. I just posted that search on ForShared that has it linked for that Michael Joseph MP3 file. People can go and download it for themselves.
Where do you put it?
On a Trust on Topics chat in Skype.
Thank you, Mike. Or thank you, Terry.
You're welcome.
I mean, those guys went into some topics saying that Hitler died at the age of 100 and something. He didn't die according to history.
In South America?
I think here in the States. And the other guy that was one of the people doing experimentation on the Jews. I mean, one of these guys was working with DNA technology at that time. He's still alive. He's like 95, and he looks like he's 70. Wanna be
Angela.
Yeah, that's it.
Yeah. It's incredible. A lot of stuff, a lot of heavy stuff that you never hear. I've never heard it before. It's a fascinating recording. It expands your horizons mentally, at least, for sure. One of the things I remember is that when a policeman stops any of these gentlemen, especially Gary, the elderly man, ex-military, says, have your supervisor, put your supervisor on the phone, or have your supervisor come, and then he'll tell you what to do. And I guess slaps him right off at the knees right there. But the guy said he read about half a warehouse of books. the ex-military.
Muted.
Is very heavy, very, very knowledgeable. So I don't know. And he's got like a photographic memory. This guy can quote. I mean, like Christian can quote UCC rules and all kinds of stuff. And where he sticks it all, But this guy's in the same same level of knowing the stuff cold. Really, really fascinating.
So, Christian, you fundamentally believe then that you can essentially go into court or in certain jurisdictions or whatever and express this kind of trust. I mean, I think there is some reference to it in Lewin's, not necessarily with doing the UCC 1 and 3, that there might just be a way how you stand and how you communicate.
Yeah, I think it's all done by the terminology. Yeah.
Yeah.
Like I think you were telling me about I was went into court and or maybe it was somebody else.
Which one? What's the story?
They stood before the judge and they had some kind of secret code. They communicated back and forth a little bit, and then they laughed, and then the guy left.
No, that was me.
Yeah, there was this Masonic communication back and forth with some verbiage or something, and then it was all done.
Huh. Yeah, that'd be a good recording.
So he came in and he tried to do some trust things, and I believe it was he used some verbiage and expressed trust a little bit. Actually, he said that the fellow was verbally shaken, the judge, took off his glasses and stared at him for about 30 seconds, not saying anything. And then it was in a bankruptcy case. He said that after the 30 seconds, he says, well, I'm going to lift the stay. So it looked to me like he was waiting for the comeback for the fellow to respond and really make the proof of the expression of the trust, but he never did. So he went ahead and lifted the stay off the bankruptcy.
They were moving his stay. That's a bad thing, right?
Yeah, and all he did was he just orally expressed some terminologies that he learned, from listening to the show.
Christian?
Yeah.
So one thing I like about this guy the most is, he'll have a trust that has a trust, and that trust is a trustee, and then he gets trustee's agent to be that trustee when he's the trustee. So he never signs anything. He has the trustee's agent sign for him as the trustee of the trust. He never has to swear. Very smart guy.
Well, I believe what Carlos was saying, that really you can have the trust material anytime you want, because it's not public, and it can be changed around to his liking.
Well, I'll tell you guys one thing that might be very interesting that I figured out. And when you convey and grant the property into a trust, Carlos, are you there? Is Carlos on the line?
Usually it takes a moment to come on if he is, Jacob.
Yes. Okay. Carlos?
Yes.
When you conveyed your properties into a trust, were you able to take the homeowner's title insurance with you?
Well, what you should just convey, you just doing like quit claims. You take everything under, because by law, the 1983 St. Gordon Germain Act, you're in Congress says you're allowed to convey your property into a trust and into a trust for asset protection or for your own protection. It's a law.
That's right.
That's it.
Yeah.
So
basically going back to the same.
But have you gotten, Carlos? Have you gotten title insurance on your whatever deed you're using when you do that? On your grant deed, have you gotten title insurance?
No, I have title insurance. You don't mess around with it because you just convey it into an interviewable trust. Don't move anything. Why would I worry about title insurance? Because when I bought that property, I got clear title insurance. Why should I worry about title insurance? Because nobody has screwed around with my title. See my point?
Well, but your title insurance that you originally bought covers that, doesn't it?
Yeah, but I'm the only one tampering with title. So don't worry about it. Don't make things hard.
Yeah, but who's actually buying title insurance and who's the one who's really the issuer behind it?
No. Forget about that.
You put your signature on the title insurance. Aren't you thinking you're buying it, but really you're the one that's granting it?
No. Jake is bringing up title insurance. I don't even screw around with title insurance. Jake is, he's bringing it up. He's making things harder.
Yeah, I know.
Why worry about title insurance? Because you're the one who's screwing up with the title. I mean, what title insurance do you need?
Listen carefully. If you get title insurance, you re-bring the asset back up to its value to use as an asset for trading. You're on your own.
Well, I mean, to each its own, right?
Yeah.
But you know what? My method has been working.
You're enhancing the value of the property. You're making a guarantee on it.
Exactly.
Which is securitization. But again, this is all debtor-creditor stuff.
Well,
you can write your own insurance because you're the one guaranteeing it all anyway.
You can do what? Your own insurance?
You can issue your own insurance. You can do your own underwriting because you're the one that's granting it all anyway. That was my point. I don't need to buy title insurance. I need to issue title insurance.
Could you do that?
I was trying to think about how you could have it acquire a value.
I think we need to get out of the mentality that we need to acquire value. We need to issue value.
Issue value.
Yes, we need to grant it. We're the only ones who grant any substance to anything. We're granting value to everything.
Christian, when you convey your own property into a trust, it's just a basic trust. You're conveying whatever is worth in it. You don't have to. I don't screw around with anything else. It's only to keep it out of the everybody's eyes, in order to keep it away from anybody else putting a lien on my property, in order to keep it away from my neighbor. That's all.
Yeah, you're not commingling your property. You're keeping it private.
Yeah, it's just I'm just playing with trust. I'm just going in my trust law. Within the trust law, I'm not commingling anything. I convey my property into a trust and I leave it there. I don't screw around with anything else. I'm just keeping it away from everybody else's reach and eyes.
Well, Carlos, what if there's an obligation against it?
What about it? You're gonna keep paying as long as you keep paying the bank. The bank will never bother you. The bank will bother you when you stop paying. But as I was telling Eric the other day, if you stop paying, and the bank's going to go after the debtor that is not paying, but that property now belongs to another trust which has 10 different beneficiaries and an LLC as a trustee if you want, or another trust as a trustee, and behind that there's an LLC, and you're just keeping it away from the bank. I mean, there's nothing against it. I mean, the bank's going to try to get it.
What my thought was is that if you can figure out a way to have a value on it, and you can
Jacob, you can probably do a lot of stuff, but I don't like to make my life harder than it is. I mean,
yeah, but I'm talking about getting rid of the obligation.
Oh well,
making it easier.
Yeah. Well, merge the title and get rid of the obligation.
Huh?
I signed the bank as a trustee and merge the title. That's it. You're gonna get rid of the obligation.
I'm talking about enforcement.
Well,
without having to go to court.
Not having to go to court.
Right.
Well, when you convey your property into a land trust, you're just granting it. I hereby grant to this such and such trust. Yes, it's like we're claiming it to you.
If you go to the bank and you have the money to pay your loan off, and you tell the bank, hey, look, I want to pay the note off. Here's all the things I need to pay the note. Can you please provide them so I can pay it? Well, if you can show proof of funds to pay it off, and then they can't belly up to the table and show the credentials and identification to be able to sell it, then they're going to get washed right out of court.
Yeah, I know. That's what I'm doing with my home. That's what I did. I told the bank, I have my dad is wiring me the money from Mexico. As soon as they bring me all this stuff, I promise I'll have the money wired from Mexico, my dad's account from Mexico, into this account, as long as I get to see all the documents. I'm gonna do.
But say I have 100 families that need help. How am I going to show the bank I have the money for 100 families? That's going to be whatever.
You only have to show one in one trust.
Right. So the thing is that if you can put insurance on the grant deed when you put it into the trust, you can create an issue like Christian said. You can issue the value to show that you have the money for each home to help each person.
I understand. I think we spoke about this the other day.
No, we did.
Okay. How I would do it, I would set up a business trust with $500,000 in there, or $1 million, right? That business trust is going to concentrate in 1,001 property. They don't have to know I'm working with 1,000 properties. That's my point.
Yeah, but if you're going to a bank, if I'm going to one bank and I have 100 notes.
The same bank, yes, of course.
And they're going to know.
Hold it, guys.
One by one.
If you want to make a payment, I don't want to make a payment. I want to do an extinguishment of the debt under trust.
Right.
Yeah, but you want to pretend you're making a payment so you can get them to come up to the table with the paperwork instead of having to do it in court.
I don't need to have them come up to the paperwork with the stuff. All I got to do is ask for the surrender, or demand the surrender of the note back.
And if they don't do it, you're going into court on a breach of trust?
Yeah.
Well, I don't want to go into court. I'd rather just have the money and say, hey, look, I'm going to pay it off. Give me the note, and I'll pay it.
Did you read the IRS strict foreclosure?
Not yet. I got to do that. Sorry. I'm making enough note.
Did you review the strict foreclosure under UCC 9-620 through 23?
20 to 23, got it.
I think he means no.
I'll do it tomorrow.
You don't want to go through court? I think you got to be reading those.
Christian,
okay, IRS goes on you and take your property without going to court. Non-judicial states, don't they take your property by not going to court? How are they doing it? They're doing the foreclosure the same way the IRS does.
Christian, if you put it into a trust, it doesn't even matter. A quit claim, grant claim, it doesn't even matter. If you put it in a trust, they can't get you. Especially when you listen to things.
For asset protection, they're using a device as a trust for that. I'm more for using the trust as an offensive device. Make the simple contract extinct and merge it into the higher security, which is the trust. It's a security. You're doing securitization. This merger definition out of Black's Law is the same thing that they've done in the past with securitization. Same thing. Exact same thing. They've taken a simple contract and they've merged it into the higher security. They did securitization. That's what securitization is. They merged it in with the deed. And what's the deed? The deed of trust. That's the trust. And what is a deed? It's just a recorded affidavit of an act. What's the act? The formation of a trust.
Yeah, but Christian, the bank has covered their behind from the get-go. They've got lenders' titles insurance. They got lenders' title insurance.
Yeah, the homeowner is under debtor creditor to keep you off track from hiding the real fact that you're the one controlling it all. You got the purse strings in your fingertips. All you got to do is take out that blue pen and start making some indentures.
Okay.
Too much confusion. Too difficult. Too much paperwork. Too much hassles. That's the confusion. We don't need 63 million laws.
But Christian.
I like the 10 Commandments that God gave us. I think I'll go by that and that alone.
I know, but listen. I figured out a way where I can get hook, line, and sinker, where I can actually get proof of the broken chain of assignment and chain of title. And I can have it certified by securities attorneys, mortgage fraud attorneys, the whole shot. So when I go in there and give them trust res and they breach the trust, I want to have some enforcement. I'm going to say, hey, look, let me just show you one of your forged documents, and I have 20 of them. And if you want to go into court with these, be my guest. But I'd strongly suggest you negotiate out right now, and let's talk about doing your fiduciary duty by the order that you were given to apply the trust res and extinguish the debt, extinguish the obligation.
Mm-hmm. So this is the proof of the chain of titles that they don't have it, or it's broken chain of titles between the originator and the trustee in the pool?
All of them. From the very beginning to the very end, I have a way now to get the broken chain of a title and the broken chain of assignments, and I have a way to get all the forms that are missing. I have a way to get all the forms that were forged because there's about 7 attorneys firms that forge most of the chain of assignments that the banks that do pretend that they have them. They're 99% forged, even if they say they have them. So if you have those signatures on, that prove forgery for the ones they forged, and you have the broken parts of the pieces of what they didn't do according to the rules, then you basically got these guys I know. They're winning every case, and they're just in the public. But I mean, they're not doing trust, but they've got this other area that I've gone into doing a deal with them, and
strict litigation, which will keep on.
They're using it for litigation.
Yeah,
I wouldn't use it for litigation. I would use it for enforcement.
Well, yeah, you could also use it for just a setup and forget about doing the trust.
If you wanted to, that's what the regular guys are doing. But they're only getting 30 to 50% off.
30 to 50% off of what?
The obligation. They're just writing it off, 30 to 50%.
And what are they doing with the 30 to 50%?
They pocket it.
What about damages?
They're not going after that. They're just getting 30 to 50%. I'm just saying that from a public standpoint, with that kind of ammo, you can get 30, 50%. With the trust, what we're doing, if we use the broken chain of title where we have it certified, we should be able to get the damages. We should be able to get the whole thing.
These guys are only 30 to 50% off of the value?
They get 30% to 50% off the note value, yeah.
And then the party has to still pay the rest, the remainder?
Yeah, the party pays the rest, right.
That ain't no deal.
I know. I didn't say it was a deal.
And these guys don't have they broke the law in securitization, and they don't have the notes, and they don't have the proof?
No, they got the proof. They got the proof that the bank doesn't have the notes.
Well, this kind of ties in with the thing I was bringing up in this thing about the mirrors in the Tennessee.
Right.
Because this was the real fact behind all this is really the banks have split the note and the security agreement and have absolutely no right to foreclose.
Yeah, but when you have a certified proof of it, you're sitting in the driver's seat.
Yeah. Now that. Why would I hang out just for 30 to 50% off if I had that kind of information?
Oh, I know. Believe me, that isn't going to be me. That's them. But just the fact that you can get that kind of evidence, that's what we need. That's the man. I mean, you can
that kind
become
of
a lot more powerful.
It's really blatant. It's got nobody went in and dug it out.
Huh?
That's what that Kansas City case was trying to point out when that judge was saying, hey, that Mears no longer has standing to do anything, and anybody like Mears, really. And that's because the note and the security agreement have been split. And that's what happens.
Not only that, the more important thing is the judge, if you guys will check it out, they don't have securities licenses. They have no business saying that a copy of a note is a note. You need to have a securities license to do that. These judges do. Hello? Anybody there?
Hello?
Did we get cut off?
Hello?
Yeah. Did everybody get cut off?
Nope. Anybody coming?
Unmuted.
Everybody cut off?
Chris, I think
No,
everybody's
we're just
tired of you
odd
talking
looking.
over them.
Christian, are you there? CW, 10-4. Anybody on?
Yep. Is that you, Chris or Jacob?
Yeah. This is Chris.
Oh, okay.
Muted.
And is that you there, Pete?
It is. Is this Eric or is it Shane?
Yeah, it's me, Shane. How's it going?
Hey, Shane. I think from the sounds of it, I think Christine got a bit pissed off and left.
Oh, you think so? No, I don't think that's Christian. He's got kind of a patience to him.
Yeah, I think from what it sounded to me, Jacob kept talking over everything he said.
Yeah, I couldn't actually hear what he did say.
I've only been on about half an hour, then it's just constant. I don't know if you recognise that, Jacob, but you tend to be a little bit too rude. Very excitable.
Were you guys cut off also?
No?
No, I wasn't. I was just typing.
I was bumped,
lost,
but I couldn't get in. It wouldn't even ring.
I just lost focus.
Is Christian still on there?
No, I think he got one.
If you had trouble getting in, maybe he did too, maybe.
But everybody got cut off at the same time?
You know, what happens, I think, guys, is apart from just protocol, I think when two people are talking at the same time, or more than two people, I think it confuses because they're still separate channels, and it creates some kind of a processing. You notice that when people talk, it sometimes blanks out?
Yeah, it can't handle the data coming in or something, yeah.
Exactly, because it's the nature of TCP/IP. Everything's in packets, so we're sending all packets from different directions. It's still a complex process, what we're doing, as amazing as it is. So just on a practical, technical point of view, we should try to avoid talking at the same time as much as possible. Kind of treat it like walkie-talkies, right?
Mm-hmm. Especially when Christian talks, he has a funny way of talking in that he pauses and thinks, and people find it difficult to speak with him in that respect, like, because you think he's finished, and then you go to, and then he'll start, and you're like, shit, and then you miss what he said.
Well, we should give him the most space, though. Yeah.
Yeah, it's because it's such vital information what he's talking about.
And he'll always get on a roll.
I'm back on.
Hi, Christian.
You got cut off too, Christian?
Yeah.
We thought you got pissed with getting interrupted all the time.
No, I'll just push the magic button and let everybody shut up.
There you go.
So, Pete, how are you doing?
I slept in. I set my alarm for 2:30 a.m. and I woke up at 1:56 or something. Slept through the alarm and then woke up and it was like 5:30.
A good nap.
What?
A good nap.
I just missed the call though. I was listening to some interview on YouTube yesterday about Jordan Maxwell going in on his angle of things. Really interesting. It's an interview on Project Camelot on YouTube, 3-hour interview, and he's talking about all his delving into the occult and everything. Really good.
He's interesting.
Yeah. But one thing I wanted to run by you, Christian, is the charitable trust seems to be ringing round my head.
Public trust.
Public trusts. I mean, is a charitable trust doesn't have to be a public trust, does it?
No, it doesn't have to be. No, could be for a limited.
Sorry.
Could be for a limited amount of people.
For a limited amount of people.
A public trust is good for the whole body, so to speak.
I was just thinking of something. I used to know these people that run a telemarketing office, and they're originally selling an information booklet, and it was for raising funds for wheelchair athletes that come to Mississauga, Ontario, once a year kind of thing. And they touted it as a self-supporting organization raising funds, right? It was kind of gimmicky, but as it progressed on, one of the girls was getting really good, and she wanted to create a different, it was a really good model they had, let's just say that. she wants to create a different thing, selling sweatshirts for the homeless, okay? And she was from out east. She had some family that worked in federal government, and they were all honing in on trying to get a charitable license. And that was kind of the beginning of the end, because what happened was, as they started getting all these T-shirts, these sweatshirts out, and it was getting a lot of public attention, people started looking at it, and they just got themselves in all kinds of crap because they were taking a lot of them. There's a huge percentage of money that really goes back into the organization, right? And I was thinking, it's kind of funny, I was thinking about the trust thing, right? Because I guess what happened was when they took on that charitable license, there was some kind of trust issue. They're probably more liable, more obligated. Whereas when they were a private, self-supporting organization, there was no receipt. It was just for, a self-stated goal, mission. They never reached the target, and they gave people this book. This it was supposed to be like $2,000 worth of coupon, buy one get one free, 50% off, 2 for 1, this kind of thing. And everybody was more or less happy. It just sort of went under the radar. So I think there's like in other words, it's kind of pointed up to me in my mind that there's a lot more obligation going on when you get into charitable stuff.
As a public trust, you're going to be much more scrutinized. But I think where we're going to fall down is we're going to breach the trust. We're going to be doing the administration wrong. We're going to be administering the trust wrong, and we're going to hang ourselves. We're going to breach.
Do you think, Christian, a part of that making the mistake will be in I'm always feeling intuitively I'm going to screw it up with understanding what's private and what's public?
Well, that's interesting.
I would rather form the trust and stay out of the public realm. I don't need to do debt anymore. I don't need to do the public anymore. Don't need to do commerce.
Yeah. So, but just establishing that and talking about it, so you can only make reference to it, getting it. In other words, the focus for me is how do you get it established, and then after that, you're more or less just making reference to it and putting the onus on them that if they want to get more into it, to see me in private, that sort of setup, right?
Yeah, well, I think the clock is running backwards, and we think the running backwards of the clock is normal, and that normalcy is debtor-creditor or commerce. And here, trusts run the opposite direction, and that's the whole thing. That's where we should be. We should be in trust. We shouldn't even be doing commerce.
Do you think, too, that the part of being able to do this without too much documentation in how we act and behave, is part of it is presenting the birth certificate? I know that how you present it may be
the opposite section, which is going to be running the right way, all upright. You can interface into the public realm with no problems, and you merge in or meld in, and you are like nobody knows you from anything else. Although you're not doing commerce, so you're not connected back into the public realm, but yet you're still using the public realm under a use.
Actually, I wanted to ask something. Pete's there, right? You're in England, right?
Yep.
You've got a birth certificate, of course, right?
Got 2.
Okay. Does it say something on your birth certificate to the effect that this is not to be used as identification or something like that?
Yeah.
What exactly does it say?
Oh, I don't know.
If you could grab it, I'd really love to
I don't know where it is. I recently moved house, and
okay.
nothing's unpacked yet. But just similar, probably, as what everyone else's says, really.
Oh, we don't get that on ours.
Do you have 2, though? Do you have like a short one and a long one?
Yeah, a short one and long one, but nothing that ever says something to the effect, this is not to be used for, does it say personal identification or not to be used as identification?
As I say, I don't know the exact terminology.
Okay.
It might be on the internet.
I would love to get
that. And about the name. The name was one way of identifying a person, and then you're saying that the birth certificate is not used for identity.
Yeah. Isn't that crazy?
The birth certificate doesn't identify you. It identifies an account.
Yeah. This is what I'm getting at. Yeah. I'm getting at. This is one guy. Yeah. Like I'm trying to figure there's something going on there.
there's this colorful wording that's hiding the truth. And the truth is that we don't know the definition switch of the meanings of the words. So I need to go back into that boundary section and find out where that one other book was making reference to and see what else can be used other than a name to identify a person.
Well, isn't that cool, though, eh? Like, I mean, so I think Pete didn't realize, I don't have that in Canada. I know they don't have that in the States, to my understanding, either. But they have it on the British birth certificate, right on the back there. Because one of the guys was talking about it, and I think he also said he had a conversation with our Registrar General, and she confirmed again, and judges have confirmed it. And I got another conversation from another guy that this idea that it's not necessarily to be used for identification. Yet it says in the Vital Statistics Act that this can be used as evidence in a court of law. And then again, it just says, for the facts so certified.
Well, you probably have to check out all those definitions of those words first.
Sorry, you cut out there. What? I missed that.
You'd probably check out all those definitions, and then you probably see the connection.
As far, what, like identification?
Yeah, the definitions of those words that you used.
Well, in fact, so certified, that's self-evident. That just means they're not specifying. They're just saying you can use it as evidence. It's almost like what they're not saying, but I believe it obviously has to do with trust, obviously. But it just shows it's this, actually I guess it's not telling you what it's used for, but they're being roundabout and even saying what it's not to be used for. And also, if you use it for identification, the question becomes maybe that's, and again, I think it's pointing to that thing that we have the right not to be recognized by the name. Because I guess maybe that's a right of a beneficiary or something, right? But we don't always have to make that joinder. That's a complete entitlement, which we can waive at any point in time.
Unless we correct misconstruement.
Well, I guess we do that through the rebuttal of these presumptions. I'm getting kind of used to the idea that that's how they got things set up. It makes a lot of sense, too, because that's how a computer's set up, right? There's so many complex functions. They have to be set someplace, so they're all preset. And if you want to go in and change it, that's fine. You go in and change it. Right? I guess you got to know it's there first before you can find it and change it.
Yeah, right. Yeah.
So, yeah, it's kind of like it's almost hinting or suggesting, again, in that roundabout language, that there's other uses, or the fact that they're, in a way, they're kind of saying, yeah, you can make joinder, but then, like on the back of Pete's, it's saying this is not. They're actually being specific enough to say this is not to be used as identification, and that's.
I wonder why.
Yeah, exactly. I'm posing within this group, so I want everybody to.
Well, I think we just answered that earlier on the show today. The fact is that there's the name is one way of identifying the identity of a person. There are other ways, and if that's so, then this birth certificate, if it's not identifying a person, because that's what that was talking about, was identifying, ways of identifying, because the name was not the identifier of the person.
Well, you're saying...
It was the identity of the person.
Sorry, Christian. Now, when you're saying the identity of a person, like you're meaning the fictional person, but not to be used as identification for, say, a living soul.
Well, let me pull it out again. Let's see what it says.
Because we know that the person, of course, is just. It doesn't. I don't think it says on the back not to be used as identification of. It is an identification of the person in one sense. I guess the instruction would be for the user not to use it as identification, period. Or is that even the proper terminology now that you know that the person is making reference to some type of a trust legal fiction entity, trust entity, a trust account, is it even proper terminology to say this identifies a trust, or is this proof or evidence of the trust?
Trust certificate, trust receipt.
Yeah, as Sam Kennedy used to say, it's a certificate, a certificated. Hold on a second. He was being very definitional, and he said it's a security certificate of a
security. But it's really a certified piece of paper.
Yeah, it's a security certificate of a certified security.
That's all a certificate is, a certification.
Yeah, in this case, of a
like something certain.
Yeah, well, Sam likes playing with words, but it was definitional when you really went through it in your head. He's just saying a certificate of security of a certified forget it. I can't do it.
Well, we like playing with words too, and there's a lot of clues in the words. Certificate, certain, same root like.
So
I've never listened to some.
Definitions, section of the names. Section 2, definition. It says names are used merely as one method of identifying the identity of persons.
And persons in this case, as we know, is a legal.
Can be. It's not necessarily is.
That one's a footnoted. Identity of persons is footnoted. And it says, see corpus juris secundum, right of privacy and publicity, section 14. So that's private versus public, the use of the names and identifying the persons. But one method of identifying the person. That's just that's one method. That's just the name.
The name, exactly.
They are descriptive of persons for identification, since the identity is the essential thing. It's not the name, it's the identity. Since the identity is the essential thing, and when identity is certain, a variance in or misspelling of the name is immaterial. Description, however, is not the equivalent of a name. And then it made reference to boundaries as being the essential thing. The identity is the essential thing. That was making reference to boundaries.
Well, that's interesting. Winston used to say something about that, too, that the name was being used to separate, where one party begins and where another party ends type of thing. And I just wonder if that ties back into that story I was telling yesterday about the guy who said, when they asked him who he is, he said, I'm commonly known in the public by the name John Doe, blah, blah, blah.
And then he addressed him as John.
Yeah, and then the judge did that whole routine. Like he said, he was just being so nice to him and asking him if it was okay and all this stuff. And what the heck? Yeah, I know. That one was going to keep rumbling around in my head for a while.
But so now back to the birth certificate thing. It's not a identifier of a person, just like they say.
Well, it's not an identifier of a person?
Yes, it's not the name. The name on the birth certificate is not the identifier of the person.
But that is the person.
The name is not the essential thing. It's the identity that is the essential thing.
So what's it an identity of?
Identity is the essential thing. And identity comes back down to boundaries.
So we're establishing a boundary when we express or present this?
When we establish a boundary, we are establishing identity of the person.
Someone asked me, do you have any ID with you? And I said, fingerprint. And she went, okay.
That's a good one.
It's undeniable.
Or you can make a statement.
Well, I don't want to... Oh, yeah, you could. Yeah, you could make a statement. Yeah, you can carry that around with you without too much hassle.
So you're so-and-so of the family name so-and-so.
But the thing is that then you're getting kind of stuck up in words, but your fingerprints, who can deny that?
Yeah.
Numbers or symbols. A name may consist of a number.
Well, that's what we all are.
In court, they know who the person is, and in court, they know that the word name or person, they know. I know they know. I threw it at them. They all picked up on that, right down to the guy who was in the back counter. Who turned out to be some kind of a prosecutor, I guess some kid working there part-time or whatever. He knew about it, jumped all over me like, oh, yeah, people tried to do that before. It doesn't really work. And then I forget what he asked me, but I caught it right away, and I just deflected it right back, and his brows went up because he knew that he was trying to catch me just to show me how stupid I was.
Well, did you get out of him what the person is?
No, he wasn't doing that. He was just blowing me off like, yeah, you're not going to do it. It's not going to happen. Yeah, I've heard people try and do that kind of thing. And, famous last word, that's all. But just the fact that he knew about it. So he knew about it. And then, like I said, he made, I forget what it was. I wish I knew the question. He just sort of said something offhand. But I caught it right away as he was playing me right there. So I turned around, and I forget how I responded. But it stopped him. So he was really... So he might have even, I don't think they level with you all the time, right?
Well, think of the word person, and then think of what the account is, and then think of what a purse is. That's the purse where you keep the money, and that's where you put an account, where you put the money. And then they're putting the purse on you, and that's where they're drawing all the funds from.
Yeah, but
I think a person has the persona, going back to the Roman, and I know this guy, he does like a 600-page slide thing. He's all nuts about the person, Kevin Lindsay, and I've kind of gone with him when he's done his library research and stuff. And it has a lot of different but it's a combination of an entity and a physical man, and who's got...
So where they're drawing the money from?
Who's got certain capacities. Who's got certain capacities.
Could you just let Christian speak there, Shane, please?
Do you have a right to use? That's Section 3.
Do you have a right to use?
Yes, that's Section 3. Right to use.
Well, you're entitled to be recognized by the name.
An individual is entitled to use his or her own name in any legitimate way, but generally, in the absence of statute conferring such right, one has no exclusive right to its use unless a question of trade or business purpose or special injury to character, repudiation, or property is involved. So, Your Honor, is this being used in a business sense?
Yep.
So wait a minute. Backtrack there. You can use it under... They're saying when you can use it, or when is it appropriate to use it? I missed that. Sorry.
Right to use.
So right to use what?
Yeah, do you have a right to use my name?
And they do outside of statute, which is non-business-like, and then when they come into business, now we're talking business.
Yep.
So you're saying that one of the first things we should do is differentiate between whether they want to use it publicly or privately?
Well, now let's take the right to use. Let's just take the word use.
Right.
Now it's trust.
Yeah, absolutely.
So unless a question of trade or business purpose or special injury to character, repudiation, or property is involved.
What does repudiation mean? Sorry.
Repudiate, taking away, lessening.
Okay, thanks. Yeah, got it.
So we're building up to something here. You're saying such as a ticket, or the whole court scene. They want some money, right? They want to do some business. They're dragging you in. They're asking, as soon as you show up, they're asking for your name, right, or the name that you have registered and use of, that you have use of, right? You have it as well.
That's what Christian's saying, it's your name.
Yes, an individual generally is entitled to use his or her name in any legitimate way, even though such use may be detrimental to other persons with the same name. So the right includes any use as whole or in part of the name of a firm or corporation by which a person is interested. Accordingly, the courts may not infer with such use where confusion occurs only from a similarity of names from manner of the use. A person has a property right in the use of his or her name, which he or she may assign.
Wow! Did you just say they have use of the name in which he or she may assign?
So when you grant them the use of your name, by giving them your name, you just assign your name to them.
Oh, you're kidding. So, but then if you've done the assignment, then you've put, that's why it works then, because you're putting the onus on them then. They've got obligation. That's almost can you have like almost like a temporary merging of the titles kind of thing in that sense? Or wait a minute, when we prove the trust by assigning, right, like UCC 1 and then UCC 3 is the assignment, the transfer.
Yeah, but I'm just making a notice of a past present transfer. And when was it presently transferred? When I gave him my name.
Right. So there's your way of doing it without the paperwork. Wouldn't that be?
Yes, because that's when the trust actually formed, when I gave him my name.
So as long as you do a formal, for and on the record type of, I don't want to say statement, but acknowledgement of granting them the use of the name on the condition that A, B, C, D, but let's face it, mostly for settlement, there you go. That's right at that point. That's an assignment, you're saying?
Yeah, you could do a 3 assignment and validate the record that you did a present transfer by telling him, I grant you my name. I give you my name.
Okay. And that would be why it works then, because they've got it, and the assignment puts them as the trustee, that's the fiduciary trustee in that case?
Yeah, well, you assigned it to him without any compensation. But this is debtor creditor unless you express it as being trust.
Well, yeah, I mean, but just, okay, yeah, I got to balance all the things there. But
no one has property right to a personal name such as that one can keep another from using that name, although there is authority that the rights of individuals to the exclusive use of their own names as against persons holding other names or corporations which undertake to approximate their names will be protected. Generally, where no question of a trade or business purpose is involved or no special injury to character, repudiation, or property. A person has no such exclusive right to the use of the name as will enable him or her to prevent its assumption or use by another, except where such right is given by statute or where such right is protected as a right of privacy. Trust.
So how does that tie in? Can you stop? So give us a little bit of an extrapolation there, Christian, like in the right of privacy.
I'm protecting this because it's my right of privacy. It's in trust. And then the next section is section 4, idem sonums. If a name sounds alike or substantially alike, they are usually regarded as the same, although spelled differently. And in the variance of their spelling is considered to be immaterial. Bingo.
That's the game. That's the game that the judges are playing when they're trying to confuse the lawful name with the registered name, right?
Yeah. Yep.
Hey, Christian, I have a related question. This is Catrice from LA.
Yeah, go ahead.
What if you, now, suppose you create a trust that's your name, and the trustee of your trust is an LLC. Could you name your LLC after your name?
I don't see why not.
That wouldn't be, confusing things? You wouldn't, automatically terminate the trust?
No, it would be a separate entity.
Okay, that's what I thought. Okay. Thanks.
So, again, idem sonum, similar-sounding name, although they're closely identified together. I think it's, what was that, confusion of identity or something? I forget the definition there. When two names or two words are similar and alike, they more or less, when notice to one is notice to the other because they're so closely associated.
Oh.
Unmuted.
Hey, Christian.
Interest is the definition. Identity of interest. Identity of parties also.
So what is an application, Christian, of the that aspect, the reference you're making to the private again? Like, I'm trying to think of a scenario, like, I don't know, just a traffic ticket or something in court, but just to see how that would play out or tie in, or how we could utilize that as an
I can't give you my name because it's private. It's being held in trust. It's privacy. And it's my right to protect it as a right of privacy.
I have heard of that argument. Somebody, I forget how they phrased it now, and they said, something about it's, and then when they asked why, you could say it's private.
Well, private means it's held in trust.
It's privileged information.
Now, what would a judge say to that, you figure?
Well, he can't take your name. It'd be a breach of trust.
If he keeps asking for your name, then...
Your Honor, that would be a breach of trust if I gave you my name.
One of the things that the judge said to me was, give me something that we can call you by.
That would be the same thing but similar, and they'll take that as the name then.
Right. But, okay, so let's go back to your scenario. I like this, right? I can't give you that name because it's private. Is it private? Is the birth certificate private? How are you interpreting that now? Because haven't they issued it? Well, they've issued it to you, right? Because you gave them enough information to say that they issued you.
Hang on.
Muted.
Issue you anything? Your name got issued to them. You didn't give your name away because you couldn't even speak.
Oh, I'm just saying the event where people go and fill out information for an application to get a birth certificate. There's some kind of issuance on their part.
But that's only a copy of.
Well, yeah, certificate, but you're...
Well, anyone can get a copy. I can get a copy of your birth certificate.
Okay, so you're making reference to something else then, the original document?
I'm talking about the original, yeah. Let's have a look what's happened there.
Well, what happened there? We talked about the mom and the baby and the footprints?
I'd be very interested to know Christian's take on it.
What was that?
You know, on the original, sort of like, from my point of view, when the mother goes to the doctors at 12 weeks, 3 months, and she gives her, like, her forwarding that there's going to be a vessel coming in 6 months' time, is that not the first res? Is that the informant?
No,
because it seems under the laws of bills of lading, then, she will be complying with the bills of lading, which is 6 months in advance.
You're saying they make the mother sign something 6 months before the baby's born? Yeah. Are you still there, Pete?
I'm muted.
Yeah, that's exactly what happens. The mother goes to the doctor after 3 months.
To get prenatal care.
Exactly. Now, why is that? Because it's all linked into the system anyway.
Well, what, she signed something then?
The bill of lading?
No, just going to the doctor to initiate the whole process. Prenatal care.
Yep.
Leading up to delivery.
Telling the doc that there'll be a vessel arriving in 6 months, which is how a bill of lading works. All bills of lading have to be issued 6 months in advance.
Well, okay, but let's go back to a practical, and if we can tie that in, let's get to, I'm trying to just see...
Well, I'm wondering if Christian's got any thoughts on that particular part.
No, but that sounds plausible.
Okay.
That comes from my studies on bills of lading.
Yeah.
I'd like to learn about bills of lading more, that's for sure. But I'm just trying to understand the picture, and I have heard stories. I got to go back to my friend to see how she said it, and she was talking to somebody who's pretty smart, and there was something she did say about when we were talking about the name, and it was so simple, and it was something very much like that. When they get to, I forget, the birth certificate or something, and she just says, well, when they start asking about that, just say it's private. So this is funny because it was kind of hitting on the same thing. But I'm trying to go back to the court now and seeing we create that dynamic model, because you know how that helps us understand it better, and it's practical. And what could be possible? So let's go back to that scenario with Christian was saying, like judge says, you know, are you John Doe, or are you Pete or Shane Moore? And I say, would you say something to the effect, are you asking me for the name, for example? And again, I'm sure the judge would just probably say something to the effect of, so are you Shane Moore or not? And then I'd have to say, are you not asking me for something that is private, perhaps? And I'm sure the judge would just say, look, I just want to know if you're Shane Moore, right? Because that's how they...
What about turning on him and say, who gave you that name? That's privileged information. That belongs to me.
Well, yeah, I could say, usually I say something to the effect like, are you making reference to the registered name? The name that's registered? Is that what you're...
I don't think that's as aggressive as coming in with, hey, that's mine.
Oh. Well, I always put everything into question. It's just...
That's stolen property. Is that not stolen property?
There you go.
Have you not stolen that property from me? That belongs to me. It's mine. Unless there is another party going by that name who you can identify.
And that's without consideration.
Well, is that where you're making a claim? I think, isn't that what Winston was saying? I hold the claim. Does anybody have a superior claim to me? Isn't that what that certificate is, a form of a claim?
It is a form of a claim, yeah. It's the Crown claim, and you're his property.
Yeah, but you're holding it. You're the holder of it.
No, you're not. You've got the copy. You haven't got the original.
So you're
saying made a claim to everything.
Okay, but if they've got a claim, and you're holding a copy of it, what does that make you? You must have some claim because they gave you a copy of it.
Equitable interest in the thing.
Okay, so is that some kind of claim to the equitable interest?
Well, it's a claim before theirs, isn't it? Because you are the actual thing.
So I've got equitable interest or a claim to equitable interest then, yes?
Yeah. Yeah, you already, it's your equitable body's your equitable asset.
Hold on. Okay, so I've got equitable interest, I've got a claim to equitable interest, and that would be, the question is then what is that? And that is use of that, what I have equitable interest in. And what is it that I have use of that an equitable interest in? And that is...
everything.
That trust. Right?
You'd have equitable interest in everything.
Which is the trust, through the trust.
Well, just through the fact that you're here.
Well, in this case, in this application, because I want to use something that is a currency that's understood according to the court. I want to make sure that they're part of the equation. It's just another way of maybe looking at the same thing what Christian's saying, maybe, just by saying, hey, this is private, or I'm going to give you this name-like condition.
How about this one? An assumed business name can be transferred by the filing of a withdrawal by the assigner and the filing of a certificate relating to use of such name by the assignee. That's under the transfer of name. And also it's under the change in ownership of business. Doesn't that sound like it might be the live birth certificate, and then they filed a transfer, which would be the birth certificate? The withdrawal was the filing of the withdrawal was the live birth by the assigner, and the filing of the certificate relating to such use of the name by the assignee, which would be the birth certificate.
So you're saying they transferred something onto us?
Yeah, the live one was the withdrawal, and the birth certificate was the assignee, the certificate relating to the use by the assignee.
Where are you reading this from, Christian?
Under change in ownership of business, under Section 17, Corpus Juris Tecumseh.
Oh.
Transfer of name section. So your name was transferred. It was withdrawal withdrawn from by the assigner, say from the private side, under the live birth certificate, and it was assigned on the public side by the certificate of which would be the birth certificate.
Yeah.
Muted.
Okay, so who's all the parties, and where does that place us then, based on what you're saying there?
So your mother was the assignor, and the assignee was the state.
Okay. So
the live birth certificate is the withdrawal by the assignor, your mother, and the filing of a certificate, a birth certificate, relating to the use of such name by the assignee or the state.
Yeah.
So the state filed a birth certificate relating to the use.
Which they use for basically floating a bond and borrowing some money, right?
Right. And that was the transfer of the name.
So now, where do we stand? Do we got any claim or right, or what?
Now, that's under like debtor creditor, but now let's treat it as trust and let's merge the titles, terminate the trust.
Okay, but before we get there, where's our starting point then? Where's that living soul as he's standing there now and he's looking at that? Just before you get to that, what is he right then and there? Is he beneficiary? Well, he's grantor still, or by virtue of passing on the responsibility of the mom signature to him?
Well, they probably tricked you to be the trustee, yeah, when you fill out the 1040 forms. And now you're listed in the IMF as the trustee.
Okay, but from that position, would you say we have the right to get hold of grantorship and fix it?
Well, as long as we claim it first and nobody says anything, then we have the right to merge the titles, do the transfer, merge the title in one entity, and terminate the trust.
It sounds like another thing Winston said is the biggest thing we're not doing is we're not claiming it.
Yeah, we've got to claim it first because you've got to show ownership, so you've got to claim it first. Claim it on a 1, UCC 1.
Gotcha.
That's like you're saying about the 1 first, because that's claiming it. You can't do anything with it unless you can only transfer what right you have. So first you have to claim the right, and then you can transfer the right.
That is cool. I hear everybody going silent,
There's another one. Filing a prerequisite. Under the Business and Commercial Code, each party doing business under an assumed name must file an assumed name certificate in the county where the party is doing business. And the party cannot maintain a suit in state court under that name. So doesn't that sound like the birth certificate again? You're recorded in the county?
How would you do that, for example? Are you saying a reference back to the UCC1 again, or a copy of it, or?
To do what now?
Well, you said to make a record of it in the county.
Well, it's already in the county. Your birth certificate is already recorded in the county by the county registrar.
Oh. Okay.
They do the recording. That's it's at the district of.
But that's the filing prerequisite for doing business and commerce.
Right. Which would make sense. That would make sense, and that's plugs you into the system, and then the birth certificate is almost like a.
Well, you're already plugged in, really, because the doctor gave 6 months' notice, but now you've arrived. Now you're you're in the corporation, if you like.
Yeah, pretty much.
Yeah, we're not granting our assets or our res under special deposit. Therefore, it's a general deposit, and a general deposit puts us under debtor creditor automatically.
But there's also that principle, whether it's statutory or not, or what could be underlying it. But I remember Vic was very specific, saying, it says right there in the Vital Statistics Act, you're entitled to be recognized by the name. And he said there's nothing in the law that says you've got to be. So it's not like they got to change.
But violate what we were talking about earlier, that the name is only one means of identity, and the name is not the thing. It's not the real issue. It said that, what was it? Let's see if I find it again real quick.
Christian, that would be another argument with the court that if you do not have a UCC file to do business as under that particular name, that they can't interface with you because you're not lawfully a business of commerce.
That's exactly what the name is that they've brought into commerce by the assignment.
I would say to that, if you just focus on saying you're not the name, they're just going to try and do something absentia. You still got to be something. You want to be something in relation to the name, and there's a responsibility of some sort, right? So,
but the name is the essential thing. The name is not the identity, the identity is the essential thing, not the name. The identity is the essential thing, not the name is the essential thing. It's the identity. And the identity is determined by the boundary.
So what is that getting at, though? I don't get the bottom line of what you mean by the identity is the boundary, not necessarily just the name itself.
The name is not important. It's the identity of the person that is important. And the identity of the person is determined by the boundary.
So they're making reference to the trust account again? And saying, like, okay, we know that you've got some kind of trust account there for use?
Yeah, I'd suggest that's what Christian's saying, is that, he's putting the blockers on, he's making it private. I believe I have some boundaries here, and you're trying to cross them. I'm not prepared to give my name, because there's no obligation for me to.
Is that what you're getting at, Christian?
Well, the identity of the person is the right of privacy versus publicity.
Okay. So wait a minute. You're saying there's two parts right there. There's the name, and then there's the identity.
Yes.
One sounds public.
The person, which is important, the essential thing, the identity of the person, has got to do with privacy or publicity. If you want to make your public, you're in the realm. If you want to make sure that it's private by trust, then you're limiting your boundaries.
Okay, so the identity is referring to the living soul. Is that what you mean?
Well, no, it's the vessel, really. You're trying to keep your vessel private.
Well, the person is public, right?
The trust.
The person is the person the public vessel?
I would assume that the person is the public vessel, yeah.
Okay.
Or the trust.
And then you've got, but it's making representation of something in the private as well.
Yeah, because it's making a reference to privacy versus publicity, or private versus public.
Wow. That is cool. Thank you very much.
Christian.
Yeah, Carlos.
Yes, how are you? I'm sorry to interrupt. Before I forget, I have to go and answer that line. I was speaking with Dr. Graves, the author of the Jurisdictionary.
Right.
Okay. And I asked him today personally, and I told him that we gave the bank or the lender, the pretended lender, we gave him our power of attorney. He says, no, you did not. He says, where is it in the contract? He says, well, you got me there, but I'll find out.
Implied.
Implied, right?
Implied power of attorney.
Implied power of attorney.
Yes.
Okay. He even read on the radio. He even read the description of the power of attorney, but I did not ask him about implied. All right. Okay, that's all. Thank you.
Well, you can just get power of attorney by stating it, couldn't you?
I don't really need to state it at all because you're supposed to know. This is all about trust.
looked at one case, and
so
the judge had ruled
you've got
that the guy was liable to pay on an implied promise.
Say what? Sorry, Pete.
I was looking at one case there the other week in the books that the lawyers learn at school, and it said that one of the cases, the judge had ruled that the guy was liable to pay because of an implied promise.
Oh, really? There you go,
yeah.
Eh? Well, ain't that fancy talk, eh? Obligated because of an implied promise. Well, they do. They like playing with us, don't they?
Well, the lawyers are learning this. That's what they teach the lawyers at school.
So that means the lawyers know about the trust.
Well, they understand the implication.
And while they're told not to, I know that they're told not to share this information. I told you the story about the girl I knew who was living with the lawyer.
Well, they take an oath.
Yeah, and she didn't get the information out of him until one night he was drunk.
Good girl.
Well, but I mean, the whole thing is she's living with this guy for a year, but, you know, he's not sharing it with his own relation because he's the lawyer she's got.
Yeah, he's not mixing his business with his private, and that's what we should be doing.
Well, yeah, I guess, yeah. That's one way of looking at it. Very Masonic, it sounds to me.
Well, it's private business, isn't it? You know, that's his private business. That's what he does to make his livelihood, you know, his living. So he's not going to be too willing to share with someone who just comes along and pops a question, because it's none of their business. But they can hire him, and then, you know, he might divulge a bit then.
Well, there you go. That's controlled distribution of information, in my opinion.
Well, I think we gave them control by giving them all the trust res, and now we just have to take back control by getting our trust res back.
Which we could do in court simply by when they start asking for the name. Now, that's a good question, though, now that you've got an identity and you've got a name. So wait a minute. Now, does that not make sense then what my friend did? Because he said, I am commonly known in the public by the name, which is what he was rightfully supposed to do, because that is the public part, and he hasn't given up any private stuff yet, and he's been very specific that this is public. Here's some public stuff for you guys. Here you go. And by phrasing it in such a way, he has, in an indirect way, made reference to the private, hasn't he?
I could have implied, yeah.
They're taking ownership, aren't they? They're the ones who are saying, you know, we've got your name. Well, where's the expression of an outright gift? Where is it?
Well, show me where I granted it to you. Show me where I granted it to you.
Exactly.
I'm trying to jive this with Vic's interpretation where, you know, he was saying, maybe he was misinterpreting what was going on, but he was saying it's the states, the state issued it. If you can pull yourself out of the joinder, then because they created it and they've got the liability, that's why they have to eventually settle the account. Only when you mix yourself in there and create joinder, of course, that's when they nail you.
That's giving them ownership, but no, I granted it to them. If I granted it, it's mine. I own it.
Yes, and they're still obligated, though, to take it, do some kind of settlement, whatever.
The only way they can take it is if I granted them the position of beneficiary. When did you grant them beneficiary position? Only the beneficiary can take.
Well, no, but I'm saying they only know how to manipulate, monetize it, and get money out of it. We don't know how to do that. So I do want to give it to them for the purpose of doing their banking business with it, so that I can don't have to take any money out of my pocket, right? Any of the other
isn't that an expression of trust?
Yeah, special deposit extinguish the debt.
That's so. How I'm just trying to understand the roles of what we're doing, how we're acting. Are we acting as the trustee, making them co-trustee? Are we acting as the beneficiary, acting them to carry out trustee service on our behalf? Or we actually
let's change this name. I grant you my name for future return. Well, how about if I just grant you my name for extinguishment of the debt?
Yeah. I was going to ask you that. Sorry, I was going to ask you that earlier. When you say extinguishment of the debt, that's more or less on a colorful level that you're using it, but it can still go back to a deeper level. Is that right?
Well, extinguishment of the debt would be using trust terminology under merger.
Okay. So you're talking publicly about a public trust?
Yeah, well, I could be talking about with enough colorable terms that maybe they might not know what's going on. As long as they don't mention, trust, I can use in confidence.
And if you mention public trust, could there not be a private corresponding trust going on?
Oh, could be, yeah. But if I'm trying to establish the extinguishment of the debt or payment of the debt under debtor creditor, which I can't do, so not under trust, if I'm going to get rid of the debt, I'm going to extinguish it under trust.
Right. Of course, yeah.
So I'm going to have to express it as being a trust without giving away, but still keep it private, but keep it colorable enough with word descriptions that are different, that don't identify particular trust terminology.
Right. Because in such a way, because of course we don't want to make reference to the private, because that would be a breach of the policy of it's private. You can't talk about it, and that would be a breach of trust if we did.
That's why I give my name in. I don't even talk about grant. So I give. Grant means the same as give. So I give you a name in confidence. And in confidence would be the code word for in trust. So I'm speaking colorably. So I give you my name in confidence with reliance to extinguish debt. And the proceeds therefrom, return that as my interest.
Well, I think. I wonder what they would do.
Well, they're then under obligation.
Yeah, I think they try and again, is it possible they could try to wiggle out or renovate that or make counteroffers? Or they're on dangerous ground, though, if they start doing stuff like that, eh?
Well, they'll laugh at you first.
Further transactions.
Sorry? I missed that, sorry.
I do not engage in any further transactions.
Yeah, sure, why not? There you go.
What if they come out, well, we'll do the hearing, yeah, because then even if they do the hearing, then do have that instruction, so.
Yeah. Do you need any further instruction in private? How about that?
Well, how about, do you need any other forms necessary for extinguishment of the debt?
And the classic one.
Do you have all that's necessary for the extinguishment of the debt?
Right. Do you require any further? Something? I don't know what to say. Do you require anything further to extinguish the debt? Documents? Do you require any further forms?
Holy smoke. Hello, everybody. I finally got unmuted. Oh, my God. That was painful. Well, I'm happy to be here. JC.
Hey, JC.
Hey, so, going back to the court scenario, and I like you continuing to hammer on this because it is all about trying to get the name out of you, and I keep coming back to the idea that, if you don't appear, if somebody doesn't appear, how does an agent or a grantor or beneficiary, how does somebody appear, walk into court, stay out of the bar or in the bar, without identifying themselves as the named party on the pleading?
Okay.
And without A, being in staying out of contempt, and B, letting the court say that the defendant has not appeared, and so let's just go ahead and issue an arrest warrant for their tick-up.
Exactly.
While the judge is staring at you in the face, say, all right, well, if nobody's going to appear, then we're just going to issue a bench warrant.
Hold on. Yeah, that's why you can't just say you're not the name. Apart from the fact that it's just too simple-minded, and they always it's not a process.
How about coming in with I have my fingerprint as my identifier?
No, just simpler.
That name belongs to me.
You've got to show up as some kind of a party because you do have some kind of a relationship, right? It's not like
the thing is, you're dropping on the back foot there, and you're not pressing home the point that the name belongs to you. It's your name.
Well, but then that's why you can go in there and just say you're operating on behalf of. And the only question is what are you operating on behalf of? What are you operating on behalf of, and what are you operating on behalf of as what? But I think you could probably say some kind of trustee position. Because I wonder if you step up to the plate and say you're going to be the trustee, doesn't that give you the right now to start dictating how things are going to go?
Grantor.
Or grantor, yeah. Well, I don't know. Like Christian always says, well, yeah, if you go through the process, and there you go. So getting back to, you are giving them the name. That's right. You just got to make a point of not just giving it to them. You got to talk to the judge in those questions again. So, again, as far as the contempt thing, it's just, I tell you, as soon as you walk through those doors, you got to think in questions. And so you're asking me for your name, the name, Your Honor, and is something to the effect of, if I give you this name, what do you intend to do with it? I mean, boy, if you start talking like that, they're going to be onto you. And you're not withholding the name. And for what purpose do you need the name? Are you going to settle and close any accounts if I give you this name? How about that?
I'll make him an offer.
Yeah.
Make him an offer, much like Gordon Hall might say, listen, judge will say, this is, and who are you? So, well, judge, I'll give you my name in confidence on the condition that you use it exclusively to extinguish the debt and distribute it, return all proceeds therefrom with my interest forthwith.
Yeah. There you go.
Yeah, and the judge will say, what the heck did you just say? What is your name? Who are you?
Again. So there's no contempt there, I'll tell you that, because you asked him a question and you made an offer, so it's ingenious, and there's no absentia because you're telling him that you've got the ability to give him the name, so you're not withholding. So I think it's kind of, I'd be tempted to try that now.
But nobody has still appeared for the defendant. So all you've done is going to give him the runaround.
The defendant is an account?
No, you've offered. Wait a minute. You offered to give him the name. If he refuses your offer, then is he not in dishonor?
Yeah, haven't they made a presentment to you, really?
Yep.
With the charge? And didn't you do an offer to pay the charge?
Yep.
With the extinguishment by giving them your name?
And that's the consideration.
Qualifier on it that they use for extinguishment of the debt. Now, if they don't accept the offer, what would they be in?
Dishonor.
Dishonor. Certify the dishonor and reverse it on them. If you went 3 times and you made the offer to them 3 times on that 4th time, I think you could certify the dishonor. Tell the court, you default, dishonor, and that's it. It's done.
Yeah, we have that in our bill of exchange.
And what about the injury that they've caused them? What sort of...
Well, next it would be breach of trust then.
It'd be nice to be able to bill them for your time.
Your Honor, are you aware that if you do not do the extinguishment, you will be in breach of trust? You will be in breach of confidence.
How?
Because he's not doing what you
I don't
say.
see any trust here. Sorry, Pete.
That's okay. I'm just saying, like, you know...
I don't see any trust here. What are you talking about? Just give me your name. Just give me your name so we can get on these proceedings.
Well, if I give you that name again, what you propose to do with it? Are we not here to settle?
Listen, I'm going to ask you one more time for your name, and if I don't get the name out of you, because I have your driver's license, so I see who you are. So if you don't give me your name, I'm just going to issue a bench warrant for your arrest, and because nobody appeared.
Can I see that driver's license?
You know, either look in your pocket, or I'll just hold this up to you from the bench. It looks like you.
I have to have a look at that. You have to give it to me. I don't have a copy with me. So I'll get it and I'll look at it and I'll say, where's this copy been? And am I allowed to perjure myself, or am I allowed to perjure here in the court? Of course not. So I don't know where this copy's been. I can't. This is not my signature.
Well, how about a picture that is a striking resemblance to you?
That is not me. Again,
that's the kind of line.
Have you not received?
I don't know how to look at that, but that's the kind of thing where I can see that could be a contemptuous charge. When you say that's not me, and they have a driver's license photo of you, I can see how contemptuous stuff being.
How about saying then? Are you sure that's me?
Yeah, you could. Yeah, you could, if you want to keep it in the form of a question. But I mean, do you have a power of attorney to qualify that signature? Okay, and I don't know where this copy has been. Okay, a copy cannot stand in court. They know that. They'll shake your can on it. Sure, they will. But that's why you got to know beforehand, because they can be very, very excellent actors. They are good actors. These are guys. Some of them are like Shakespearean.
Yeah, and now we're giving them a new role as trustee. We're saying to them, extinguish the debt, and then, give us everything that belongs to it, and I'll be on my way, and everyone's happy.
But hey guys, what about by special appearance?
Yeah, I like being something. I like saying, I'm here as the trustee, grantor. What did I say? I said trustee and grantor in fact with special interest in the name. How accurate that is or not, I don't know. But as when she said, "Well, we're just going to say you didn't show up," and I said, "Well, how can you do that if I just told you I'm here as the trustee and grantor in fact?" And again, I said to the judge straight on, man, I nailed her on it, and she answered. I said, "Are you telling me that I don't have the right to be the grantor and trustee, or the trustee and grantor in fact with special interest in the name?" And she said, "No." And I said, "Fine." I was screwed up, though, because I wasn't demanding. I went and said I petitioned the court to dismiss the charges. I got that backwards. He said not to do that. And I think that's maybe where I was getting at, because I just kept saying then, why aren't you recognizing me as the trustee and grantor in fact then? And she couldn't answer that.
How about when they say, "Is this your name?" And you say, "Yes, that is my equitable asset."
Well, I just say we're still taught from Vic that it's not our name; it's the name that you have registered. Right?
No, that's the one they've got. But who gave them that? No one.
I don't know.
They took it.
The parents.
And no one's challenging them on it. And now you're coming in challenging them, and they've got no say.
Well, that could be a whole interesting. That's a whole other tack, but that would be an interesting study too. But I mean, you got to stick to you can only do one. You don't want to throw a whole bunch of spaghetti at the wall. I really don't. You know what I mean, Eric? You got one good shot. Keep it simple, stupid, because it's going to be bigger than you find out anyways. I guarantee you that. And you want to keep your experiment simple so that you can see the correlation, the cause and effect, you know.
Well, would everybody agree that if you didn't give them your name, they would probably issue an arrest?
Absolutely.
Or foreclosure or whatever?
You got to be there as something.
Yeah.
Somebody has to appear for the name, even if they hijack your name by putting it on a pleading. And, you know, I mean, that all-caps name that's a name. They might have hijacked it. They might have ownership. You might have nothing to do with it because they stole it 25 or 40 years ago. But that's a fiction that's in court right now that somebody has to appear and defend the proceeds that they're attempting to steal. So somebody has to show up and close out that account and then have those proceeds distributed because they're doing something with it.
I did say to them, you can call me Larry. That's the middle name my mother gave me, and I accidentally removed it from her birth certificate, the birth certificate that I have interest in. And I heard when they were all disorganized and flustered, they were speaking out, and I heard the recorder say to the judge, what should I put down as the name here? And I heard the judge say, you're going to have to put Larry. So I said, I'll give you, because I heard somebody, this guy named Lee Banks, said, just give them permission. I said, okay, fine. If this is really causing you a problem, I'll give you permission to call me Larry. Just to make everybody happy, okay?
Well, that's just like a license. It's no different than giving them a qualified use, giving you in confidence with reliance that they're going to extinguish the debt, distribute the proceeds therefrom. It's no different than that. It's a limited use.
And then get back to your track. I'm here as the grantor or whatever, and I'm more than willing to give you the name on the certain conditions. So actually, maybe you don't even want to use the word give, Christian. Maybe you want to say, like you said, grant. What did you say? I'll grant you my name.
The use.
Yeah, I will grant you the use of the name. So maybe you can qualify it.
It's quite the study what can happen in the first 10 seconds, huh, guys?
Yeah. I've always said the whole game is won or lost at the beginning moves of this thing. That's how they play it. These guys are always big on that strategy. They're trying to get when you're showing up at the court by definition. Don't forget, you're accepting an appointment to show up in court is joinder. You're showing up in court is joinder. You've got to rebut all that stuff when you get there. You got to have a position. You got to have a reason why you're there. You better tell them.
Exactly. And you have to distinguish. And you have to distinguish yourself from the birth certificate name and the name on the pleading, and the idem sonums that Christian referenced earlier. If you give them your name, even you can't say, well, my name is spelled, capital or lowercase or whatever you're going to say. So my way to cross the bar at least is use, I'm here, or you can call me as first middle of the family. Blah blah blah, and come in that way as I'm here. I'm appearing specially as grantor beneficiary in this matter to close and settle all these matters. But I gave you that name, and I'll give you the name of the defendant in confidence, which relies to extinguish the debt and return those proceeds therefrom with my interest.
Sounds good.
So just making sure that the idem sonums is not. Is there some distinguishing factor of that, just like you gave Larry? I think that's critical.
Yeah, well, he tried to immediately start changing it around. Okay, so you're Larry Moore, is that it? And I said, no. What did I just tell you? I said, I'll give you permission to call me Larry. So, and then the judge, like I said, the judge recognized it. So it obviously didn't give them any jurisdiction because it was not tied to in any way, shape, or form, and it got over the name game because now they got a name. So they're trying to. I just played stupid right into their thing. Oh, we need a name in this court. We have to call you something. And it's like, okay, fine. Here, I'll go along. I'll show you how cooperative I am, and just smooth.
So how are you then going to assume your authority as the grantor?
Well, I told them that originally. I said I'm here as the. I stuck to that. Yeah, I didn't say okay. I didn't pretend to be Larry. I just did that to satisfy what was obviously, transparent excuse, right? They're not being on the level with you, obviously. So I already said, here's the, do you not understand I'm here? I mean, I'm not having a hard time necessarily. You can do this if you got a nice flow. Do you understand I'm here as the trustee and grantor in fact with special interest in the name? In the criminal court, man, that got the judge up, and he walked out, and then he came back in 3 seconds and made an adjournment, upon which 2 planted individuals tried to approach me in the hall.
So he adjourned, and then did he dismiss the case, or did he just adjourn?
No, they just adjourned it for 5 minutes, and that girl and that cop, they were so planted there. She was on a mission. She was trying to mess me up. She was trying to say, are you feeling well? Do you need to see a doctor? Are you the guy that had not wearing a seatbelt? And I just blew her off at every step because I caught on to her, and the cop was making sure I didn't tell her to F off, basically. He was going to try and nail me on something like that, right? Yeah, and I couldn't buzz her off as we were walking back in. She was like whispering to me, like, as we're walking down the aisle, right? She's like, oh, you can do this, you can do that. Oh, it's okay, you can step across. The judge said you can step across. And I'm like, would you shut up? I was like, it's embarrassing when people like whispering that loud and the court case is going on and it's in session. I was amazed that nobody called us out and said shut up, but because they knew she was working me, so they're going to see what was going to happen. We got up to the line. I just said, no, the judge didn't say. Stop it. And then you could not get her to go away. She then, without my saying, stepped across, did a little bow. She started to talking, and at that point, I just said, "Hey, what's going on here? Who is this?" Seriously, I was like, "What's going on here?" And that's when she did the little cringe, and then she cringed, and then she crawled back to the gate, and she crawled back into the crowd and sat down and mixed herself in, just like she was crawling back under a rug. I swear to God. I nailed her though.
And then what happens in the...
Christian, what are your thoughts on that? What are your thoughts on coming in, as like the first middle of the family, something that separates you from the ad insanums, and then expressing yourself as a capacity managing the trust where there's grantor beneficiary?
Yeah, you could do that, but if you had some kind of proof that that's who you were, that you were a separate entity, and then you had the authority to operate on behalf of that other entity that they're trying to get.
Well, you can be any name you want, though, can't you?
As long as you can prove it.
But you need the reason to show up. You said that before. You have to be there appearing on behalf of the defendant or whoever's the named party in the pleading. Somebody has to appear on that person, just like an attorney has to appear, make an appearance. So if nobody shows up, once again, you're going to be toast.
I know that I'm not that entity, and they know that I'm not that entity, except that they're going to misconstrue it.
They're going to misconstrue.
All they want the measure for is to get the debtor-creditor thing going, but why can't we just stick with trust and settle the debt?
Menard did something similar a while back. It was him and his friend Dene. Dene showed up, and he said, "I'm the administrator." I don't think you got to be a name necessarily. You can be a trustee or an administrator. And just, I don't know, off the top, Sam Kennedy says, avoid even using the appearance, because any kind of appearance is still something they could construe. Just say you're there to visit. You're visiting the court. You really don't want to be a part of their scene, right? I'm only here because I have no choice. I'm here under duress. Do you understand that? Okay? But if there's something I can do to assist the court, I'm more than willing to help. And I just want you to understand that. You know what I'm saying? You got to get that stuff out, and it's got to be right at the beginning. And I guarantee you, they'll fight you.
As Christian's saying there, he's saying come in trust.
Well, I'm saying that you got to establish the jurisdiction. I'm not sure if you want to be right out.
He is establishing the jurisdiction. He's saying it's a trust.
It's a trust.
Exactly.
Hey, I'm getting that. Mute out. Somebody's doing that. They got split responsibility.
Okay. Okay, press star 6 to unmute. Anybody there?
Yep, just got back up.
Okay.
So yeah, that's exactly what you are saying, isn't it, Christian? Come in, establish the jurisdiction, and don't move from that.
Yeah.
Couldn't be much cleaner than that.
If they go in,
how do you establish that jurisdiction, Pete? What is your recommendation?
As Christian's describing.
If they go anyplace else and they try to do something else, I just tell them, I do not do that.
Ah, sorry, what did I miss?
Now, that's not to say that they might try to go ahead along with it anyway, but then I'm going to have to plan on doing an enforcement. But I would put them on notice that they're right on the verge of breaching the trust.
So, sorry, Christian, how are you establishing jurisdiction when you first walk in by saying, by making reference to the trust? How do you do that?
They get jurisdiction by you making a general deposit instead of a special deposit because you're not claiming trust.
Okay, so that gets
Under
back
a deposit, you're putting yourself in the debtor-creditor relationship and you're the debtor. By expressing trust, you're making a special deposit because I want my signature or whatever the res is returned, and if I'm going to get my property back, it's got to be special deposit. So by claiming special deposit, claiming trust, that's claiming the jurisdiction, and they can't claim the debtor-creditor jurisdiction.
So can we do all this before, like via paperwork, and communicate with the court?
I want to learn how to say it verbally, but so that gets back to your phrase then, Christian, which is I'll give you my name in confidence.
Yeah, in confidence, right? And maybe in the future.
Can you say, is it okay for you now? We know that every word has special meaning. Is it still good to use the word "I'll give you my name," or should we be saying something else like "I will grant you use of my name," or I will grant you my name in confidence?
Well, give and gift mean essentially the same.
Are we not still giving it to them, but even if we put conditions?
Well, you could probably put grant. I mean, it means the same thing, grant. I grant.
Yeah, that's right. Okay, that's right. That's right. You're saying just don't give them a carte blanche, a blank check give. It's a give with conditions.
Yes, because the condition is I want it back. It's on special deposit.
Yeah, so it's really a matter of saying this with understanding.
I really don't care if they understand or not.
No, for us to be saying it with understanding so that we...
Well, it's more saying it with ownership.
Yeah.
Now, back to my question, Christian, would you say that we could do it on the paperwork before the court case?
Yeah, because you could put motions in there before you went.
I see that as being a very sensible way of doing things. I mean, it would be nice to know the verbiage as well, but, you know, getting the specific words down isn't going to come out like that anyway.
Sure, well, if you practice it.
Well, yeah, practice it and stick by what you're going to say, and then, you know, job done.
Yeah.
But you still don't know what they're going to come back at you with. But if you're not going to move from it, then, you know, there's not much they can do.
What if the judge doesn't understand any of this terminology?
I guess that makes them incompetent, doesn't it?
I guess so, yeah.
Christian?
Yeah.
What if the judge doesn't understand this terminology about trust?
I guess he'll learn real fast because we're going to educate him on the enforcement.
Now, the courts have like a complaint system, so are we going to put a complaint into the Department of Justice or something?
Well, that's the beauty of being there live, though. You can do stuff right then and there, can't you?
Recommend, yeah. My guess is they don't understand anything about this, and so all the things that we're doing in there, it's like secret code, and we know it, and we may be right, but they're not going to get it or understand it, and so they're going to act in their own debtor creditor minds. And I chatted this on the chat earlier. You were talking about attorneys and what they know and what they don't know. Attorneys know how to be scribes and steal pleadings from other attorneys and modify it for their fact-specific issues. It's like rote memorization as a 10-year-old trying to learn a second language. They don't know any of this stuff. They've never been taught this. They don't study, and this is all they know. Black law, and that's all they know. So, and because judges come up from the ranks of attorneys, unless there's some special read-in at some special judge educational center, which I'm kind of suspicious that there is not, or I suspect that there's not. I just don't think they know what we're talking about. So, to answer your question earlier, I think sending the judge in chambers your private documents proving the trust in advance of you walking into court so that he can't deny that he doesn't see a trust here, or when he says, I don't see a trust here, you can say, Judge, did you not get the proof of those documents in chambers? And by the way, we can't talk about that because that's special. I sent that in confidence, and you're about to breach the public trust in that matter.
That's good. I think I wouldn't underestimate these guys. But, they obviously use the word understanding all the time. So when they're saying they're not understanding something, which they do a lot, if you start hitting on the hot topics, what are they really saying to you?
They don't want a contract.
Exactly. So but they got to do some business. They can only refuse contract for so long, right? Or your offers for so long. And then, again, if you know how to hit them with the
so we're not offering contracts. There is no offer to contract.
Well, our offers in general, though, they're saying they don't understand.
No, this is an offer. This is an order.
Yeah. Okay. There you go. So then you've got to find a way to colorfully point out to them. Are you sure you got to kind of like, if they had, for example, if they had said, well, I'm refusing to do what you say, essentially is what they're saying in their little fancy talk. You got to kind of point it out to them. Are you sure you're in a position to do that, one way or the other?
Well, I'll then notice you that you're in breach, and then we'll go from there.
There you go. Do you understand what a notice of breach is?
Do you understand what enforcement is? On a breach of trust, Your Honor.
Yeah. Well, I think get right to the punch, right? If you know you're in the position, you might as well lay it out, because if you're wrong, you might as well know that right away.
Are you going to let the trust fail for a breach of trust and yourself breaching the bench?
Oh, shoot. You guys cut out.
Are you going to let the trust fail for a breach of trust, Your Honor, and breach the bench yourself?
Yeah, so you can practice. If you get 3 or 4 questions like that, you'll scare the judge right off. If you give out like 1 or 2 or 3, he'll just think you know everything.
It'd be like when, there's a Charlton Heston when he talks and all the apes are all looking at each other.
Yeah, when he said, get your hands off me, you dirty ape.
Yeah.
Yeah. Good old Charlie. Charlie Bronson. Anybody seen that movie?
Is it a trust movie?
No, it's just a real crazy guy who's in jail, though. And he's, I think he's the most notorious prisoner in England. And he had a Charlie Bronson alter ego complex.
Is there any movies you could recommend, Christian, which might touch on trust? Because I've been looking through, Boston Law and some of the others. What?
Wizard of Oz.
Wizard of Oz. Have you guys seen The Gamer? That's an interesting one.
How does Wizard of Oz come in at trusts?
Right from the beginning, when the house crashed on the witch, she was granted the shoes.
Cool.
Sorry, when the house I missed that. When the house crashed on the witch, then what?
Dorothy was granted the shoes.
Right.
Granted the use of.
And everything was colorful, wasn't it?
It was trust from the beginning.
And she didn't recognize it was a trust.
Yeah, she didn't recognize the right title and interest because she didn't click her heels 3 times together because she didn't know. She had to go through all the ordeals first because if she would have been told beforehand that she could get home anytime she wanted, she would have never believed her.
So when they told her to follow the Yellow Brick Road, they were sending her down the road of commerce into the colorful way of doing things?
Yeah, she had to be tested to develop her belief, yeah. And belief was the trust.
There's so much in that, though. There's tons and tons.
I'm saying especially that's a trust.
Christian, have you watched The Matrix a lot, right?
A few times.
You notice every time that they wanted to get out of the Matrix, what did they have to do?
Unplug the head.
Well, before that, if they wanted to get unplugged,
they had to make a call.
And what kind of a phone did they use?
Use the hard line.
Yeah, it was always a landline, eh?
Yeah.
They had cell phone, but they couldn't get out on the cell phone. They had to use a landline. I just thought I'd share that.
Well, I know what that means.
Land, Admiralty, getting out of Admiralty, getting back on real land.
Oh, I see. Mm-hmm.
So, Christian, if I go to the Privy Council this week, I intend to speak with a representative there, and I'm going to say, can you show me the proof that you have an outright gift from me to use my name? And they're just going to sort of like clam up and say, I don't know what you're talking about.
Stock evaluation.
Stock evaluation. Yeah. I want to audit the account.
I don't know, man. This thing takes a lot of understanding to see when you land like a cat on your feet, no matter how they throw you. You just got to be with enough knowledge to land on your feet.
I think it's getting the fundamentals.
Yeah. Making them understand and make sense to you. That's the tough part of it, but it's, staying up to 3 o'clock in the morning, that'll do it. Good medicine.
So you're going to go into the court, Pete? And
it's kind of, the Privy Council is like, it's the advisor to the government, and it's kind of like, it's the Crown's, it's the nearest position in the public to the Queen, if you like. they're privy to all her knowledge and understanding.
And you're going to ask them whether or not
they have proof of an outright gift from me to use my name for citizenship.
Is there a charge?
Well, I have some documents that are contrary to what I believe is true. That people keep sending me letters which are registered to the UK, and apparently I'm registered to the UK, but I don't ever remember registering. So can you just give me some proof of chain of title, as it were? Well, as it seems to me.
How about your birth certificate?
The documents, yeah.
There's got to be something to it, right?
I'm just wondering what Christian would think on, approaching someone like that.
Like, sorry?
Well, I'm going to the Privy Council this week to ask them, what does this documentation mean?
Oh, Privy Council, they deal with private stuff, don't they?
Public and private.
Yeah, that's the same in Canada.
Sure.
The Governor General, Privy Council, and somebody said the Queen herself if you address her as Elizabeth. I'm not too sure on that one, but he insisted.
Yes, that's what I mean. I'm foreign to UK. They're assuming that I'm a citizen. So where's the proof that they have that I gave them ownership?
Hey, Pete, I ever thought about that?
Okay, JC, yeah, love to hear it.
Well, like anything else, my analogy would be if I'm standing in court and I'm trying to tell the judge, who gave you license to use that name? And the judge would say, well, why do we need license? It's your name. And they could ask the same analogy, and then, but if you have proof that you've claimed it, that that's your name, or that you have ownership to that name, not just equitable, but first possibly legal, but through the merging of those titles, or the merging of the birth certificate and the claiming and merging, rather. So you have your evidence package that you're prepared to present when they give you a response that you don't want. You know you have a superior claim. You want them to prove a claim, and if they stumble on that, you have the paperwork to prove that you have a superior claim.
What are you trying to prove here, Pete?
I'm trying to prove that they've taken something, they've split the title, if you like, and they've used what they claim that they own to generate funds for their benefit.
All right, but what are you trying to come up with for proof for what? That they've done that?
Not so much that they've done that, but where the authority came from for them to do that.
Sounds like
How can they prove that? How can you prove that they did that?
Because of all the letters that I get, and everyone who I check out is registered to UK, including the name. And I don't believe that I ever granted the use of my name to be registered with the UK.
So is that your claim? What is your claim?
Well, I've made my claims of ownership to that, but now so are you saying that I need to come in with my evidence first? Here's my evidence of my claim, that I have the right of ownership.
That whoever makes a claim has got to come forward with the burden to prove it. So what is your claim? you're asking them to prove it up, but you haven't made a claim, so they don't have to prove anything up.
Okay, yeah. So come at them with the evidence that I've given me NOIs and me SOIs, and now why are they using it?
Well, that could be the question. Okay, this is mine exclusively. Now you're stepping on my claim.
Yep.
This is a trust. This is my trust. What do you guys got to do with it?
Well, they're the only ones that can pay things with it. And you can't necessarily pay anything. You got to still give it to them to make the payment, right?
Well, that's kind of what I was wondering, why he was making a claim. Is there a specific reason? How is he going to make them prove up when he might not be stating a claim himself? Because it's the movement that has to prove up.
Yep.
Yeah, I'm not too sure where Winston was going with that, come to think of it, but...
The only way you're going to get it shifted, the onus of probandi, is if you claim trust, then you're the beneficiary, made claim, their trustee. Now, all you got to do is just make the prima facie case, and now they got a claim up, which is just the opposite.
That's kind of where it gets a little bit stitched up, in that they're the highest court in the land, but also the representative of the Crown.
Like, you got to have a breach of trust already, and then come in and say, why are you breaching trust? Because I'm the beneficiary, and now you got to prove it up.
I like that.
Otherwise, if I come in and don't claim trust, and I just say, hey, what's your authority? How come you're on this thing? They don't have to prove anything up. It's up to you. You're the one that's going to have to make the case, come up with the evidence, and prove out the facts, and then so they can rebut you.
Yeah, I get you. Yeah.
But I think I've come in under breach of trust, and then I'm beneficiary, their trustee, and now they got to prove up. I don't have to. The onus shifts to them under equity.
And what do you got to do, Christian, to do that? Just to state that, or do you got to do your UCC 1 and 3?
Yeah, I'd have to have some kind of trust, for one thing, be able to prove the trust, and then make the claim for the breach of the trust.
And so, Christian, my thought on that, going back to Pete, the first question was, if you come in as beneficiary, you're going to claim and prove the trust. You're going to merge titles on maybe the birth certificate or something relating to that first issuance of your name. So you have you should have full title to that name, or you're directing them. You're coming in as you're coming in stating that you are the exclusive beneficiary of this trust, and through your documents you have proven your trust. You come in stating that they're trespassing, that you're there under injury, and that and you demand that they prove their any claim superior to yours, and that they have not breached trust.
Well, equity is going to assume that they have breached trust and don't know when are they going to make the payment within a certain amount of time, or else they're going to be in contempt.
Then you should just give them a bill.
Yeah, bill in equity, right?
Yep.
Says that this trust is established by a bill in equity. Page 7 in Lewin, or 15? 15, I forget which one it is. The footnote 1.
So, Pete, what would you use to claim and prove that trust? What trust are you trying to claim and prove? Just the name?
Page 17. Page 17, footnote 1.
still?
Yeah, sure, yeah. I didn't know if Christian was going to speak there. No, I'm going to be claiming the Foreign Citus Trust. The trust that the UK say they have. I'm going to come in as beneficiary.
What's the breach?
Conversion.
So, Christian, you saying that footnote on page 17 applies here?
Yes. A bill in equity.
The remedy must be in equity?
Uh-huh.
And the action is to be brought in the name of the trustee?
Yep. When he disclaims, then you can come in as beneficiary yourself.
Then it says the trustee or his grantee may protect his legal title against a suit at law by the Sestuki Trust. A bill in equity may be maintained to establish a trust where the jurisdiction over an alleged trustee is likely to terminate.
Out in the middle it says, a bill in equity may be maintained to establish a trust. How you establish the trust in court is by bill in equity.
You mean like a true bill?
That's your claim for breach.
Oh, just by issuing him a bill, you're making a claim then?
Yes, the bill in equity is the claim of the breach, and that's what establishes the trust in a court of equity. A bill in equity may be maintained to establish the trust.
Hold on, sorry, you cut out there. That's what establishes?
Yeah, a bill in equity may be maintained to establish a trust. So what establishes the trust? The bill in equity. And the bill in equity is a claim for breach, the breach of trust.
Well, what's the difference between saying I'm going to give you a bill and what makes it a bill in equity? Is it just a matter of just saying here's a bill?
Yeah, you're going to have to give them a bill, a charge. Remember, a charge was a trust. Remember, by definition, a charge was a trust.
Wow. So again, there we go. Something simple as a bill establishes a trust. Wow. You guys are cutting out. I'm going to hang up and call back in here. Something's going on.
At the bottom it says a suit may be brought by a trustee, which he would be estopped to bring in an individual capacity. But then if the trustee probably isn't going to bring the suit, so if he disclaims, then beneficiary could bring it in.
Yep.
The remedy is in equity. There's no remedy at or trust. That law is public. Inequity is private. And then there has to be a subpoena. There is no remedy at law but by subpoena in chancery. So you got a subpoena.
Which book are you in? Because I'm reading 1837 and 1889 volumes, and I can't find either of them.
Page 17, up on number 6. No remedy at law. And then it says, quote, has no remedy but by subpoena in chancery. And then it goes footnote number 1. And then number 1 is the remedy must be in equity. The action is to be brought in the name of the trustee. And then in the middle, a bill in equity may be maintained to establish a trust.
Yep.
By chancery just means in equity?
Yeah, equity. Yes, courts of equity. Courts of chancery, same thing.
So, and again, that's just, we don't have to do anything fancy. We just basically, if we've got some kind of a pre-made bill kind of thing, and then just say, can you pass this to the judge?
Well, it's the cause of action, which is breach of trust.
Yeah. That definitely might put them on the spot, eh?
Right.
Are you going to put them out?
One of the elements of a temporary restraining order or injunctive relief is that there is no adequate remedy at law. And it never hit me before until then. I saw this in number 6. No remedy. Well, no remedy of the City Key Trust, but in Chancery. That's no remedy at law, the same as the elements under the TRO for the beneficiary, but in Chancery courts of equity. Because it's the at-law side is not where your remedy is at, because that's the public side of the court. You've got to go to the private side of the court, which is equity in chambers.
We don't need the subpoena because we're already in court. We can just issue them the bill?
Well, I think that this subpoena is the summons, might be, for the corporation, which is kind of like if you already got a claim, it would be your counterclaim. So they're going to be summoned into court to answer the beneficiary's claims.
That makes sense. Winston always said that, right? You got to go counterclaim all the time.
Well, you guys either be making the claim or making a counterclaim to their claim.
Chris, and you said something that was important earlier. I don't want to gloss over it, and that is that we have to give the trustee has to disclaim, and then the beneficiary can bring the action. So we need to give the trustee notice and demand that the trustee has to remedy the breach.
Yes, so he can't bring a charge against himself. He's probably not going to, but as long as we've noticed him of the breach,
right,
and gave him an opportunity to cure it before we take legal action.
What an interesting statement this is. The trustee or his grantee may protect his legal title against a suit at law by the Cestui Que Trust, which is kind of getting back to the birth certificate, right?
Well, the birth certificate, that's just a certificate to the account.
Well, what's the Cestui Que Trust again?
The beneficiary. Whoever the beneficiary is of that account.
You call the beneficiary the Cestui Que Trust?
Yes, the City Key is the beneficiary. So it's a beneficiary trust, a City Key Trust. City Key means beneficiary. He's the ultimate owner of the trust res. The account.
Yeah, I've heard somebody once told me they thought it meant it is you. City Key. I don't know. Like it's close to French, eh? It is you.
Yeah.
But, although it's originally Latin.
But it's whoever the grantor set up to be beneficiary, because he's the ultimate owner of the trust. The res.
And the grantee, that's just another way of saying trustee, right? The trustee or the grantee, or his grantee. Like grantee, trustee is the same thing.
His trustee is Bailey. They're all the same. They all have possession. They got as trustee, they have legal title, beneficial interest or beneficial titles in the beneficiary, and he's the sole owner, and that's the real title, beneficial title, which is the 1/10 title. Possession is the 9/10, or the legal title, which is in the trustee. And we're duped to believe that the 9/10 title gives us ownership. No, it doesn't, because your liability, the beneficiary's got the real title, the 1/10.
And who's got the 1/10?
The beneficiary. He has the equitable title.
But who actually has that?
Beneficiary.
Who's the beneficiary, though?
Whoever the grantor named as beneficiary.
We don't, but that would be us again. In the case of the birth certificate, that would be us, would it not?
Right.
We have that 1/10?
1/10? Yes. No, not the legal title. Equitable title or beneficial title.
Well, but I thought beneficial title.
title.
Okay, I thought beneficial or equitable title is the possession and the 9/10.
No. Trustee has 9/10 or possession. He has legal title. Beneficiary has 1/10, has equitable title, or it's also called beneficial title or beneficial interest.
Hold on a second. Hold on. Wait a minute. Ownership is possession, right?
No, it's not. Ownership is not possession. You're holders. You got use.
Okay, so what is okay, I got to back up here then. I have a feeling you're going to give me a major understanding here. Okay, so I always thought that ownership was the equitable title, the 9/10, the possession, right?
Ownership is the equitable title, but equitable title and ownership is in the beneficiary.
And we always say that possession is 9/10 of the law, right?
Yes, but that's holding title or legal title, and that's trustees.
And that's law, but not equity. We're coming in at the equitable interest. Yeah.
That's the at law under the trustee, under the legal title, under possession.
So you're saying it's different when we go into the trust?
Well, the trust splits the titles, gives the one at-law title to the trustee, but maintains the ownership in the beneficiary. Although he doesn't have possession. He has really the ultimate ownership.
Okay, so okay, wait a minute. Wow. Oh, man. So
the use of.
So in a way, is that what they're doing? We are the beneficiary, so we are the legal title holder, and the state.
We're not the legal title holder.
We're not. Oh, okay. I thought you said we was.
We're the beneficial title holder or the equitable title holder.
Okay, so we got to put these
title
together.
Holder and trustee.
So beneficial title holder is equitable title holder.
Yes.
And that is the 1/10.
1/10, correct. But it's the total ownership, really. The 1/10 is really the guy who owns it.
Sure. The legal title is okay, equitable is 1/10. Okay.
Because
so wait a minute.
Ultimately, the beneficiary ends up with it all. Or whatever, how the indenture was spelled out, let's put it that way. Whatever regarding the trust res.
Equitable title, beneficial title, 1/10.
Christian, can I add something?
Yeah, go ahead.
So it makes sense to me then that going back to Pete's discussion on the ownership, the Crown holding everything, holding title to everything. They have that birth certificate, which may have stamps all over it, may have been around the world 10 times, but they have possession of that. They have legal title to that. They have that 9/10 ownership of that. We just have that 1/10 beneficial interest or equitable interest in that certificate, that birth certificate that they're holding title to. And but along with that attaches all the liability because we allow that to happen.
Yes, but they're switching the trustee to be you under a misconstruement.
Oh, they're getting all the benefit, and then when we go to court, they switch it around and make us take all the liability.
In fact, they duped you into you volunteering for it because you filled out the 1040 forms and all the IRS stuff that you self-appointed yourself to be trustee. And they got the evidence to prove it. Although you didn't do it with Sentier, but they don't go by Sentier in the fiction realm. They go by manifestation of the records. And you created the records for them, even you didn't even know. So you're operating like a fiction and don't even know it.
But that's why we got the power. If we just recognize it, then we can turn it around and say, hey, I've misconstrued things here.
Yes, and that's before it had to go through the whole movie before she finally believed at the end, and then she could click her heels together, which was a manifestation of her belief.
Okay. So a big part of this then in terms of application is just effective ways of communicating, of making record, of declaring whatever that these things that we've signed have been misunderstood. That's a misunderstanding. That has to be corrected, et cetera, et cetera.
The movie The Matrix, when he was on the steps in that subway and he turned around and they all said, "What's he doing?" And he said, "We're beginning to believe." And then he went and fought the agent. He lost that one. But anyway, at the end of the movie then,
that was pretty close time.
He was shot. But he just believed he was dead. And then when he believed he was alive and not dead, that's when he could start seeing the code for what it really was. Because the code consisted of making everything up. And he could see it for what it was. And he was no longer bound by the system. Because he could operate outside the system and inside the system. Because he knew it. It's all about knowledge and understanding, and then stepping out in belief or trusting on the belief, because that trust will manifest the intention, which will confirm the belief.
Yeah.
Same thing with they use. They want to see a manifested record of your belief. But you didn't believe because you didn't know and understand, so you weren't operating with sentier. Under common law, you got to have sentier. You got to know and understand before you can enter into a contract. But in the fiction realm, you don't have to know or understand. You just have to create the record. And they go by the record because that's the only thing that they see.
That is sort of one mistake people make a lot is they keep saying, well, I said this and I said that. And I say, well, why don't you put that on a piece of paper so that there's a record of it? Because, 2-3 weeks from now, when they look back at your case, there's no record of what you were saying.
So, Christian?
Yeah.
If the beneficial, if the beneficiary has 10, trustee has 9/10, what does the grantor have? Use?
No, he has nothing. Once he forms a trust, he's out of the picture.
Well, in a car or a house or whatever, the person that has the car, who are they?
Trustee. They have possession.
Oh, they have the legal title?
If they have the legal certificate, yeah, they're trustee.
Well, normally, but first in the normal setup that everybody's used to in the box, they got equitable title, the 9/10, right?
Yes, they really do, but they don't believe that. They don't know that. They don't understand that.
No, yeah, they think they own it.
Yeah, I don't want to own it.
Can you say that again, Shane?
I was just, because, this is turning my head around. So we've gone from the birth certificate, which is one thing, but going into things like cars and, I guess, houses, the quote-unquote owner is actually the equitable title holder with 9/10 possession. That's where I was probably getting confused, right? I was thinking of a car or something.
Yes, but then it's assumed, and you're being tricked to give them that title. Because the county is... you've given it to them.
That's right.
They're your trustee, and they are the beneficiary.
We gave it to them when we signed, and they registered it into the public?
Yes, and you took on the trustee position because you signed up. The grantor was the previous seller. You were the buyer, and you said you were trustee on the trust deed, and you registered it into the county, and what you did was you gifted it to them. You gave it to them. You formed a trust. They're the beneficiary.
Even if you buy a house for all cash.
Buy it how? There's no money. You can't buy it.
Well, I mean, if there's not a loan on it.
How can it be a loan on it? There's no money. It's all an illusion, guys.
So I know. I'm just saying, if somebody bought a house with Federal Reserve notes,
stop thinking.
Whoa.
Let's stop thinking in the box, thinking that this is all money and real. Let's get away from that thinking. Let's start thinking outside the box. There is no money. There are no contracts. There is no debt. You're the beneficiary on all this trust.
Okay.
Let's merge the title, extinguish the debt, and let's get on with life.
You know, I did this thing. This is an interesting thing. Maybe this will make sense to you. Here's another crazy experience. I've never bought a property, but I got real close to it once because I was trying to get out in Fort McMurray, and because that's out in Alberta where all the oil money is, and people get jobs at McDonald's for $30 an hour and stuff. So the trick is if you can get into your own property, because the thing is they suck all the money out paying rent, right? So there was somebody selling a trailer out there because it's frozen land and all that, and people live in trailers. And they wanted $90,000. She was willing to say that it was going to be $120,000, and she was going to give me $30,000 equity and all this stuff. And at the time, I was just learning about commercial redemption stuff. So this other girl, I talked to her, she said, go to this broker, he's the best guy, blah, blah, blah. And I said, how should I sign it? And she just sort of threw up in the air, sign it as buy with the full column. Now, I'm thinking back, like in retrospect, it didn't dawn on me, but there was something funny there. When I put buy and I filled out the application and I gave it to him, I remember there was something funny about this guy because he got back on the phone with me and he was kind of chuckling and laughing. And he was saying, oh, you know how all this works, don't you? And I said, of course I blew it because I just said, obviously, like, well, what do you mean, right? And he said, he was going on something like that. You know what I mean? And I was wondering now, like I've been looking back at that experience now, and it just dawned on me. I wonder if he was making reference because I signed by. We'll call him. Do you see what I'm getting at?
Yeah, I do. But, Jacob, could you just repeat what you were saying there again?
Oh, I don't remember, Pete. What was it?
It's about the house. You were saying about the house. Now, how can you be sort of like held liable for the house as trustee? I think that was it.
Yeah.
So the land is registered under your name. So, you know, you've given your beneficial interest away to them. You've come in as trustee. Now, whether you've actually done that or not, but the deed is moved over to you. And now the deed is, you know, the handing over the beneficial title, and you've never rearranged it or expressed the trust. That's how I see it, like from what Christian's explaining.
That's in the box what everybody's doing, right?
No, it's confusing, though, because you become the trustee, and then the bank's, you know, having a trustee.
You said that you pay cash.
Oh, yeah.
Well, what different? Okay, but what difference does it make if he paid cash or I lent him $100,000 and he owes me the money back? It's still in how he
Well, he was trying to make a difference, you see.
Right, but what difference would it make if you know, that's just two separate transactions, but it still gets to how he signed and the titles and the registration and that stuff.
Well, that's what Christian's saying is come away from all that thinking and get with
No, wait. Two separate things here. He's just saying, what's the difference if I get a mortgage or pay cash? Well, what is?
Yeah, but what Christian's saying is come away from that because there is no cash, there's no mortgage.
Well, that's what I just said.
Only mortgage in it.
I don't think it makes a difference if his aunt gave him the money or if he found it in a bag under a bed or if he got cash or he did a check or if he got a mortgage. It's how he filled out the registration, how he did how he signed the deed, how he registered it. That's it.
Yeah, but let's realize what we did wrong, what happened, and let's go back and correct this misconstruement.
Cool.
Yeah, but how do I go out and buy a house today?
So it gets back to...
Hang on, let's deal with one issue at a time, Jacob, instead of getting all excited and...
Does it got to do with these signatures, Christian? Right?
Yeah, because you signed as trustee. And you did the recording or they did it for you, but for your authority... You set the trust up.
Okay, so you're saying...
You got to correct that.
So you're saying when you just sign regular, you're saying the presumption is, bang, you're the trustee.
No, but
in warranty deed, you are trustee. It says right in there, you're the trustee. You signed that, you agreed to that. You set that trust up.
Okay. Just off topic, just because it's a small point, you get the whole story there before everybody forgets it. Do you think that I'm pretty sure this was like I never met this guy before. And all of a sudden, the first call after I sent that application with the buy, and he was saying the weirdest comment, like I didn't know what he was getting at. He's going, like he was kind of like chuckling, like I beat him at something, you know, kind of like he was already like, you kind of know how this works, eh?
You signed a restrictive qualifier.
Do you think that made any difference, just putting the buy and the name kind of thing? Because I was already signed on behalf of.
That got you out of liability.
Can you guys help me for a second?
So technically, could I have enforced that a bit?
Yeah, you could have expressed it as a trust and proved it, yeah.
Yeah, something was there, okay. And that actually is, I think, what we're talking about, guys. Anybody wants to clue in there?
How do you guys help me for a second? If we have a trustee and we're the grantor and we assign the bank as the beneficiary and we assign a trustee, how do we end up being the trustee?
You got another presumption. You got a statutory trust in the county, which is different from the trust in the bank.
Okay, so there's two sets, you mean?
Yeah, there's two trusts. At least two trusts or more.
Okay, so when we're buying the house and we're at escrow, we're the grantor and we're signing the bank and the bank's trustee.
Everybody thinks all this stuff is one thing. We only got one trust. No, there are thousands of trusts.
Okay, well, just go to the two, please, so I can try and keep it simple.
Yeah, the two of them are separate.
Okay, so I just mentioned the first one that I'm familiar with. And in the second one, I'm the trustee?
Actually, this colorable statutory one that the bank established in the title company as being, say, trustee to close. And once they closed, that trust was done.
Okay. Now what trust are we in?
Okay, now we got to talk about the trust with the note, with the bank.
Okay, so the beneficiary has the note, correct?
No, the bank's got the note.
The misconstrued beneficiary probably has the note.
Huh?
The misconstrued beneficiary has the note.
And that's the bank?
No, the bank is the...
Yeah, I thought you said the bank was the beneficiary.
Bank is the beneficiary, but, you know, I really want to be beneficiary myself on this, but anyway. But if we're going to merge it all in one, you already set them up on the note to be the beneficiary, the bank. So it's much easier to make them trustee.
From the statutory trust?
I didn't hear you.
We set up the beneficiary with the promissory note from the statutory trust.
Yeah, when you filled out the note, you made them pay you, and they're the beneficiary.
So in the new trust, after that one's extinguished, we're going to keep him in as the misconstrued beneficiary.
Well,
I don't want to.
Right.
Okay, so now we're the trustee?
I can't change the note. The note's been made out. And if the note is a special deposit, how am I going to change it?
Okay. So he's the misconstrued beneficiary.
Well, really, if you knew what was going on, you would have never made him beneficiary. It was only due to your not understanding that now they tricked you in misconstruement so that you made it out that way.
Okay. I agree. I follow you.
Now what?
Well, now I'm the trustee. I'm no longer who's the grantor in the second trust?
You are. You're always the grantor.
You're the one that's got the signature. If you sign the document, you're the grantors.
No, but the second trustee, is there a signature for the second trustee? The second trust? It's still the promissory note?
Well, you're signing all this stuff, aren't you?
You're calling the first trust. Which is the first trust?
The first trust is the statutory trust.
County.
What do we call the second trust?
Yeah, that's what I'm asking.
Yeah, what's the name of the second trust? The remainder trust?
There's really only two trusts I'm worrying about here. That's the one in the the one with the trustee on the title company, and the bank, the one that they're involved in.
The statutory trust.
Yeah, the statutory trust with the title company, once that transferred, that was done, that was closed, they're no longer trustee. It's gone.
Okay, the title company is no longer trustee, but the bank, we made the, that was the title company that we made the trustee on the original statutory trust?
Yeah, per the implied power of attorney to the bank, and the bank appointed the title company to be trustee.
Okay.
They couldn't be beneficiary and trustee in one entity. They would terminate the trust automatically themselves. They knew that.
How come the
title? Why they come up with a title company to do closing or an escrow?
How come the title holder is no longer the trustee on that, Christian?
Yes, they're no longer trustee, so there's really no trustee.
How did they not become? How did that all dissolve? What happened there to make it go away?
Well, what happened? You went to closing, you signed the note, you gave it to the title company, the escrow closing, whoever, the same one and the same say. Their trustee, what was the trustee's duty? Disperse the funds. Who did they disperse the funds to? The beneficiary. Who's the beneficiary? The bank. So now, once you put a trust res, what happens to the trust if there's no more trust res? Terminated.
They terminated, but they didn't do that though. Instead,
they did. Yeah, they did. That trust that they set up for you is now terminated.
Doesn't the seller that get funds, isn't he a beneficiary as well?
You see, there's two trusts. The bank has got really one trust because that's the one you're going to form. Make sure that they got it.
Okay. Oh yeah. But the rest.
The trustee is done. They're out of the picture. So now I don't have a trustee. So I gotta now get a new trustee.
So the bank that makes the substitution trustee, or the beneficiary, the misconstrued bank beneficiary, he now gets a foreclosure trustee.
Yeah, on another deal.
Yeah.
Another trust, another new statutory trust to foreclose on you.
Okay, so that's a third?
Yeah, that's another one, yeah.
Okay. So he's not really a trustee because all we got to do is take the power of attorney back and just fire him.
Well, he's got this colorable contract with all these terms in it, and he's acting any way that he wants to because you gave an implied carte blanche everything because you didn't understand what was going on. That's why I like to do the 9-210, get the revocation for the contracts, do a formal firing of the trustee, terminate that trust, do a reappointment for the bank to be the trustee. Now the bank's trustee and beneficiary, they got a problem. Order the note back, and then when they don't order to give you the note back, get them for a breach of trust.
Nice. Well, there's your title.
Wait, guys. So is that 3 trusts?
Depends which way how you look at it. I'm only seeing one trust.
I want us to look at it so I can be in sync.
I only see one trust because the escrow closing agent title company, that trust, that's defunct. It's done.
Okay.
And I put a permanent closure on that. I fired them and I did a reappointment.
But they do still have title insurance.
I don't care what kind of insurance they got. That's my title insurance.
Oh, no, okay.
Let's just worry about the note.
Okay.
They're from.
Okay, so now that trustee's gone out of the statutory trust. Does it become a resulting trust or a remainder trust?
You're going to make it into an express trust.
Express trust, okay.
You're going to express a trust.
Okay.
You're talking about
it's going from a statutory trust, and it's going to go to an express trust as we express the trust.
Yeah. And your deposit was your note under special deposit.
Okay, the promissory note. Now in that resulting express trust, are we going to be concerned about the payments we put in or the interest from the promissory notice of security or anything of that nature?
If you want to be, yeah.
Is it separate RUS?
Yeah, but in the same trust.
Yeah, okay, separate RUS, same trust, okay.
Separate deposit.
Okay, separate RUS. So the payments are separate RUS. The interest off of the promissory note as a security is a separate RES. Now we have three distinct RESs.
Yeah, and if you want to, you can include the signature on the application. Throw that one in there, too. So you got three separate deposits.
Okay, yeah. Well, isn't that I'm going to include on the promissory note, right?
Well, the promissory note's one, say, $100,000. The application was another $100,000, and you had a $100,000 house, but they got $200,000 out of it.
Oh, you're going to include the credit application as res?
Well, how else would they gotten the money? You didn't sign the note yet. You didn't do closing. Where'd you get the money from?
Yeah, from the application res.
Your signature.
So now we have the express trust that is a new expression from what's left over of the statutory trust that's now terminated. Is terminated the correct word or extinguished?
Well, extinguishment of debt, termination of trust.
So that was a termination, right?
Which one?
The statutory, the original statutory trust is now terminated?
Yeah, because that duty was done. The purpose of the trust was to just do closing. Is closing done? Yeah, it was done. They passed the note on through. The note was the res. There's no purpose for the trust anymore. The purpose was fulfilled.
So it's terminated?
Yeah, it's done. Wound up.
Do we ever need to express, do we need to express that it's terminated?
I would, yeah.
But they never took that note, though, Christian, and they never put it towards the payment. They just put it into a special deposit, right?
Yeah, they did because they securitized, and that securitization is the special deposit.
No, Christian.
But there was, hold on a sec, Jacob or Chris or whoever. I just want to ask, so they put it into special deposit, but there's still that step where you want to merge the titles and get them to terminate the trust where it pays for the actual, it goes to the beneficiary and pays them, right? That they haven't done.
No, you do that.
All right, I want to call the note back. I want to demand the note back, order to the surrender of the note.
Because if we don't do that, that's why the mortgage kicks in?
Yeah, that's why I get the 9-210 to revoke the contracts. That way the mortgage can't kick in.
Wait. Revoke the power of attorney and rescind the contracts?
Yes, rescind the contracts.
Rescission of signature?
They didn't validate the debt.
Right.
Rescind the signature on the contracts. Now the contracts are null and void. They're done. You've got no worries about them.
Okay, and we also revoke the power of attorney, so we can now reappoint the bank as the power of attorney.
Well, no, as a bank as trustee.
Trustee, sorry, thank you. We could reappoint the bank as a trustee now after that, or do you have to do a step in between?
No, you can do the reappointment of the trustee being the bank, yeah.
And how do you mean they didn't validate the debt?
Well, we do a 9-210 just for revocation and get a dishonor. So I got something colorable I can come out and hit the contracts. I can revoke the contracts with that.
Okay, here's a detailed question about the order of the res and the surrender of the note. Do you have to do that after you appoint the bank the trustee, or you can do it before?
I'd appoint them first to be trustee, yeah.
And then demand.
Yeah, because now, once you merge the two positions into one entity, the trust terminates. So what happens upon termination of the trust?
Disbursement.
Disbursement of the funds. So if they don't disperse the funds, order the surrender of the funds back, which is the note.
Yeah, when they do that, that's the note gets returned, doesn't it?
Supposed to, yeah.
Supposed to, yeah.
The order for the PN res, the promissory note res. What exactly is the order intent? You order that they do what with the res, with the promissory note, because they've got the liability portion of the title, and the res is the asset title, and we're going to order that the asset title be merged with the liability title and be terminated.
Say again now. It's getting late.
Okay. The bank has the promissory note. They have the liability side of the title of the promissory note. Is that correct?
The bank has promissory note as liability title as trustee.
Mm-hmm. And the res is the asset title of the promissory note.
Yeah, it's the res. It's the res.
Is that the asset title?
Yeah, that's the asset, right?
Okay. So when we order the asset title, the promissory note res, to be merged with, how do we say it? What's the exact trust term of the order that merges it?
There's no exact. You just express as settlor.
Well, you could use the definition of the merger. You know, it says that the simple contract, which would be the debtor-creditor contract, for any purpose, and afterwards and they're entered into a new identical engagement by deed, and the simple contract is merged in the deed, but becomes extinct. It's extinguished. And this extinguishment or extinction of the lesser in the higher security, or the higher security being the trust, like the extension of the lesser in the greater interest, is called merger.
So then, what is our order? Our order is to say, I order that the merger of the special deposit be merged with the promissory note that the beneficiary is holding?
Well, when they don't wind up the trust and do the disbursement, when they don't give you the note back, then it would be a breach of trust.
So you're going to order the promissory note back?
Yes.
But how when that's part of the disbursement, right? That's after it's been extinguished.
Well, no, it hasn't been extinguished. They should extinguish it. But the trouble is that they're not going to do it because it's being held in securitization there.
Right. So they can't do it.
They can't do it. No, they've gotten paid. They're out of the picture. They're between a rock and a hard spot, really.
So we're forcing their hand into a breach of trust.
Yeah. Yeah.
That's our enforcement.
Yeah. We're going to come back in and we're going to bargain for the treble damages and the house.
And what is the title of the house? The mortgage?
That would be probably the deed.
The warranty deed?
Yeah.
But in a non-judicial, it's the trust deed, right?
All right, yeah.
Pete, what do you guys have in England?
Same thing.
Oath or warranty?
Trust deed.
We have trust deed?
Yep.
Okay. So we're going to order that they pay the obligation with the special deposit. Is that the order we give?
Well, it's like, okay, they've had all this money, they've been using it, they got the note, they won't give the note back. You know, I want treble damages, I want the house.
And the note back?
Well, if you guys are going to keep the note, you know, I want the treble damages, I want the house. they'll never give you the note back. They want to keep the note because it's exposing them to a wide open for fraud and everything else. They're toast.
So you got to let them. So in the bargaining chip, you got to let them have the note. That's the trade-off.
I would let them have the note. Let them keep the note. Give me treble damages and give me the house.
So treble damages is a check.
If I want the house, give me 4 times then. You keep the house. If they foreclosed, okay, you keep the house, give me 4 times. Treble damages plus the value of the house, 1. So that's 4.
So this strategy could be after they foreclosed on the house also?
Absolutely. They got the house, you keep the house. Just give me the money. Give me 4 times the value of the house.
What kind of a strategy do you have to go in on if they foreclosed on the house already? You have to open a case?
Yes, right.
And if they haven't foreclosed already?
Yes, you have to open up a case, yeah.
Can you not come at them like in negotiation stage?
Yeah, you could.
Yeah.
What's that, Pete?
I got an offer for settlement on the table here.
Yep.
This is what you guys have done. This is what I'm going to do, basically, without telling them everything. This is what I want.
You mean this after they foreclosed?
Yeah, after they foreclosed, yeah.
Or before any action's even taken, you write to them and you say, this is what's going to happen unless you give me what I want. And if they don't give the note, then you say, well, I want compens and I want the house.
Yeah, after all, I mean, you've got the house. I want the note. You can't have the house and the note, same thing. If you're foreclosed on the house already, you got to give me the note back.
Well, what if the house is empty and there's a cloud on the title?
I don't care. If it's been foreclosed on, what do I care? Give me the house, or give me the value for the house.
Well, I got one case where the guy put in a quit claim a week before they sold the house. They tried to sell the house twice already, and it didn't close in escrow, and it didn't clear title, I think because of that quit claim that was on the title that was clouding it.
Probably so.
So to go back in there, the guy has given me the house, and so to go back in there, I need to, I guess, put some kind of a settlement together and tell them what's going to happen. But I can see your point where you're going to have to go into court.
Yeah, I don't expect those guys to take the offer unless you force them in court, because they think you can get away with it. So
what about if you cited a case to them? Is there a case that could be cited?
Yeah, I would do that. I would do that, Pete.
It kind of strengthens your claims, doesn't it, to them, like without having to go to court?
Well, under common law, you can't have the note and the house.
Yeah.
Under common law?
Right.
Banks are under common law.
You can't have the house and the note?
No.
Okay, so in a case where they've already foreclosed, and you ask them for the note back, but you say instead of the note, I'll go ahead and take the house?
Yeah, you could do that, yeah.
Now,
when you're quitting here because you're not giving me the note, I would go through court, get the certification that they damaged you because they didn't give you the note back. Then you could go in with 3 times damages.
Okay, so what happens? Most of these deals that we're talking about have to do with refis, a lot of them. And in a refi, there's going to be a note that wasn't returned that they have also from the refi. What do we do with that note?
That's another note you can get back, too.
I know that. And we haven't really discussed that, so that's why I'm asking, because I've got several cases like that.
Right. To everybody who's been foreclosed upon, all you got to do is make a demand for the note and come at them with a case for breach that they haven't given you the note, because they can't have the house and the note at the same time under common law.
Oh, you mean you have an automatic case for breach if they didn't return it if they foreclosed?
But not under trust, just plain litigation. Common law says you can't have the note and the house. You got to give one back.
Do you have a case for that, Christian, under common law?
Yeah, just go to the law library and you'll find under causes of action all kinds of cases for that.
Okay. Yeah, I think I know a bunch already. That's right.
Has this been recorded, this call, Christian?
Yeah.
Okay.
So in that case, Christian, you're suggesting just use plain litigation.
You could, yeah.
Just demand the note, but make a case for breach that you didn't get the note back, and make a demand so you get treble damages.
Yeah, but not breach of trust. Just,
breach of contract.
Common law, you can't have the note in the house at the same time. You got to give one back.
Pete, was that breach of contract you said?
That's what I said. It was as a question, though, to Christian. Would it be a breach of contract?
Yeah, but I think it's, you can't have the note on the sea of commerce out there floating around all over the place. It's got to be surrendered.
I see.
Have you heard of that case where the guy got foreclosed on 3 times yet?
No, I don't have.
Oh, yeah, there's a case right now where the guy got foreclosed 3 times on the same note.
That's why you got to ask for it back.
Well, I know. I mean, that's a good case to bring up, right?
Yeah, I mean, you took the house. Give me the note.
So what would be the evidence, Christian? What evidence would we be bringing to the court?
Well, I just have to make a claim they didn't give me the note back, and that's my claim.
Are there any cases like that, Christian?
Yes, there are.
Okay. I mean, where they got a check for the amount of the note?
Yeah, they should get a check for the note or get the note back.
Right. But are there any cases that they did that already?
Or they should give them the house back.
But are there any cases that they've done that already?
Yes, I haven't dug it up. They've got it sitting over here someplace.
There's a case where a woman got treble damages plus $1 million.
Do you have it?
1.5 million. I got that in an email.
Then do you know the name offhand that you can give us?
If you can give me your email, I'll send it to you.
Well, you want a Skype?
Yeah, but my Skype is on the other computer.
Okay. I'll give you an email.
Give me your Skype. Give me your email and Skype, and I'll do them one or the other.
It's just Javik.
J.
Dot E-B-E-K.
E-B-E-K. Javik.
E. Edward, E. Victor, E. Edward, K. Kelly.
Okay, J. Dot E-B-E-K. Okay.
Mm-hmm. No, Skype.
Oh, that's your Skype, okay.
Yeah.
There's no remedy where there's a lack of knowledge. There's only remedy where there is knowledge. There's a ton of things everybody can do to stop their foreclosures, get their houses back, or at least the value for the houses. It's just that they don't know about it.
Yeah.
Yeah.
Could you give me your email instead? Because I'm not in the Skype, and I have it in an email form, so that's the only thing I can send you.
Yeah, G-E-O.
G.
Yeah, like geometry, G-E-O.
G-E-O.
Raw.
L-A-W.
Uh-huh. At Gmail.
At Gmail, okay. Okay, it's coming from A. Linares 11 at MSN.
Caitlin?
A. Linares 11 at MSN.
Okay.
Al Linares.
Will you send me the same email?
Okay, Pete, I hear you all the time, man. I like your accent. Give me your email.
It's Pan, P-A-N.
P-A-N?
Yeah, 283.
283.
At googlemail.com.
At Gmail?
Yeah, I think it's Google Mail. I've never tried. Gmail.
No, Gmail.
Is it? Okay. Yeah, cool. Thanks.
Gmail.com. You know what pan stands for in Spanish?
Bread.
Yeah. Are you sharp guy? Okay. I'm falling here. My eyes are like closing on me. But anyway, I'm gonna get this email I got from Francis, and I'll send that over to you.
Christian?
Yeah, it's getting late, guys.
Last question.
I have $1 million.
This service is provided by freeconferencing.com. Please enter your access. Thank you. Access code accepted. Muted.
So, Christian.
Yes, Shane.
Do you think going back to, I'm sure I saw the hint or suggestion of something from that guy. Do you think he could actually, in a preemptive approach to this, do something where right off the application you're letting them know that you're signing on behalf of the trust, and there's got to be some way to follow through, because if they don't, like you say, all this stuff, they say, oh, they won't do it. But if they don't, that's some kind of breach on their part, right?
Kind of. I'm not understanding what you're trying to get out there.
Well, this guy, like I said, he just kind of laughed at me like it was like he knew me or something. It was like some kind of guard was down, and there was a little intimate couple seconds there, and he said, like, so you know what's going on here, don't you? And I had no idea what he was talking about, but I did know, at the time I didn't even put it together, that it was maybe because I signed by Phil Collins, like on behalf of. And I just think now it had to have something. What else would he be getting at and referring to? You don't just meet somebody point blank as a broker to somebody just fill out an application to do, to do a mortgage application and make a comment like that.
Yeah, you signed restrictively, yeah.
So he was basically checking me out there.
Yeah, he probably was, whether or not, yeah.
So that means they do know what's going on. He was testing me there, and of course I blew it in the first second. But see, that makes me think there must be something that you can do. Because I always say to my friends, right, we got the big $1 million houses around here, and I try to talk to them about this trust stuff and the stuff you say, and I said, you don't think those people there, you think they're paying a $7,000, $8,000, $9,000 mortgage a month? Come on. You know what I'm saying?
Oh, they are.
No, they're not. Take my word for it. They're too quiet. And my friend has said he's seen property deeds of trust with promissory notes attached to them in the land registry. So this stuff must be going on. But like you said, it's the knowledge. So I think next time he says, "Do you know how this is operating?" Yeah, and I should have said to him, maybe, "Do you know how to operate it?" Because he would be the trustee at that point, wouldn't he?
He didn't have trust res.
Yeah, I mean, he must have been looking for more, obviously, because eventually he came back and I still filled out I filled out all the things and I gave him all my credit information and all that. But he still asked me that question. So that still probably was part of the colorful process. But, yeah, I don't know what the trust res, well, I mean, he's got the signature on the application, whatever that counts for. But, so
that was trust res, but were you treating it as trust res and forming a trust? That was the thing. Otherwise, it's debtor creditor.
Yeah, so there'd have to be something again with the well. I guess by Full Collin is open. Maybe that's why he was asking, because it wasn't clear enough. It potentially could be construed as trust, but it could also be construed otherwise, right?
Wouldn't be construed as trust. It'd probably be construed as debtor creditor, because you were not making a special deposit under trust. So you were making a general deposit, which puts you under debtor creditor.
Okay, so if I took the application and actually put by grantor Full Collin signature.
Right. That'd be one way, or start expressing a trust.
Okay. And then if they try to negate that, then they're violating a breach of trust, right?
Right. Yeah, after you approve the trust, yeah.
And then they probably want to see a copy of the birth certificate or something like that. And then I'd probably have to come up with some form of a promissory note.
Well, no. Actually, the signature is proof that you're the grantor. Now you just need 2 manifested records of, say, claiming, and 2 manifested records of transferring notices of the trust resident you gave him.
So I would, manifesting records, you mean the ECC 1 and 3 on
Right.
the actual application itself?
One is claiming and accounting.
Okay, on the application
2
itself.
records for claiming. And then for the transfer, the UCC 3 and accounting, which are notice records, 2 notice records.
That's just on certified copies of the application itself.
Yeah, because that's what your signature forms the trust, and then your signature is the asset or the trust res.
Okay, that's an interesting that kind of shows how universal that is. Then that's pretty wild.
That was the special deposit, except you're not treating it as a special deposit. Special deposit, we treat you like a trust, but you're not. So therefore, you made a general deposit, and that was a debtor-creditor relationship. Then you didn't grant it.
Right. Yeah, I just signed by, but it was just quite interesting. It evoked that response. I just thought that was unusual.
They tricked you into voluntarily or transferring your name to another without compensation. You got a debtor-creditor relationship. You didn't get compensated for it. You got a debt.
That is an odd response, though. It doesn't quite make sense. I mean, some people could say, well, that doesn't mean anything, but like I said, it happened coincident upon the way I signed there, and like at point blank, never to meet the guy, just right off the bat, him going, kind of like, just. I guess you got to hear the tone, right? It's just kind of like a very resigned, kind of like ha ha ha, like so you kind of know what's going on here, right?
Shane?
Yes.
You have what's known as an unqualified signature or clean signature and a qualified signature. Now, the qualification of signature that you've given is you're not accepting liability. You're signing it, but you're signing it by. Now, the things that Christian's saying is, as you mentioned there, is come in as by grantor or by grantor beneficiary or whichever.
I think you cut out there. I don't know if you can hear me.
Yeah? Can you hear me?
Yeah, you just come back.
Yeah, so you come in as by and then you sign, and then underneath you put grantor, beneficiary or whichever, and there's your qualification, and now they have to act in that capacity because it's recognised that there is a trust because of the qualification that you've given upon your signature, because you haven't given the clean signature, you're not just giving it away. Even as by with the signature, you've not accepted any liability, but you've still given the signature, as it were, unqualified. You've qualified it to a point, but you haven't qualified it as.
Right. So you're saying would you say to put underneath it again?
Grantor, beneficiary, whichever, trustee, I don't know.
Do we got to maybe put that before the signature?
Yeah, by grant the signature, say.
Sorry?
I put mine under because generally that's where the position on a signature usually is. It's usually under the line.
Oh, I thought you got to have your signature underneath all of those things to underwrite it. Oh, come on, guys! You gotta come back in.
I thought the status is below.
Yeah, I gotcha. You're back in. You were. Oh, what's going on here?
Maybe we can pick up later because we got a call later as well, haven't we?
Yep.
Listen, the gentleman with the Geo Law, what is your name so I can put you in my list?
That's Jacob.
Oh, that's Jacob. Okay. Jacob, I don't know the last name, but anyway, that's fine.
Summers.
Oh, like Chris? Maybe they're related. Okay, well, the email went out. You look for the
They're Siamese twins. Got two heads.
Just look for the title that says Documents for Bank Order to Compel. That's the title.
I got it.
And look down below and you see that there's a lady that won a lawsuit for like $1.5 million.
Cool. Yep. He gives woman 1.25. Yep.
I didn't get it.
Where's that? Where are you guys looking at?
Geo Law?
Geo Raw, not law.
Oh, well, that'll
raw,
work.
like raw food. Geo.
Oh, that's different.
What did you just looked up something with Geo Law and you saw a case or something?
No.
Geo, Georaw.
At Gmail.
Huh?
Sorry, you guys said you saw some case or something?
Yeah, there's a case that was of a woman that a judge awarded her like $1.5 million, $500,000 in treble damages, I think, and $1 million in.
Where are you seeing that?
I got it. Someone sent it to me. Let me read it. This is okay.
Okay, I thought it was just somebody had it there, right at him.
I have it. If you want, I can send it to you. Let me see. That's Jacob.
Yeah.
Jacob Summers. Okay. Let me. I'm going to write you.
You don't have to put a name. You can just put georaw@gmail.com.
No, I did. But it's asking me to save the name. Contact.
Okay, guys, I'm out of here.
You're really about done yourself this evening, Christian.
We got to record that. Get a recording of that, Christian. Where do you keep the recordings? I got to get that downloaded.
Yeah,
the last part on trust. We're
going to have a new nickname for Christian after tonight, Marathon Man.
Yeah, well, there's one other one that went longer than this. So.
Oh, okay.
Cheers, Christian. Have a good rest, and
thank you.
Later.
Everybody.
Yeah, nice one, guys.
All right, guys. You have a good night. We're gonna go to sleep, man.
Yeah. Good night, all. Good night.
Christian, thanks a lot. I'll talk to you tomorrow. I guess he's gone. Take care, guys. Okay. You got the email? Okay, guys. We'll talk tomorrow or later. Bye.